was understood by Jean Baudin. So you have about 7 other strands of sovereignty. You move henceforth from the traditional understanding of sovereignty. And I would want to throw it further to the Honorable Court. A reading of Article 6D and Article 27.2. What does that mean for us in terms of, for example, candidate states? Do we admit, for example, a country that does not respect the principal provisions of the East African Community Treaty? Do we, for example, need to relook at the Ntege case decided by the court, which said that integration and admission of states is a matter for the council? How about the court playing its judicial review role and examining if these candidate states have conformed to community law as a question of prior commitment before you are admitted? And with regards to that, there is, in addition to what Justice Kathurima was saying yesterday, Article 26, Vienna, Pacta sunt servanda. We have other pactas in terms of international law. We have Pacta do Contrahendo, Pacta do Negotiando, which will bind states that have not been admitted to respect core values of the community. Thank you.
Thank you for your comments. Mr. Dondea, kindly join the rest of the panelists at the front. A question, a comment? Yes, can somebody take the microphone to the AG of Uganda?
Thank you very much. Mine is both a question and a comment. First, Chiriwachwan, Attorney General of Uganda. First of all, I'd like to thank the panelists for a very intriguing conversation and yesterday. One, I think Lady Justice Fiona Mwale makes a very important point, and I speak here from the perspective of the government. She makes a very important point, and I think that is what we need to be looking at carefully. Governments are actually not saying that we don't understand the agreements that we enter into. The question is, does it mean that when I enter into a treaty position, I have actually given up my sovereignty? No, I have not. I have actually just given away limited rights for those parties to come and participate in this space. And I think the question that we always need to address our minds to is, how do we understand each other? For example, I'll use the example of the ESCJ, which I'm more familiar with. Courts must be accepted by the people. And when Dr. Mweche asked the question, is it really a legal question? Is it a legal question? I don't think it's a legal question. What the ESCJ is doing here is actually seeking the acceptance of the people to the courts. While we are going through this integration process, you will hear every so often one country and another struggling over movement of people, movement of goods, and then you want to go back to the people and say, the court of that institution has said this. So we need to really introspect on the issues that are being raised. How do we go out to actually get the people to understand? So I think the question that we need the question that I'll put to the panel is that when a country purports to assert its sovereignty, is it purporting to assert sovereignty to a specific aspect? Because I think that's where the issue is. Yes, Uganda is a sovereign state, but a member of a supranational organization called the EAC. So we have issues that are internal, so does Kenya, so does Tanzania. However, we did give the East African Court of Justice authority to conduct matters, say, on the interpretation of the treaty. So is a country challenging that question on the interpretation of the treaty, or is it even challenging the understanding of the ESCJ on the provision of the treaty? So I think that's where the issue always is. And I thank you all because it gives us food for thought. We'll continue thinking about it. And I like what Don said. We need to have to support the courts. We need to support the courts to be able to do what they are supposed to do. And we are not supposed to be happy all the time with decisions of the court. We are not happy because there's a loser and a winner. We are not going to be happy. Being unhappy and accepting a decision are totally different things. So we need to allow the courts to do. But I don't agree with the assertion that we will make decisions even if the heavens fall. The heavens need not fall. Actually, the heavens should not fall. Because if they fall on all of us. So who is the court actually working for? So that's what my comment. And I think we just need to keep engaging both the court, and I like the ESCJ for the diplomacy, that to understand each other. What exactly is the issue? But there's some other elephant in the room which everyone seems to have. You seem to be pointing at governments, but I think you fear to point at the judiciaries. I think there is a bigger fight between the regional courts and the domestic judicial systems, as more than there is between the regional courts and the executive. I think that's an area where we need to get some help, because we get more jostling between those two institutions than even the executives. I thank you.
Thank you very much, AG. And I want to invite Honorable Justice Katharima to just briefly respond to that with your thoughts, and then we'll take just one more question and we close. Thank you.
Yeah, thank you. I think the point is really well made. As far as we are concerned at the East Africa Court of Justice, what we are seeing is this opportunity to hear other people's views and we reflect on them. It's the only way we'll move forward as a court. I don't think what the Honorable the Attorney General of Uganda is saying is fundamentally different from what we are saying about the issue of sovereignty. But I think we would really expect all the partner states to be acting in good faith as far as their obligations under the treaty are concerned. I think we do not come from a position as a court that partner states are actually enemies of the court. They are actually the guarantors of its existence and its independence. That's for sure. When we come to Kigali like this and we find the government of Kigali, the judiciary, hosting us and keeping us here for a month to hear our cases, it's a major statement that actually the court is important. But as Dondea said yesterday, the court itself also needs its people. The guarantors of its existence and its independence are the people of this region. If there's a disconnect between the court and the people in terms of their expectation, the court cannot go very far. But my last point is simply this. The SADC decision is a good decision in terms of reminding us what can happen. But it's a very, very, very bad decision in my view. We should not make it the boogeyman. You know, the way when children don't eat food, you tell them a monster is here, it's coming to eat you, and to get them to eat. We should not, SADC should not be our boogeyman. We will take into account and we must look at it very carefully, but it should not be something really to scare us around all the time. When somebody wants to interfere with the court, scare the court, you waive SADC. I think we really, really, really must see through that. Thank you.
Thank you. One last question. Yes, microphone here, please. And please let us know who your question is directed at.
Yes, my name is Charles Uyonyawelo from the High Court of South Sudan. I'm not asking a question, but I'm rather responding to the comment that was made by the Attorney General of the Republic of Uganda. He says there is a tug of war between the National Court and the East African Court of Justice, that is the regional court. And it shouldn't be that way, because if a case is seen in Uganda, for example, or Kenya, and then an advocate comes to the court and frames it in terms of violation of the treaty, and when violation, for example, Kenya has violated its own law then automatically that violation is a violation of the treaty. And that case is subject to review by the East African Court of Justice, starting from the First Innocent Division. And the power is given to the court under Article 6 and 7, too. And this is where the problem seems to be, because if the countries have decided to come together into a community, and then a power is given, and then a court is created to interpret that treaty, then the court went ahead to interpret Article 6, and that's how some of the decisions of the AFEC courts from the regions, or from the states, have come to the East African Court of Justice, and the East African Court of Justice delivered judgment, and this is where there seems to be a tension, but there shouldn't be a tension, because if it is a complaint that there has been a violation of treaty, that is it.
Thank you very much, Honorable Justice Nyawelo, for your comments. And this gets us to the end of this session. I want to thank you very much for your contributions to this conference, and we'll continue engaging as we hear from the other panelists in the other session. Thank you very much. Kindly give them an applause. I'd like to recognize the presence of Honorable Justice Sam Rujeje, Chief Justice Emeritus of Rwanda. Thank you for joining us. So we're now moving on to session 5 on the implementation and enforcement of decisions of the ESCJ by domestic courts. The session chair of this session is Professor Eudes Ruhangisa. The presenter was supposed to be Professor Frederick Sempewa. Unfortunately, he's indisposed, but we trust that Professor Ruhangisa will take charge of this panel. The panel is made up of the Honorable Attorney General of the Republic of Uganda, Honorable Kiriwa Kiwanuka, Honorable Justice Cheborian Barishaki, Judge of Appeal from the Republic of Uganda, and also Judge of the East African Court of Justice, Honorable Dr. Anthony Kafumbe, the Counsel to the Community, Mr. Guy So, Registrar of the ECOWAS Court of Justice, Professor Thomas Milech, academic from Kenyatta University, Nairobi, and finally, Mr. Fulgence Masawe, an advocate from the United Republic of Tanzania, and one of our leading litigants at the East African Court of Justice. I'd like to invite you all to the podium to kindly take your seats, and Professor Ruhangisa shall take it on from here. Before I hand over to Professor Ruhangisa, I would like to extend our sincere appreciation to Konrad Adenauer-Stiftung, who has sponsored this panel. We appreciate the continued collaboration between our two institutions, and we look forward to hearing your remarks, Dr. Stephanie, at the end of today. I also want to extend our sincere appreciation to the Honorable AG of the Republic of Uganda. He actually personally requested to be part of this, not just part of the conference, but to actively participate in the conference. And that is the kind of collaboration that, as a court, we continue to advocate for, and we really appreciate this gesture by you, Honorable Attorney General, and it is because of you that we are actually a better court. And we invite all other government officials to also actively participate in our future conferences. Do not wait for us to call upon you, but please offer to be part of us. Thank you. Professor, I hand over to you.
Good morning, everybody. Hope you, all of us, slept soundly because we had a connection with the ancestors in the course of our sleeps. That's where life starts from. I thought Professor Sempembo would be online because we had him here early in the morning when we were meeting, but I'm told he's indisposed now. In that circumstances, we would like to observe the following. We prepared questions to guide us. And I have a panel of discussants of 6 people. In the absence of the presenter, initially each one would be given 5 minutes. But now you will play both roles. You don't have a presenter, you are the presenters now. So prepare yourself in the next 10 minutes to expand. Answer the question, and in the course of answering, please add what you had earlier on planned to include in your presentation. 10 minutes for each one of us, strictly on the line. The rest would like to engage the participants so that we also make it a two-way discussion instead of turning it into homily proceedings where a pastor or a sheikh stands there on his own to preach even where he misses the point. He cites it as Luke when it is Joanna or Matthew. But you cannot raise your hand to challenge him for that matter. This is not the same. So we know we have the CVs of all these guys who are present here. We can familiarize ourselves with their details. They are all luminaries of law in their own rights, experts in the areas they will be talking about. Let's hear from them and also get to hear from you participants as you intervene or interject wherever. So time is on our side. I have Honorable Kiryowa Kiwanuka, who is the Attorney General of Uganda. I have my Lord Justice Cheborion Barishaki. He is the judge of the East African Court of Justice. Yes, he is standing. You can see him gathering his materials from what he had left. I have Honorable Honorable Kafumbe, is the CTC, next seated right before me, the counselor to the community. And I have Guy Sowe, registrar from ECOWAS, who is in charge of implementation. We will benefit much from him. While we have experience of going through a number of challenges, but ECOWAS have come out with a certain strategy of having a person in charge of implementation. And I have Professor Thomas Millage, a famous lecturer in international law, regional integration. He teaches at Kenyatta University. And last but not least is Advocate Fajansi Masawe, a practitioner, a regular practitioner in the East African Court of Justice. You can hardly have 3 months without seeing him in the corridors. He engages the court sufficiently together with his colleagues, so here we are. We don't want to give them a round of applause before hearing what they have. Let's reserve our appreciation at the end. So I will start with the Honorable Attorney General, Kiryowa Kiwanuka, with the following questions. As a member, the question goes, as member of the Council of Ministers, who has attended a number of its meetings, do you see readiness on the part of the partner states to accept the fact that East African community is a supranational regional organization whose organs, meaning EACJ, EALA, and others, make decisions that take precedence over decisions of similar institutions in national level. Question number 1. 2, as a necessary party to most of the cases being filed at the EACJ against the government, are attorneys general satisfied with the implementation stance of the EACJ's decisions, especially those which do not impose pecuniary obligations on a person and involve partner states? The floor is yours.
Thank you very much, Professor, and good morning, everyone. I think this is the best way to set someone up. They tell you have 5 minutes, then they tell you have 10 minutes. So now you have to find words to use in the 5 minutes, extra 5 minutes. But I'll do my best. The question that we are dealing with here about the East African community and the commitment of the partner states, I don't think is really in doubt. It is akin to, for those of you who are married, when you leave your home and get married to a wife and then you join another family, which is already grown. So you need to find a way of fitting in within that family. That is what we are dealing with. These are countries, 8 countries, which are grown, mature, have their own way of doing things, and are coming together to do certain things. And that means we need to learn how to manage ourselves. We are lucky in East Africa that we are connected by culture and values. So the differences in our cultures and values are not very different. And therefore, it makes it easy for us to engage. Secondly, we are lucky that we have a language which can be used to communicate around the community. So the countries, from my viewpoint, from where I sit, are very clear on the principle that countries must abide by the treaties and the agreements that they've entered into. It's actually not even a state question. It's not a big, we can use all these big Latin words to pacta sunt servanda, all. No, even in our day-to-day living, we must get to agree to be bound by the agreements that we make. So the East African Treaty is really one of those agreements. And Uganda, and I'm sure without fear of contradiction, I speak for the other members of the community, we are committed to this cause. And you can see the commitment, how it is growing. ESCJ is one of the organs of the community that has grown over time. But the others that have grown, which we don't even speak of, we even forget that they're even treaty obligation. We do not have a customs law in Uganda separate from that of Kenya. We all use the East African Customs Management Act, which was enacted by the EALA. And none of the partner states has ever challenged that. Yes, we come to the court for different reasons on that. But that is clear commitment from the parties. We have challenges that we also have to deal with in as far as the court is concerned. If for those of you who are here before us, but those of us who read about it, before we had the East African Court of Appeal, where decisions of the partner states could be appealed to the regional court. That's not the case today. And therein is where we have the issue we need to address. The most litigated issue in the East African Court of Justice is the provisions of Article 6D. And when you read Article 6D of this treaty, I wonder which other part of our domestic laws is not covered here. The fundamental, and I'll read it verbatim, the fundamental principles that shall govern the achievement and objectives of the community shall include good governance, including adherence to the principles of democracy, the rule of law, accountability, transparency, social justice, equal opportunities, gender equality, as well as the recognition, promotion, and protection of human and people's rights in accordance with the provisions of the African Charter on Human and People's Rights. Now, my lords, the members of the ESCJ will tell you, I think each and every single petition that has been filed in the East African Court of Justice quotes Article 6D. Article 6D of the East African Treaty is encompassing all the values, and all these values also exist in our different constitutions and local legislation. So the question I'll put to you is, for example, if a person came to the court and said that the state has taken my land forcefully without compensating me, and it therefore breaches Article 6D of the East African Community Treaty, would they be right? Would they be wrong? Remembering that in Uganda you have Article 26, which provides exactly that a person shall not be deprived of their property without compensation, prior adequate compensation, and that this person has a right to challenge that decision in the court. So the question is, therefore, would the East African Court of Justice be wrong to say that the action of the state was indeed in breach of Article 6D? And if it is so, what other question cannot be brought to the court? That brings me to the issue of the precedence, and I think that is where we were coming from. That the principle of precedence of the judgments of the East African Court of Justice were to say that we have encompassed the principles and the values of all our partner states and reduced them into one treaty. And if that court says that it is not in consonance with those principles, then that provision will take precedence. But this question is a question we are going to continuously ask ourselves. It's a question we are going to continuously have to engage. And therefore, for me, I think that the partner states are very clear and are committed to this, to the East African community. But I always sound a word of caution to the courts. A decision made without taking into consideration the realities in any space can create more problems than the justice we look for. So when the East African Community Court is making a judgment, it is not enough to resolve the dispute between the member or the member of the community, the person in the community, against the Republic of Uganda. Your role is to make a decision which is acceptable, not between those two parties, A versus Attorney General of Uganda, but that principle must be acceptable to all the other partner states. And therefore, it is incumbent upon the court to make sure that the decision they make does not in any way violate the values of another state, because the decision made by the ESCJ is not only binding on Uganda, but it's also binding, that principle, the ratio, is binding on all the East African states. I'll give you an example. Before I came into government, the only one time I think that I took government to court before I came to government. I was not in the business of taking government to court, but that time I took government to court. I came here representing a private entity, BAT. And the East African Court of Justice, the complaint was that BAT was set up in Kenya, but there was a tax being levied on BAT in Uganda on the produce that it makes in Kenya. The question before the court then was, are the products coming from Kenya foreign goods or are they local goods? And we were saying that in as far as the East African community is concerned, those were local goods. Now that principle was set by the East African Court of Justice, and it said those were local goods. And I thank the government of Uganda, even before I joined this side, that they actually implemented the decision of the East African Court of Justice. But the meaning of that is, I do not expect another partner state to now have a levy on a produce coming from another country, because the East African Court of Justice has resolved that question on what is local and what is important. So we do actually encourage the East African Court of Justice to continue doing this, and we will support you. We'll continue to support you, but we'd like to see that 360-degree view of things. If I make a decision, it is going to affect the entire community. It's not enough to make a decision that only deals with the issues in that particular country. On the issue of implementation of the decisions, I said earlier, commenting on something, the court should not expect that we're going to agree with you with every decision you make, because we came to court having a different view. There was a party A versus the Republic of Uganda. The Attorney General of the Republic of Uganda came here and made arguments before you. You ruled against the government of Uganda, for argument's sake. And they expect the Attorney General of Uganda to come as soon as the court ends, aside from saying, most obliged, which is what I am supposed to do as a professional. I'm not supposed to entirely agree. I may even feel aggrieved, and that is why at times I go to appeal. But the issue of acceptance is another matter. Whether I agree or I don't agree, I must accept. I must accept. And I may even come out and say, no, the courts were wrong because this was the principle that they were arguing, and I don't agree with them. But the country, the partner state, does not have the liberty not to agree, not to accept the decision of the court. So it is something that we need to continue engaging about. We have to look at it and say, I don't agree with you. I may even bring another matter before you on the same question, but that is something that we will accept. But I want to, the issue of pecuniary obligations of person is something we need to address. Because from my viewpoint, I see an abuse. I see an abuse of the court, and the court needs to protect itself against that. It is not enough that I have a disagreement with the country or with the government. It must be a justiciable disagreement. So whenever we come here and they say each party bears its own costs, the state pays the costs, the other party doesn't pay the costs, you may create another monster, not the SADC monster, but you may create another monster where now people just misuse the court. I don't have an issue, but I can bring it to the court. After all, there is no penalty against me. There must be a consequence for doing the wrong thing. That is what laws are for. It can't be okay for you to just come to the court, spend 6 months of the taxpayers' money in the East African community, go away, come back the next month and do the same thing. So that for me, I think that while we enforce this judgment, and we don't have a problem with enforcing the judgments of the East African Court of Justice, I don't think, yes, we have disagreed, but Uganda will always, and I've seen almost all the East African community countries have actually implemented the decision. But I think there must be a protection of the process so that it is not abused. I don't know whether I still have 10 minutes. But those were my comments on the questions that were given to us, and I think the thing we need to continuously engage on is how far are we going to go with this dual supranational, national, how far do we go? Because that 6D for me is wide, is wide. And therefore we need, as partner states, to start thinking about it and start finding the acceptance. But the court can only interpret the treaty provision, not the laws of the country. I thank you.
My patience is almost running out.
When I asked for 10 minutes, you kept quiet, so I thought I had more.
Okay, I had used my prerogatives to allow you some extra minutes to wind up. Thank you, AG, for your presentation in that form. Now I move to my Lord Justice Eborion of the East African Court of Justice. Only one question. The EACJ has been bold enough to make decisions against the partner states whenever actions of violation of the provisions of the treaty were brought before it. And it has largely depended on the national courts in the implementation of its decisions that impose pecuniary obligations on a person. What is the court's standpoint in view of the Kenya's Supreme Court decision on Martha Karua's case? Does the decision enhance the complementary function among ESJ and the national courts, which is envisaged under the treaty, or a manifestation of competition between the two? This, you will recall, had earlier been referred to by the Honorable Attorney General in his contribution comments to the previous presentation. Does the court feel like? My Lord Cheborio.
Thank you, Chair. I want to begin by saying that yes, the court has been under a lot of pressure in making its decisions, many times, not all the time. And this has come mainly sometimes from the executive. A classic example is the case of Professor Peter Anyang' Nyong'o, which came from Kenya, where the court had said that the process of sending representatives to Yala in Kenya was flawed. And the court was put under a lot of pressure to review its decision. But it got a lot of support from civil society, from bar associations, from civil society organizations, and it stood its ground. And you explained yesterday how it ended well. So it's true the court has been getting pressure on its work. But what I would like to say is that there has always been solidarity among the judiciaries in the region whenever pressure comes up. I remember in 2017, we were attending a CIMIJA conference in Dar es Salaam. That was the time when there were elections in Kenya, and there had been an election petition in the Supreme Court of Kenya. And while we were still in Dar es Salaam, I think the court had a few days before given its decision and annulled the election of the president in Kenya. Now, the then CJ came to Dar es Salaam to attend the conference. He was accompanied by another judge. And when he arrived in the middle of the opening ceremonies, he was given a thunderous standing ovation. Many judges went out to hug him. There were many chief justices. Why had this happened? It was to thank the Kenyan judiciary for having stood bold in its decision, because it had been under a lot of pressure. This was all in the press, and we could follow it. So the judiciaries in the region stood in solidarity with the Kenyan judiciary at that time. And this was a good gesture. I could see Chief Justice Maranga smiling. I'm sure he got energized when he saw his brothers and sisters supporting him in that way. Now, the Martha Karua case, which has now come up, I don't know whether it's still on the same footsteps as what had happened in the election petition. The Martha Karua case seems to have set a new trend, a new trajectory, where now we are not seeing the executive putting pressure on the judiciaries. We are seeing a sister judiciary putting pressure on another judiciary. In almost the same jurisdiction, we are all East Africanness, but there is pressure coming from one judiciary to another. And so the element of solidarity seems to be waning. the solidarity that we had in Dar es Salaam seems to be waning. This time the executive is sitting on the side, watching us, trying to pull each other down. And that would not be a positive trend. So to answer your question, I think then it's not a positive trend. And this had not been the case before. If I go back to the case of Katabazi in Uganda, that would have been a case where one would say the AG of Uganda should have come up to do what the AG of Kenya did in Martha Karua. Because the circumstances and the facts of the Katabazi case were quite sensitive. What happened in that case was that Katabazi and 21 others were arrested for treason, and they were charged for treason. When they were arrested, they were detained by the High Court. They applied for bail. The High Court granted them bail. When the High Court granted them bail, the army said, no, this is treason, you can't grant them bail. They rearrested them. And this time, took them to the court-martial, where instead of charging them with treason, they were charged now with terrorism and being in possession of firearms. But based on the same facts that they had been charged in the High Court. They went to the lawyers went to the Constitutional Court to say, look, this is not acceptable. The Constitutional Court in Uganda declared that the actions of the military were unconstitutional and these people should be released. But they were not released. So the lawyers, the Law Society, brought the matter to Arusha, the East African Court of Justice. And the court declared that these actions were in breach of the treaty. Now, what is important in that case, in respect of what we are discussing here, is that when the matter came back to Uganda after the verdict of the regional court, the AG Uganda was put under pressure by government and say, look, challenge this decision. These people want to overthrow the state. But the AG of Uganda stood his ground. I remember that time I was also working for the AG and said, no, we must respect the decision of the regional court. And the matter ended well. There was nothing like filing or seeking for an advisory opinion. So in my own view, I think the AGs have a big role to play in bringing together the judiciaries, in harmonizing them, in making sure that they don't tear each other down. Because had the AG of Uganda gone the way the AG of Kenya went in the Martha Karua case, maybe by now we would not even be having a regional court. So the AGs have a central role to play. The judiciaries on their own also have a duty to make sure that they harmonize activities and they dialogue in order to avoid what is going on. But overall, in my own view, the court has done well and its decisions have been respected. Some of them quite sensitive. If I can just mention a few, I will mention the UTC case in Rwanda. Here, I think the government had taken over somebody's mall. He came to the court, and the court said, no, that was not proper, and awarded hefty special damages. But the state here, the paternal state here, honored the decision of the court and paid. This was complementary. In Rwanda, again, the case of Kalari Stephen and Attorney General, which challenged the closure of the border by Rwanda, the border of Gatuna here between Uganda and Rwanda. Kalari came to the court, and Rwanda obliged and implemented the decision of the court and opened the border, and business continued well. In Tanzania, in the case of Media Council, where the law on press freedom was challenged, the court said no, it was not proper. that law infringed the provisions of a treaty, and Tanzania obliged and amended the law. So this Martha Karua case, I think, should remain an isolated matter, and we should thank civil society, we should thank the bar associations who have given us support whenever such pressure comes up, and we encourage them to continue to do so again. I think those are my views.
Thank you so much, my lord, for responding to the questions. It was only one question, but it received the proper treatment that it deserves. So my take from what you presented is that the Martha Karua situation in East Africa is an isolated case, and we should not take it to be a new life concerning relationship between ESCJ and the National Court. Otherwise, the National Court and ESCJ have been working in very good relationship. In other words, you are refuting what exactly the Attorney General had earlier on said. He said there is a big conflict between the hassle, the war, the antagonism between ESCJ and national courts. Having heard from ESCJ itself, we can confirm that there is nothing like that. National courts and ESCJ are in very good partnership, trying to complement each other, much as this Martha Karua is an isolated case. But he emphasized that AGs, ministers, have a big role to play in this kind of relationship, because ministers play a political role and AGs give proper position of the law. Respecting the law is one, especially respecting the decisions of the judiciary is one element of rule of law. Thank you, my Lord Justice Sheborian, for that. Number 3 follows my friend here, Dr. Anthony Kafumbe, who is counsel to the community. Dr. Kafumbe, you hold a very sensitive office crucial to all activities of the community, and you are the legal advisor to the community. Have you noticed any inadequacies on the treaty provisions with regard to the implementation of ESCJ's decisions and the accountability on the part of the partner states? 2, in your view, what should be done to improve the otherwise unsatisfactory state on the implementation of the ESCJ's decisions? Dr.
Thank you very much. I would say that in discussing matters on implementation of the judgments of the court and any inadequacies therein, it is important to recollect that we are operating under the Treaty for the Establishment of the East African Community that was signed on 30th November 1999 and came into force on 7th July 2000. So you are now looking at close to 25 years. And therefore the question that arises is that if one were to look at the treaty critically and ascertain the provisions of the treaty that speak to implementation of judgments of the court, is this 25-year-old document still fit for purpose in respect of those particular provisions? And my assessment is that we need to relook again and amend. In fact, that's one of the things I'm recommending. In respect of this matter, the provisions that are relevant, if you look at Article 38, for example, Article 38.3, and I can read it, it reads that a partner state or the council shall take without delay the measures required to implement a judgment of the court. That is what Article 38 sub Article 3 says. Now, when you look at that, you wonder, when they say the partner state or the council shall take without delay, what is this delay? Is the delay, is 1 year too long a period of time to implement? Is 2 years too short? So I think the starting point is to have some kind of timeline. I wish the Twitter had proposed some sort of timeline so that the duration is known, and when the duration is exceeded, then we could then blame the partner state or the council for not implementing. So that is one area that I think needs a scrutiny to have some kind of timeline for this. It could be that in writing their judgments, the judges may now moving forward say that every judgment they give, they put a timeline and say we expect this to be implemented within a year, so that if a year lapses, then they can say this has not been implemented. The other challenge I notice is the lack of procedural rules of the court to govern execution of its judgments. The court does not have enforcement rules of its own. It relies on partner state civil procedure rules, and that itself has its own challenges. Beyond that, we are also aware that the court does not have an enforcement institution to compel compliance. I recall yesterday there was a discussion about the African Court on Human and People's Rights, and it was indicated that they have the latitude of escalating matters to the Executive Council, even the Assembly, on the status of implementing the judgments of the court. What happens in the ES is that every time, well, in ordinary meetings mainly, when the council is meeting, the court will come with a report, and this is more or less, this is actually more for noting than reporting partner states that have not implemented. The other issue I notice, of course, is that you don't have sanctions against partner states that are not complying with the decisions of the court. And the sanctions, if sanctions were in place, this could be a deterrent and an encouragement. I'm aware, and we all know that the treaty provides for sanctions under Article 143, which says that where a partner state has defaulted on its obligations, the summit shall impose sanctions on recommendation of the council. But this is one of those provisions that have not been fully operationalized. It is work in progress. We had a council meeting last year, which directed the Secretariat to come up with a paper and share with the partner states. The partner states are expected to comment. And it is anticipated that once the comments are received, then perhaps the council will meet and take a decision on this issue of sanctions. So that's another pullback for the court, because once you are not able to impose sanctions, then for partner states or the council for not implementing your decisions, then you'll notice that there's an issue. There's an interesting article, provision in the treaty, Article 44. Article 44, when you look at it, it reads that execution of a judgment of the court which imposes pecuniary obligation on a person shall be governed by rules of civil procedure in force in the partner state in which the execution is to take place. The question arising there, then why don't we have some clarity on implementation of decisions that do not have monetary implications? And related, of course, we also notice that when you are relying on partner state civil procedure rules, then you must be able to accept the challenges that are inherent in those civil procedure rules. So it is important that we have a community law that can provide better clarity instead of relying entirely on partner states. So that is, quickly, that's what I would say are the challenges. And as I said at the beginning, I think it is time that we had a serious scrutiny of the entire Chapter 8 that touches on the court, and in particular address issues to do with enforcement of judgments. What can be done in respect of this issue then is to propose amendments of the treaty. In particular, since this is a subject that touches on enforcement of judgments, there are two areas to look at: Article 38, Sub-Article 3, and Article 44. Those ones need to be revisited so that at the very least the court can have some kind of mandate to monitor implementation of its decisions instead of waiting for maybe reports from partner states. Of course, I'm not projecting doom here because I'm aware a study was done way back in 2019, I think by the East African Law Society, and the conclusion was that 47% of the decisions of the court had been implemented. We are now in 2025. I anticipate that the scenario is much better. But nevertheless, I think the court needs to do some monitoring as to how the decisions are implemented. It is equally important that the article that talks to sanctions, that is under Article 143, is also operationalized at the earliest, because in one way or another, it will be an additional tool to the court to ensure that partner states that are not implementing judgments of the court are not, I wouldn't say punished, but at least they have some kind of, there are some consequences for not implementing decisions of the court. And of course, as I indicated earlier, it is important to address, to amend Article 44 to address the issue of non-monetary awards. It is important to have a timeline within which a judgment should be implemented. It doesn't matter whether the court says 2 years or what, depending on the subject matter, of course, that will be a discussion that the court will have to decide how do you do this so that you don't seem to be pressurizing the council or partner states excessively. And then, of course, it is important to borrow from other regional economic communities and other institutions so that the court is not seen to be reinventing the wheel. If the African Court on Human Rights has a mechanism that is working, that can be borrowed. If ECOWAS has a registrar for implementation, that's an idea that the court can borrow. I suppose there are quite many options. Equally important, of course, is that and I'm happy council members are here, that you need to consider the budget of the courts. If we expect the court to come up with, for example, what should I call them, periodic reports. If the court were to do periodic reports every maybe 6 months to ascertain which judgment has been implemented, which has not been implemented, so that then it is able to present a detailed report, a comprehensive report to the council and other stakeholders on what country has implemented what and where. It means the budget must be available for that. These things are expensive. If you have to do conferences of this nature and interact with stakeholders, you need the budget. If you have to do rotational sittings, as it were, so that people get to know what the court is doing, awareness programs, all of that requires a bit of money, and I think it is important that the budget of the court is looked at from that perspective. I'm aware that one of the issues that needs to be, I'm afraid my time is almost over, but I think that Article 33, Article 12 of the treaty has already given precedence to judgments of to decisions of the East African Court of Justice over national ones. I think it is time that some of these provisions are also reflected in national laws and civil procedures of partner states. And then it is equally important that we continue with programs on harmonization of laws in the community. So there are quite a lot of things that can be done. If the sanctions are pushed forward as quickly as possible, if the budget is enhanced, then some of these things will be unlocked. It means the court will be able to do more rotational sittings and periodic reports every now and then and engage all manner of stakeholders. So I suppose that is my first take on this issue, given the time.
Thank you, Council, to the community, Dr. Kafumbe, for scanning through possible answers to the question. And I was interested so much, or impressed for that matter, on the areas of improvements, particularly to do with provisions of the treaty. He has identified a number of treaty provisions that need improvement, clarification to assist the court. And most important to me is was the follow-up mechanism. The court should not just end at pronouncing its decision and leaving it at that. It should have a follow-up mechanism. And this should be supported by the treaty. Now that the treaty, I hear from different sources that there are some proposals or going on consultations among partner states with regard to amending the treaty, formal amendment, which is it's a consultative process, and this is what the treaty requires. So we can probably take this opportunity. The court should sit down, work out some document, and get it presented to the relevant authorities. Thank you so much, Dr. Kafumbe, for that. Now, our discussant and companelist number 4 is Honorable Guy from the ECOWAS. He's the registrar, but his office as registrar is solely focusing on one thing, implementation of court decision with the ECOWAS. So registrar handling the portfolio of implementation of court decisions. Honorable Gay, these are 2 questions. You can answer them in a manner you wish. Question number 1, we have learned of the laudable work being done by your good office in following up the decisions of the court. How did the ECOWAS come up with such a unique idea? Meaning, was the office established after experiencing hardship in the implementation of the court decisions, or the idea existed from inception of the court? 2, what do you think ESJ can learn from your side to address the challenges facing the implementation of its decisions? Honorable Guy.
Thank you. Thank you very much, Honorable Chair. And thank you to the East African Court for inviting us. Yes, it is recent, as in my office, of recent creation. In fact, maybe I want to give a bit of context, some background, a little bit of history. If you look at the 2006 organogram of the ECOWAS Court, the registry was very, very lean, you know. Not a lot of personnel provided for at the time. That was 2006. But even before then, it is important for me to point out that the 1991 protocol on the court was amended in 2005. That's the 2005 supplementary protocol. And that new treaty introduced some very, very important provisions. First, it, for the first time, gave the ECOWAS Court a human rights mandate to deal with cases. Again, it allowed individuals direct access to the court. And very importantly, too, specifically in Article 24, states are required, or it required states to appoint what is called a competent national authority responsible for enforcement of the judgments of the court. Which means a lot was required from member states. But there were challenges from the get-go. The first being the failure on the side of member states to appoint the competent authorities provided for in Article 24. In fact, more than 13 years after the treaty was adopted, only 4 out of the 15 states appointed the the competent national authority I referred to. And we also saw, after the doors were opened, as in giving the court a human rights mandate, allowing individuals access, we saw the number of cases increasing. As of June 2006, there were only 12 cases before the court. But come June 2024, the number increased to 175 cases filed, and a total of about 86 judgments delivered. So which means there was a very, very big increase. But then people started asking questions. Yes, you've delivered 86 judgments. What happened to those judgments? Have they been enforced? Yes, the states are required to appoint a competent authority. Have they done so? We know in almost all cases, when we talk about the effectiveness of any court, whether at the local or international level, we always have in mind the rate of enforcement of the judgments of that court. So scholars started asking questions. CSO started asking questions. You know, so many people, lawyers started asking questions. So the court at the time felt it needed to do something about that. Like we go on our international conference, we go on our sensitization missions, people would ask, what is the rate of enforcement? We don't have any dedicated office or any dedicated officer who would be able to put together the information. So what the court did, it decided to set up an ad hoc committee, made up of people who had other responsibilities. The ad hoc committee decided sending emails at the time, decided calling some of the lawyers. But like I said, those who were on the committee had other responsibilities. So they were more or less overwhelmed. Fortunately, in 2018, the court decided to revise its organogram. And when it did so, it felt it was very, very important that the Office of Registrar for Enforcement was created. Like you would have someone who would spend her day putting together information on enforcement. That would mean sending reminders to member states, etc., etc. So that was introduced in the organogram, and I was appointed as registrar in 2022. That's October. That was when I assumed office. What have we been able to do since then? We, of course, have been following with member states on the need for them to appoint the competent authority provided for in Article 24, which I referred to earlier on. Of course, we can't say the success you have to attribute to the office because almost everybody in the court is involved. So we saw between 2023 to 2024, because of the little bit of pressure we were putting on member states, the number of appointed authorities rose from 7 to 13. So as I speak, we only have about 2 member states that have not yet done so. If we did not have an office following up, I'm sure that would have made it a lot difficult. So the appointing competent authorities makes engagement extremely, extremely easy. So in other words, if you want to engage the states, you don't have to go to foreign affairs. You don't have to look for the Chief Justice, or you also do not have to look for the AG. What you look for is the authority appointed to enforce. So all communications you send directly to them. One other thing we also have been doing is sending reminders to states, letters, requests. Please tell us what you have done to enforce the following. So we come up with a very nice table. We put the judgment number, we summarize the orders of the court, and we very nicely request the states to provide us with information. I would say important to be cautious because a lot would say, what is your business? You have delivered your judgment. You have functus. So why are you coming back to us with additional information? Sorry, requesting for additional information. What we try to do in the letter, like more or less very administrative, we're not asking for anything extra. All we are saying is, these are the orders. Please let us know what you have done. And some states really don't like it. As my ladyship mentioned yesterday, in one occasion, we got a stinker from a member state, but at least that did not discourage us. I'm happy to report for the institutions, remember for the ECOWAS court, you're allowed to file a case against any of the institutions. We got responses from all the institutions. We also started getting responses from the states, and some of them have really been very, very, very favorable. In other words, even though we got a stinker, we thought it's important we continue engaging, that there really wasn't any need for us to give up. One other thing also introduced, in 2023, the court sent a memo to the president of the commission requesting the commission to give a slot to the court to make a presentation on enforcement during the meeting of Council of Ministers. That's not a problem with the African Court because they are required under the treaty to report to the Executive Council. In Europe, the court reports to the Committee of Ministers. But the ECOWAS treaty does not provide for that. So we really had to find a way, administratively, to get the commission to allow the president to do so. So for the first time in 2023, that was the 92nd session of the ordinary session of the Council of Ministers, the President of the Court was allowed to present on enforcement. And if you look at the report of the Council of Ministers, they invited the Judicial Council to work with the court on how best we can come up with recommendations on how we can improve on the rate of enforcement. Again, at the 93rd session, which was just October last year, the Honorable President is here. He also had the opportunity to make another presentation before the Council of Ministers. And again, if you look at the report of the Council, they invited the Commission and the Court to work together to do a study on enforcement. Here is about identifying challenges and probably coming up with solutions on how the issues, the challenges can be addressed. So more or less, even though not in the treaty, we're doing our best to make sure we make it a practice or a tradition. So that helps in putting enforcement on the agenda outside the court. So when ministers meet and the court is there to talk about the challenges we're facing, that will always help in putting it on the agenda of the Common Council or any other body. There are also other measures. I understand I have about 10 minutes. One other thing we have done is try to find ways of compiling, categorizing all judgments of the court. Not all of them are monetary orders. Some require changes in our laws. Try to make sense out of those. And of course, in doing the categorization, we more or less generate stats, which we share with all relevant stakeholders. So like now, whenever you ask us any information on enforcement, all we need is a connection to the internet to retrieve the information. And we're hoping at some point we'll be able to have the information on the website of the court for all those interested to see. The second part on lessons the EACJ can learn, I would say first, set up that office, I think is important. It's always important to have a dedicated member of staff doing the needful when it comes to, following up. The reminders we've been sending to states, like I said, that has also been quite helpful. We also, like I said, have received responses. So I think that is a very good thing. I'm not sure whether the East African Court reports to your Council of Ministers. If it does not do so, I think it's important you start looking at that option. I think getting member states to appoint, the African Court call it focal points. We call it competent national authorities. That is a treaty provision. I'm not sure whether your treaty provides for that, but even if it is not there, probably you can speak to the African Court so that they can advise on how they went about getting 23 member states to appoint the focal points alluded to yesterday by one of the speakers. What we also try to do, we use sometimes at the level of my office, formal, informal means. Every opportunity we have to talk about enforcement, we grab it. We go for a meeting, we see a minister, we wouldn't mind calling the minister on the side, sharing information. I think that helps. Sometimes those personal relationships can really, really help in making a difference. Also, going back 2020, it has also been the practice at the court when it delivers judgments to always include a clause requiring states to report back within a particular period. Sometimes the court would say 3 months, sometimes it would say 6 months. Not that that has always been complied with. I'm not aware of any state coming back. But at the end of the day, when we engage at the level of the registry, when we engage anybody from the competent national authority, we always would remind them, at the end of the day, you were required to have reported back about a year, 2 years ago. You still haven't done so. At least that helps. So in conclusion, I would want to say I am of course, we know there are tons of challenges. Some would say at the level of the African Court, 11%, ECOWAS 21. But when we talk about enforcement, I'll advise we shouldn't just look at the statistics. 10% doesn't mean the court does not have impact. Impact and rate of enforcement, I think, are two different things. In fact, if you come to the ECOWAS court, you would see a lot of politicians running to the court when they run into trouble. We've had former presidents coming to the court. We've had very senior government officials coming to the court. Why are they doing so? They're doing so because they have confidence in the court. Why? Because of the impact some of the judgments have had in our sub-region over the years. One other issue I also wanted to highlight, for me, the biggest issue isn't lack of action. The biggest is communication. A lot is done by our member states, but unfortunately, they don't bother to report back. I have had conversations. I remember when we had our international conference in Sierra Leone, I had the opportunity to speak to the Secretary General of the National Human Rights Commission of Cote d'Ivoire. We had written to Cote d'Ivoire, we didn't get any response. So he was on a panel. After the panel, I went up to him and I was able to bring out the letters we sent. He looked at the list, he was like, what is the problem? I personally know some of these judgments have already been enforced. So I then tell him, please, when you go back, can you please help us put pressure on your competent national authority to send us the information we're requesting for. It also happened at the court. We had a lawyer from Togo who came to Abuja to represent the government. After the court sittings, we were able to have a very short meeting with him. In minutes, we were able to retrieve the information we needed for Togo. And he just looked at the first pages. I mean, going by our records, we have a total of about 27 judgments that that country has not yet enforced. But when he looked at our records, he told us that he personally knew there were more than 10 judgments on our list that were already enforced, but we do not have the information. So I think continuing to engage helps, which is why we decided, as in the management of the court decided, that this year the court is going to have a meeting of all competent authorities. So we're hoping we will have that in the first quarter of this year, bring all of them together, all the competent authorities, so that we can, share ideas as to how we can make our court, particularly the enforcement of its judgments, a lot better. So you can learn about their challenges and probably come up with a roadmap on the way forward. I think communication is key. If we continue, or maybe once we start getting the information we are requesting from member states, I'm sure some of these statistics would go way up, way better than they are at the moment. So I thank you all very much.
Thank you so much, Honorable Gay. Actually, every time you opened up your mouth, you came out with the materials, and I had to resist the urge to stop you because you were saying almost everything very, very important to us, because we cannot be perennial complainants without getting solutions, and you seem to be coming out with the solutions. Thank you so much. I now move to panelist Professor Thomas is a renowned professor of international law, Kenyatta University, and he has been working so much on regional integration issues, particularly with the East African Court of Justice. He holds multi-courts with the students to raise up the public interest litigation. Professor Thomas, answer the following question. There is something peculiar. I have been warned, ticketed by the registrar, that I am not time conscious, but as a lawyer I can defend my case and justify why is this session so important to me and to us all. There is something peculiar about being an academician, Professor. Academicians stand as vessels for mentoring, shaping, and communicating the gap through research and situation analysis. From academia experience, what gaps in the implementation of court decisions do you think should be filled, learning from other regional and international jurisdictions? Please.
Thank you very much, Professor. Thank you for the kind introduction. It's, of course, a great honor to be a member of this panel for me. Answering your question, I picked a thought from yesterday's presentation by Dr. Mercy Detcher, if I understood it correctly, is that the thought was that the interest of those who are in power is to stay in power. This is something to which research, academia should answer by giving the situation or offering the situational analysis. So there's some quantitative research, unfortunately not enough of it, but there is some quantitative research in terms of the percentage of implemented and not implemented judgments. And this quantitative research reveals astonishing things. Astonishing things. Some of them were mentioned yesterday. African Court on Human People's Rights, 75% of judgments, no implementation. The Commission, full implementation, only 14%, 1/4 of judgments. Partial implementation, 30%. EACJ, I think the Honorable CTC mentioned that figure, 47%. That's a research from 2019. There's another research from 2021, 50% of judgments implemented of the East African Court of Justice, noting, however, that most pecuniary orders, orders which award damages, are being implemented. Similar figure for the Inter-American Court. So that's the comparison. But now, and Don Deya mentioned it yesterday, let us compare it with the implementation of arbitral awards by ICSID, International Center of Settlement of Investment Disputes. ICSID is basically a post-colonial arrangement that ensures that the rights and the needs of international capital are given preference over the development needs of the countries of the global south. It is a place where, for a lot of money, foreign investors can sue the host states for the violation of a biased and exaggerated standards of protection of capital. And now the figure of implementation of those arbitral awards, 97%, 9-7. Now my first thought on this, if I want to stay in power, and that's my interest, then paying is easy. Paying is easy. I just do online banking. And after all, it's not my money. Yeah? It's the taxpayers' money. I pay and I stay in power. In human rights cases, rule of law cases, most of the docket of the East African Court of Justice, so I pay. But taking some action, for example, amending media laws, and I know my brother is going to say something about that, amending electoral laws, amending land laws, releasing political opponents from prison, giving voice to the people, or taking action against a foreign investor. This is risky, because if I do that, I might lose power. I pay for things to remain the same. Russia was particularly good at it. I do nothing, but I pay the compensation. Was good at it before being expelled from the Council of Europe for invading its neighbors. Now, so that's quantitative research. Now, qualitative research, and the question which I would like to ask is, why do the states actually implement judgments of international courts? And the main reason in the international scholarship which is given for that is reciprocity. Reciprocity. If I don't implement judgments when I lose, other states will not implement judgments when I win. EACJ has jurisdiction for interstate disputes, but it has not been frequently used as of now. But there is one case pending, I think. and I am afraid more cases are likely to come up. So reciprocity, number one. Number two, reputational cost. If I lose, but I do not, because I don't implement, yeah, I lose and I don't implement, I lose reputation. I lose, but I don't implement. I lose reputation as a law-abiding state. But the question is, what reputation do I have? And what reputation do I want to have? The one that I'm at risk of losing. The reputation as a reliable business partner and investment destination. Oh, that's a reputation all governments want to have. If I don't implement commercial awards, I will lose business. And every government likes business and investment, also because it is the political and economic elites that benefit from this. Business and investment help to expand power and stay in power. So the compliance rate is high. Human rights cases, rule of law cases, democracy, transparency, oh, that's different. Reputational costs occur only for governments that have the reputation of respecting human rights and want to maintain it. Fortunately, it applies to all EAC partner states. But there are also other costs. And I remember my guiding thought today, the highest cost of non-implementation of a judgment is the loss of power. The loss of power. So do I lose power when I don't implement judgments? Am I at risk? And now it depends. And we are still talking about human rights cases. It depends on how angry people can get, the Gen Zs can get, also millennials, others, about ignoring of judgments. How angry. Now, the second factor, how can they organize themselves? And are they in a position to organize themselves, to mobilize, and to mount and put pressure on the government to implement? And then finally, the third factor is how responsive the government is to that pressure. And if people are angry enough, if they can generate enough pressure and the government is responsive to that pressure, the compliance rate is going to be high also with human rights, in human rights cases. It's going to be high because there is a likelihood I will implement, because there's a likelihood that I will lose power if I don't. If you look at those indicators, I realize that those indicators are also indicators for the quality of democracy. How well can people organize? How well they can communicate? How do they put pressure on the government? It's the quality of political process, how responsive the government is. The quality of democracy. If the quality of democracy is good, the judgments will be implemented. It's a litmus test. Implementation of judgments in human rights cases is a litmus test for the quality of democracy. So now, EACJ, 47%, 50%. What does it say about us? It's the glass half full or half empty. Now, my final one. My third point is also some scholarship that, it's a string of scholarship that says, well, it's not always about winning and implementing. Sometimes it's just about filing and complaint, which can sometimes be an act of heroism to file a complaint against the government or a desperation. So sometimes it's just about filing and being heard and being able to debate an issue in front of an international judge, an issue which cannot be debated nationally on any domestic forum. It's about being heard about having grievances acknowledged, publicized, communicated. And sometimes it's also, and I alluded to that, the specific morality of a courtroom. That the petitioner, the aggrieved, the overlooked, the marginalized, the weak can face the government, the mighty, on equal footing and exchange arguments and communicate the grievances and argue the grievances out. And this is where I want to finish here, and I want to finish on an optimistic note. 30 seconds. The deficits of implementation notwithstanding, we must acknowledge that the EACJ has succeeded in giving voice to the voiceless, in stirring up the debate, and consequently also in improving the quality of democracy in East Africa. Thank you very much.
Thank you so much, Professor To. Actually, you have confined yourself within exactly 10 minutes. Congratulations. I don't want to add anything on what he has said. You will do the same. You will chip in when time comes for you. Now, our last discussant is Advocate Fajensi Masawe, who is a litigant in EACJ. Please answer the following question briefly. You can put them in one form. They are four, but summarize the answers. From your experience as a litigant in the EACJ, how long has it taken you to have a non-monetary decree obtained from EACJ implemented, if at all? What about non-monetary decrees? What are the challenges, if any, that litigants face at the stage of implementing EACJ decisions? And what are the causes behind those challenges? Is it inspiring to litigate in the EACJ, and why? What should be done in addressing the unpleasant atmosphere characterizing the implementation stage of EACJ decisions? Please.
Yeah, thank you, Prof. Yeah, and thank you, EACJ, for this wonderful opportunity for me to share my experience. Yeah, I'm an experienced litigant from the country I'm coming from, Tanzania. And I've done a number of the human rights and constitutional cases at the municipal courts, at the regional courts, one of them East African Court of Justice. I've also litigated before the African Court and African Committee of Experts on Rights and Welfare of the Child. And from all this experience, I've learned so many things which I think they worth sharing. When we started using East African Court of Justice, and that was the case of Mseto. Mseto was a newspaper which was banned in Tanzania in 2016. Some of my colleagues were challenging me. Why are you going to this regional court while you can't enforce? I was challenging them back. How many cases have you conducted at the local court and they've been implemented? It means it's not about the question of the East African Court decisions only. It's about all decisions of the court, even of the Court of Appeal of Tanzania, they've never been implemented. I'll give you an example. Sometimes we litigate on the issues which they complement the government policies. Let me give one of the cases which I litigated to Court of Appeal is the issue of the early marriage in Tanzania. You hear ministers, government, president, district commissioner, regional commissioners, police, everyone talking bad about early marriages, and even arresting those marrying the girls underage. And when we went to court to challenge Section 13 and 17 of the Law of Marriage Act, which is allowing the children to be married at that tender age, the government to become adamant to implement. So when it comes to the regional courts, and for this case, East African Court of Justice, we cannot blame you or hold you accountable why your decisions are not implemented. Go first and study the behavior of that particular state, partner state you are talking about. Are they compliant? For the ICD, arbitration and so forth, 90% or 99% I can say. I agree with Thomas here. But when it comes for this, for human rights, people's rights, freedom of expression, political rights, and so forth. It never happened. Let me start with the Mseto case, 2016, which was suspended. We came before the court, and we challenged the suspension to be unfair, and it was violation of Article 6D, 7.2, foundation principles of the community. And the court ruled on June 21, 2018, that the suspension and the banning the newspaper, it was violation of the treaty. Nothing has ever been done. We stayed almost for 6 years, and this newspaper was relicensed last year, among other 4 newspapers which were suspended around the same times. And all of these 2 among these other newspapers went to the local court and had decree against the government, and they've never been relicensed. Back then, when newspapers were suspended or banned in Tanzania, you go to court, you win. The next morning, the newspaper will be back on the street saying that we are back. But in 2016, we enacted the Media Services Act, which we brought to youth again. And this introduced the license annually. So when you are suspended, you go to court. At the time you finish the case, you cannot say, I'm back. You have to go back to the same person you are suing to ask, I need the license to publish my newspaper. And I'm wondering, where do you get this information about the implementation without consulting the lawyers who conducted these cases? For the Media Services Act, the law is being amended, but I can say it is 4% of what was ruled by the court. They've amended some other provisions which are not related to the case. But from what I've witnessed from the government, I was invited in the conference organized by the ministry last year. And one of the discussions around the Media Services Act, it was that we have failed to implement fully this newspaper act because some of the stakeholders went to court to challenge this. And sometimes I wonder who are advising the government. When they amended this law, it's as if they've implemented the decision, but not true. They are saying that they've done away with the criminal defamation, but they went to remove the fine. It's not the crime itself which is created by the law. So this percentage, I don't know where it's coming from. So who has the duty of implementation? We lawyers who conduct the case, we monitor implementation. And we have used fully all platform which is available. Tanzania was reviewing under UPR in 2021, 2022. And that was our platform. We prepared all the cases and outcomes. We do advocacy-based, research-based advocacy, evidence-based. Where is your evidence? You are saying media laws are bad. Here's the decision of ESCJ. You are saying early marriage is bad. Here's the decision. We are saying the issue of re-entry of pregnant girls. Here's the decision. So to us, all these decisions are coming. Whether they are implemented or not, they are of great value to us. And we use them as advocacy tools, sometimes to name and shame. And when you take them in the platform like UPR, before the UN Council of Human Rights, you don't have any good answer to give. Because it's not about the allegation, it's about the decision of the court. So how do we now, we can even monitor the discussion in the parliament when they're enacting the law. They always say, you'll hear some member of parliament say, or even the speaker, saying that, let us not enact this law the way it is, and tomorrow we hear that has been knocked out by the court. So they get the message. So your presence as a guider, as a protector or whatever, it has a lot of meaning. What we have to do is to amplify all the decisions coming from the court to make it popular. So it takes long to implement, but it has very big impact. But because I've litigated in different platforms, let us borrow the African Committee of Experts on Rights and Welfare of the Child strategy. They have the implementation hearing. When they deliver judgment, after 1 or 2 years, you'll be summoned by the committee to appear. The applicant will be given an opportunity to present what was the finding and what has been done by the state. And the state will come and do something. What happened? We have the re-entry policy in Tanzania right now, secular, and the guideline for re-entry. For the case which we brought before the African Committee of Experts. Why did they do that? Because they knew that we'll go there back to share the implementation. So what are we going to tell the committee? So at least let us do something. So from this, I'm advising, and the Council for the Communities here, to look at the treaty, to make sure that we have those kind of the implementation strategy within the. So mostly, all this implementation depends on the political will, whether it's from the national courts or from the regional court in the government of the day. There are things you can talk about right now which you could not talk about in the 5 years or 6 years back. Because the head of state set the tone. And once he set the tone, that's the government of the day. So some of the things which we are doing or we are not happy with, you can litigate on or you can pursue them to the government or whatever, and then you'll see what will happen because of who is the head of state. Luckily, right now, there is open dialogue within our country. All this discussion is going around like this one. We don't have opportunity to discuss those cases coming from the local court. For those coming from Tanzania, they know. Two of my colleagues, one of them is coming for this session here. They faced the problem before the Advocates Committee because they wrote an article and comment on the decision of the Court of Appeal. While for us, we understand any decision of the court is open for debate. And that was on the bail. They were writing that the time will come when our children will ask us, where were we when all this were happening? And he said that, he wrote that there are so many brave lawyers who saw all this shortcoming, but there was a judiciary which was so blind to see all these bad things happening in the community. You know what? That was an insult to the court. If you disassociate yourself with your decision, it means there is something wrong with the decision you have delivered. And for me, I know decision of the court is open for public discussion. So whether the decision is implemented or not implemented, to us as the advocates for human rights, we always use that as a tool of advocacy. And we are the one who is monitoring implementation. So the mechanism for implementation is within us. So next time, Mr. President and Registrar, I've seen Madam Christine around, have the platform or have the contact of the lawyers, contact them. And during this first government, even the then Attorney General wrote to me asking to provide with him the list of the cases which we have conducted in the local court and regional court and the status of implementation. That is the Attorney General. It means he doesn't have the database. So it depends on us. So also depend on us. We'll share the information. Thank you.
Thank you so much. You will agree with me that sometimes you even, as I said earlier, resisted the urge to stop a person when he's presenting because of what Tanzania calls madini, minerals coming out of his. So let's give them a big round of applause for the quality of their presentation. Thank you so much. Now I turn the ball to the other side, please. Any question, comment in the remaining, how many minutes? I want to be guided by Registrar. How many minutes are you giving us while the microphone is going on? Only 7 minutes, you can imagine. I think they have been exhaustive, much as I'm sure they have raised so many questions than even answers from the presentation they made. Yes, we are allowed only 7. Yes. Oh, Minister here.
Yes. Thank you very much to the moderator and all the panelists. The session has been very, very informative. And I hope the Attorney General of Uganda will pick up some areas that we need to work on in our country. but specifically to Secretary General of EAC and the CTC. I hope you now value our request to have a sitting to hear the issues that come from the Court of Justice. You know, I've been very unhappy about what you call noting. You know, for me, it's very unsatisfactory to say we have noted when we have not discussed. So can you now take up the, can you now introduce a sitting of the Council of Ministers to discuss the work of the EACJ together with its outcomes? Thank you.
Thank you, Honorable Kadaga, for that. Sorry, there is somebody. Yes.
Thank you very much. I'm Françoise Umukiza. I'm a member of parliament from the East African Legislative Assembly, EALA. I come from Rwanda. Thank you very much for the Lord's or Honorable Justice. You know, these are new terminologies, but I would like here to highlight that there is a linkage between EALA and EACJ. Maybe you are surprised, but I've been reading through the East African Legislative Assembly Powers and Privileges Act of 2003. And I was also surprised to not have heard from the CTC to mention about this, because it's very important that we know that EALA and the committees, the standing committees, have got also the powers as for the High Court or the Court of Law or the Court of Justice, like we are talking here. For instance, if there is a case whereby EALA or one of the standing committees of EALA, they are seeking evidences, they have powers under Provision 15 and Provision 27 to summon anyone in the community to come and present the evidences, even from the Council of Ministers, from anyone, even the SG, anyone in the community can be summoned to come and present the evidences. So this is a linkage you have to know. And you have to support each other because it's very important. And I have heard from this, my question is to know how EACJ is ready to show EALA that these powers should be really be highlighted, because we do that as members of parliament, but they are as if even the council doesn't know that these powers and privileges are here. Even the CTC, they don't mention about them. I was just surprised because this is the good platform, a good forum to highlight the linkages and also to strengthen it. The second question I'm asking is about the trade remedy committees. I know this committee of trade remedy, if it was put in place properly and also operationalized, many cases that EACJ is dealing with should have been avoided, especially those trade-related cases. So I think we can also take this opportunity to revive the operationalization of trade remedy, because it's another common market protocol, provision of the common market protocol, and we have to make sure we implement all the pillars of the integration in justice to support EAC citizens that are people-centered. And we're also promoting trade integration through market promotion and private sector promotion. Thank you very much.
Thank you so much, Honorable Member of EALA. Another, Chairperson, Council of Ministers here. Please bring the microphone to her. Yeah.
Thank you. We've listened carefully on the various discussions that have been put forward. I support my fellow minister from Uganda for spelling it out that there is a need for us to converge and discuss around the rulings that have been done so far and how the council can get to know some of these things that are cutting across with intentions to really advise appropriately. But the other concern I have is I am borrowing this, getting back to what we discussed yesterday with the various judges, where the point kept repeating itself that when they make some rulings within the regional courts, it comes clearly that there is something that heads of state could mention, like you are interfering with the sovereignty. Now, the concern that I want to put forward is, how have been the cases handled at the regional body to warrant an opinion like seems to be continuous from the heads of state that some of the ruling are interfering with the sovereignty of that specific state? Is it then like the cases we pick within the regional body? I'm just thinking loud on this. Is it then possible that most of the cases we work around the regional courts touch on individual versus the state, institutions versus the state? There is no one that is state versus the state. Or do we have, it's nice to look at it widely. Do we then have a case where we can say, the state has also taken an individual over a particular position? Would we then even have a case where the state also has taken to court an individual or an institution? So that now we see a balance, because if it is going to lean towards all the successful cases being against a state or a member state, a partner state, then that guarantees the speaking of you are interfering with the sovereignty. I'm just thinking loud over this, so that we are supposed, in my last opinion is, I think we need to work harmoniously. We need to harmonize our speaking, our consultation, our issues, so that at least there is a win-win situation, because we need support from the member states as the chairs or as the decision summit of the community. You also need our support, despite the fact that somebody was saying Council of Ministers is somehow political. We are also professionals at one given time. So all these things need a win-win situation and a tone that would bring all of us together, even as we stand to protect our rights, to protect our dignity as citizens or as partner states. Thank you.
Thank you, Madam Chairperson of the Council of Ministers. For the remaining, my apologies, you would allow me a few time now, so that I can, for the remaining 3 minutes, I give the opportunity to the discussants, particularly the questions raised by the Honorable Member of Yala, who was focusing on Dr. Kafumbe, and another one would be dealt with by Honorable Gay. Please, otherwise time is not our best ally at the moment. Chip in quickly, and then we move to another session.
Yes, thank you very much. I've heard the minister from Uganda say that it's important to have a meeting between the court and the council. That is advice that is well taken. We'll have to arrange that probably in an extraordinary session, so that it is dedicated entirely to matters of the court. I think the same idea then cuts across to the assembly, because they also have issues. It is true that under their rules of procedure and under that act that has been mentioned, the committees of the assembly, like what happens in partner states, they have powers of the High Court when they are summoning witnesses, and it is therefore possible that they could have some challenges that the council can help them resolve. So that is action that a message we are picking from here, and we are going to carry forward and implement.
Thank you. Honorable Guy? The Honorable Chairperson of the Council of Ministers wanted an experience of what was happening in ECOWAS.
Yes.
Vis-a-vis, isn't that also? Isn't that the case? Or what exactly do you want from us? I thought you wanted a clarification of some sort. Where is the microphone? So that that was very important, so that we can have a comparison.
I think it's source for the AGF. Yeah.
Thank you. I don't know whether I made my point clear or kizungu ndio shida. Anyway, what I mean is I had a concern that is coming informed by what we had yesterday with the judges, where they said in the course of executing their duties within the regional courts, there are cases where a particular ruling attract an opinion from heads of state that in the course of them executing their day-to-day duties on the regional matters, the opinion like they are interfering with the sovereignty of a particular member state, despite seceding powers or seceding provision. So my concern is how have you been attracting such a kind of opinion, because it kept appearing from the panelists? What attracts such a kind of opinion where heads of state at times say, you people are some rulings are interfering with the sovereignty? Would that then mean most of the cases we pass are all individual against the state, institutions against the state? There's nothing like a state against an individual that come before the regional bodies. That is what I meant. So that now we need to look at how have we been handling our cases. Are they too much on individuals, institutions against the state? Or there are also cases where we've won cases that the state versus an individual.
Okay, thank you. Now I understand. You don't need to come in. You know, you don't need to come in. This question, this concern is for all of us who have participated to reflect on the concern raised by the chairperson of the... Oh, you wanted to chip in?
Yes, please.
In half a minute. Can you make it?
Yes. Just a very brief comment on that. So I think it is a very common worldwide custom of a head of states and head of governments and politicians commenting on judgments. The question is how they do it and what follows. The panel is sponsored by a Konrad Adenauer Foundation, so I want to quote Konrad Adenauer, who was a Chancellor of Germany. And there was one judgment of Federal Constitutional Court in the 50s that ruled that establishment of a government-owned television company is contrary to the Constitution. And the Chancellor Adenauer said, this is not how we thought that the court would behave. The government is of the opinion that this judgment is wrong. Now, this is a comment, but which the Chancellor was entitled to make. But a key issue is that no intimidation of judges followed. That the judgment is subject to a debate, and the fact that this debate takes place is important, as highlighted by my colleague. The problem begins when the heads of states and the governments start to delegitimize the courts, putting pressure on judges. This is when we should draw the red line.
Thank you. That is a professorial half-a-minute response. With that remark, I thank you for listening to us, and we handle the microphone to our moderator, our MC. I should thank my panelists for not letting me down in any way. Thank you so much, and God bless you.
Thank you very much, Professor Ruhangisa, and all the distinguished panelists. Thank you very much for your contributions. And I just wanted to remind participants that the purpose of these conferences is to also allow us to have conversations informally on some of the contributions that have been made during the panel discussions. So even if we've not given you an opportunity to ask questions, it doesn't mean that you can't, on the sidelines, engage directly with the panelists. Now, we are not doing very well with time, and I would like to request that we make this a working coffee. So kindly grab a coffee, do a quick run to the bathroom if you need to, as the next panel takes their seats at the front. Now, the next panel is a panel on treading the thin line, litigating human rights issues before the East African Court of Justice. The session chair is Mr. Evans Ogada, a leading advocate from Kenya. The presenter is Honorable Justice Geoffrey Kiriawire, a former judge of the East African Court of Justice and a judge of appeal from the Republic of Uganda. On the panel, we have the Honorable Justice Sengu Mohamed Koroma, the Vice President of the ECOWAS Court of Justice, Honorable Lady Justice Anita Mugeni, the Vice President of the East African Court of Justice, Mr. Ramadan Abubakar, the President of the East African Law Society, and Mr. Peter Muriuki, a senior officer with the UNHCR. I'd also like to make special mention to the fact that this panel has been sponsored by UNHCR, and we really appreciate your support. Now, we have a publication here titled Upholding Judicial Independence in Kenya, Challenges, Context, and Solutions. And this publication has been developed, or the papers have been contributed by Thomas, who was just on the panel now, and Mr. Evans Ogada, who's the session chair for the next panel discussion. They have a few copies left. Please engage with them to get a copy for yourselves. Thank you very much. Kindly, can session chair please take over? And can the panelists please take their seats? I just wanted to remind you also about our social media card. We've been following up, and I think a number of you have not been hashtagging or updating your social medias. It's important that we have this from you. And don't forget to turn on your cameras, direct them to the QR code to get the pictures of the session. Thank you.
The Chief Justice of the Republic of Rwanda, the Judge President of the East African Court of Justice, all protocols observed. Mwaramutse. Is that the local way of saying good morning? Mwaramutse. Habari yenu. Bonjour. Welcome to this session. I don't know, my ancestors conspired when I was getting on stage and the light went off. We will be fine. Now, I will not be saying much. The panel is here, and it is a stellar panel. So for me, when I'm on stage, and this being East Africa and we being Africans, I like a little bit of energy. So can we clap for my panel, and we do it the Kenyan way. So the Kenyan way is always moja, mbili, tatu. That was a teaser. So you'll do it the Kenyan energy way. So moja, mbili, tatu. Asante sana. So without further ado, may I invite the presenter for this session, Justice Geoffrey Kirabwire from Uganda, to take over from here. I think he will be doing it from that side or here. From there. Okay. Could we welcome the good judge to take over from here? Thank you.
Thank you very much for your introduction. My Lord, the Chief Justice of Rwanda, my Lord, the Honorable Judge President of the ESCJ, allow me to stand on the protocol that was established by the Assistant Registrar and say to all of you a very good morning. I can feel the energy is not there after the Kenyan clap. but a very good morning to you again. The topic that I have been asked to speak into is treading the thin line, litigating human rights issues before the East African Court of Justice. I have a paper which, if I read, would take far too much time, so I will try my best to speak into the paper and raise a few issues for discussion. The question of the ESCJ, don't worry so much about that paper. I'm not going to go word for word. That is being, the question of the ESCJ and human rights kind of reminds me of that time as a student of literature. Shakespeare and Hamlet. To be or not to be is the question. In other words, does the ESCJ have or not have a human rights jurisdiction? Of course, this is intrinsically tied in with another question, which is whether the objectives and principles for the EAC can be achieved without having a human rights jurisdiction. Now let me put some context around that. When you look at the preamble of the treaty, it is very specific that the cooperation that the treaty brings is to cover all endeavors of human activity within the ESCJ, to ensure that the peoples maintain and enhance economic stability, foster close and peaceful relationships, and actually realize ultimately an economic and political union. And to do that, the treaty establishes various organs and institutions. And so, one of those institutions under Chapter 3, one of various institutions which are listed in Chapter 3, but Chapter 8 specifically provides for the establishment of the ESCJ as a judicial body. So in my paper, I try to establish whether, one, does actually the treaty confer this jurisdiction, and to what extent the ESCJ can actually ensure the interpretation and application of human rights. And I also want to look at the practice through a series of decisions that the court has made. Now, yesterday, Dr. Mercy cautioned us about the issue of jurisdiction. I remember as a law student, we were taught that jurisdiction is everything. And indeed, that has also been the position of the East African Court of Justice. If you remember the case of Alcon versus Standard Chartered Bank, the court held that without jurisdiction, a court cannot take even the proverbial first Chinese step in its juridical journey to hear and dispose of a case. And so, if you are to understand whether the ESCJ can or cannot hear human rights matters, then one has to look at the treaty itself. But you have to unpack the word jurisdiction, especially when you're dealing with an international court. Because you can look at jurisdiction from 3 points. You have ratione, persone, You have ratione temporis, and you have ratione materiae. All of those must exist at the same time. We're talking about the parties, we're talking about the time, and we're talking about the subject matter. And I've detailed that in my paper, if you need to look at it. But also, you must put the ESCJ in some context. And I think part of that was raised by the Honorable, the Attorney General of Uganda. Because you have to put it in the historical context of the community. In this regard, we must also look at the travaux preparatoires that led to the creation of the court. Unfortunately, we do not have a very central document in the community which details the travaux preparatoires in establishing this particular court. But we must remember that in creating the ESCJ, there were various voices as to what they wanted the ESCJ to be. And so one of the voices was this, that we want the ESCJ to be like the defunct East African Court of Appeal. That was one of the voices. And we must remember that the East African Court of Appeal itself was created by the Treaty for East African Cooperation of 1967. I think, yeah, the spirits from Kenya are still operating. Must be Marua. Okay. So this court had jurisdiction in Uganda, Kenya, and Tanzania. And it had jurisdiction to hear appeals from domestic courts, as provided by the law in those domestic courts. So what happened is that partner states had discretion to confer on the ESCA on a state-by-state basis jurisdiction on the court, which was ratione materiae. And therefore, the ESCA acted like an apex court. That is what some people wanted. And we must also remember that the ESCA itself was a successor to the Court of Appeal for Eastern Africa, which was created under the 1902 Order in Council. So the DNA of the ESCA was actually obtained from the Court of Appeal for Eastern Africa, which was a colonial court set up to do judicial work in the territories of Uganda, Kenya, Tanzania, Aden, Seychelles, British Somaliland, and St. Helena. Unlike the ESCA, it also conferred powers to these particular territories to determine what jurisdiction it should have. A lot has been written about this area of the creation of the ESCJ. And I'd like to share with you two scholars who have written articles and try and put all of this into some context. So Dr. Helena Trolley, who is from St. John's University School of Law, observed that even though special jurisdiction would have been given to IACA, or the East African Court of Appeal, it created a kind of common law that was used in all partner states. It therefore created a standard jurisprudence, and it created harmony within the laws of East Africa. And she quotes the former Chief Justice of Uganda, who said this about IACA. Said the Court of Appeal was credited with harmonizing various laws in East Africa and also developing law and common jurisprudence in the region. It promoted the observance of the rule of law, the protection of human rights, democracy, and good governance, the advancement of economic development, and the promotion of unity, cooperation, peace, and security. That was the view of the former Chief Justice of Uganda. Another scholar, Professor Seiji Taye of Buffalo School of Law, points out that this is what the civil society and many lawyers wanted. They wanted to see an ESCJ, which was in substance an IACA. However, he also argues that on the other hand, partner states in negotiating the treaty preferred an ESCJ with limited jurisdiction. They wanted their domestic courts to continue with unlimited jurisdiction because during the passage of time since independence, partner states had created their own domestic courts which acted as apex courts. It is these courts which used to go on to adjudicate matters relating to the individual Bill of Rights that were in the constitutions of those partner states. And so from the community point of view, it was thought that ESCJ would probably eventually become an apex court when political federation had been attained. So from this I draw this proposition that the jurisdiction of the ESCJ created a dichotomy of expectation, which has continuously played out in the life of the court. Of course, this situation has been open to speculation and uncertainty as to the outcome of a case. Now, when we look at the specific role, and I think of the court, and a lot of this has already been said, the treaty is the grand norm. It is the constitution of the community. And it is to this that the ESCJ looks to derive its jurisdiction. This is an important point because sometimes when people talk about the ESCJ, they are actually trying to assume what jurisdiction it has. They are trying to guess at what the jurisdiction should be. And I agree with many of the speakers that this calls for a lot of sensitization. When we look at the human rights jurisdiction in particular, you have already been referred to Article 27(1), which provides that the court shall have a jurisdiction, read this in full, the court shall initially have a jurisdiction over the interpretation and application of the treaty. The word initially suggests that the jurisdiction will be an evolving one, progressively changing as it is enhanced. This probably reflects the dichotomy that I have already talked to you about. That on the one hand, there was expectation that it could be like the IACA, and on the other hand, that it would be a regional international court which jurisdiction is progressively enhanced. But then we have 27(2), which then provides that the court shall have such other original appellate human rights and other jurisdiction as will be determined by Council at a suitable subsequent date. To this end, partner states shall conclude a protocol to operationalize the extended jurisdiction. So that's where the problem is. The word other. The use of the word other presupposes that it does not have that jurisdiction at the period of time. And therefore, that human rights is not part of the EACJ's rationale matériel. Of course, when we look at how the treaty has handled this, you have to look at the cases. Now, one of the areas is with personal jurisdiction. Rationale personnel. It says that Article 30 provides that any person who is resident in a partner state may actually file a reference. The details are there. And when we talk about individual, we are talking about both legal and natural persons. There are some mixed views about how Article 30 operates. In the case of Manrio Desiree and the Attorney General, the court held that individuals who live outside the partner states will not have access. And so if it were to have the human rights jurisdiction, there is this problem. If you're a citizen and you're resident, yes, you can have access. If you're a citizen and you're not resident, then you cannot have access. This decision led to the first dissenting opinion in the EACJ. I happen to be part of the dissenters, so I need to raise this issue with you. But whatever your understanding is, it would appear to me, and I suggest to you, that the EACJ is generous in allowing access to it, whether it is for legal persons or individuals. And this compares favorably with other regional courts like the African Court on Human and People's Rights and ECOWAS. The problem that has happened in the courts is that even though it is generous for people to come in, it has a time limit of 2 months under Article 32. You have to bring that action within 2 months of the cause of action having been crystallized. And the court has been very strict on this, if you look at Alcon again. And so one can say that even though it is generous on entry, it is quite tight on time. Now, this may not be very conducive for human rights cases, because many times when the violation has taken, it may not have been fully understood by the time you are able to file the reference. The other area worth mentioning on jurisdiction, and that has been said, so I will not take too much time around there, is the exhaustion of local remedies. This is also good for the litigation of human rights cases within the EACJ. What seems therefore to be outstanding is the protocol. Now, I'd like to review with you about 9 decisions of the court. And I've tried to put them in some kind of sequence so that you can see the evolution of the human rights litigation at the ESCJ. And the first case I would like to talk to you about is the Democratic Party versus the Secretary General of the East African Community and 4 others. In that case, the Democratic Party was trying to look for the corpus juris, the applicable law in terms of human rights in the ESCJ. And the Democratic Party argued that partner states had failed to make individual country declarations accepting the competence of the African Court of Human and People's Rights. In other words, also the Charter. Now, the ESCJ held that it only had limited jurisdiction to interpret and apply the EAC treaty. The court added that not making country declarations was squarely within the discretion of partner states. The court went on to find that the correct forum to determine this complaint was the African Court for Human and People's Rights. And therefore, the court found that there was no violation of Articles 6D and 7.2 of the treaty. This was a very interesting decision, especially when you look at the decisions today. We have looked at Article 6.2, and it specifically brings in the application of the African Charter on Human and People's Rights. 7.2, on the other hand, also talks about the implementation of universally acceptable standards of human rights. So when you look at this holistically, when you look at Article 27.2, and then you look at the decision in the Democratic Party, then it looked like the jurisdiction for the ESCJ to handle human rights matters was very uncertain. The second case is Venant Masenge and the Attorney General of Burundi. This involved the expropriation of land in Burundi. The court there found that, I see the president was in that case, the court there found that the exhaustion of local remedies was not necessary. They also found that the applicant's rights under Articles 6D and 7.2 of the treaty had been violated. And it stopped there. The court refrained from granting any further declaratory or injunctive relief. It said, the court found that if the applicant wanted to obtain relief, then it had to go back to the Burundi National Courts, thereby creating a contradiction. If you don't need to exhaust local remedies to file a reference, and the reference finds that there has been a violation, then you have to go back to Burundi to get enforcement. Again, it would appear that here it gave there was a wrong which went without a remedy. In Samuel Muhoshi, an Attorney General of Uganda, that one has been spoken to a lot. I will not go too much into the facts. We know there was a deportation at Entebbe, and the applicant was not given reasons why he was deported. Again, the court made a generic declaration and said that Articles 6D and 7.2 showed that Uganda had violated the treaty. But it said that it had violated the principle of illegality. It did not mention anywhere in its judgment that there had been a violation of human rights. For example, freedom of movement. And so we continually see these generic declarations. The East African Law Society and Attorney General of Uganda has also been spoken to this morning about, no, that was different. This is the one of walk to work, what we call walk to work in Uganda, where a protest was disrupted by the police and army. The East African Law Society said this was a violation of the right of freedom of association and demonstration. The court found as follows, that the applicant had failed to provide sufficient evidence to justify the claim, notwithstanding that the facts were notorious. That's a very technical finding, that even though you have notorious facts, you have a burden to prove them specifically. It's almost like fraud. But what is interesting about the East African Law Society is the dicta of the court. And I want to read this aloud. The dicta of the court stated, however, this finding should not be taken to mean that in appropriate situations with sufficient evidence, this court would not have held the Republic of Uganda in breach of the principles of the rule of law and good governance. I think it threw what you can call an olive leaf. And so we see the ESCJ alive to references coming to it, which have a human rights flavor, but is wary to make decisions that would open a floodgate of human rights litigation into it. But you see, the interesting thing is that the litigating public did not relent. They kept on filing more and more cases. And I think the breakthrough, as we have all known, came with the case of James Katabazi, which was talked about this morning, and the Attorney General of Uganda and Secretary General of the EAC. And this involved the case of bail to people who had been charged with treason. In Uganda, it was better known as the Black Mamba case, because everybody, the people who rearrested the accused people who had been granted bail were all dressed in black. The court then made this very interesting statement. It said, while the court will not assume to adjudicate on human rights disputes, the word human rights enters the what? The judgment. It will not abdicate from exercising its jurisdiction of interpretation under Article 27.1 merely because the reference alleges human rights violation. Judicial notice was then made that business will not be the same after Katabazi. And post-Katabazi is when you now start to see the change. The first areas to be litigated were those of freedom of expression. Burundi Journalists Union case against the Attorney General of Burundi. Judge President, you know that one as well. In that case, it held in part. In the present reference, the substantive issue to be addressed is the freedom of press and freedom of expression in the context of Articles 6D and 7.2. They moved away from generalities, illegality. The human right violation was identified. It went on to hold that there is no doubt that freedom of press and expression is an essential component of democracy. Then came Museto, an Attorney General of Tanzania, also in the same area. We have been spoken to about this case. Let me jump the facts. But I want to point out that in that case, in the Museto case, and I know Advocate Masawe said implementation was difficult, but the court for the first time gave declarations and orders which looked like having teeth. The court held in C, the minister is hereby ordered to annul the order forthwith and allow the applicant to resume publication. D, the United Republic of Tanzania shall, in accordance with Articles 38.3 of the treaty, take measures without delay to implement this judgment within its internal legal mechanisms. We are now seeing the court taking a more aggressive stance. The teeth were then further sharpened in Margaret Ziwa versus the Secretary General of the EAC. And it reaffirmed that, look, we are an international court, and as an international court, we have a duty to give effective relief through appropriate remedies where there is breach. In Margaret Ziwa, they did not only give a declaratory judgment, they also gave damages, moral damages. This was the first time that the court had done it, notwithstanding that Article 44 had anticipated that it is possible for the court to give damages, pecuniary relief. And so we move on to the Attorney General of Rwanda and Union Trade Center. The facts have also been given, and again, moral damages were given. I will not go into that. Nyongabo Theodori and the Attorney General of Burundi is an interesting matter, again involving the cancellation of a land title. The court held and said this was unlawful, and it actually applied Article 14 of the African Charter of Human and People's Rights, which guaranteed the right to property. It then went on to provide moral damages because at the time of granting the damages, the land had already been sold. And therefore, compensation was given. This was a departure. This was a departure. Remember the other one? Where they said, you go back to Burundi to get enforcement. Now the court itself was taking on that power itself and granted damages. So we can now see that the East African Court of Justice, notwithstanding 27.2, is starting to operate like what you see in other international courts. If you look at its practice, it also allows for amicus curiae, it allows for interveners, which is important in public interest litigation. Of course, the problem has been enforcement. I will jump that one because We had a full session on that one, but my views are in my paper. The problem with enforcement, and again this has been raised, is the matter of the Attorney General of Kenya and Martha Karua. Now, my brother, Honorable Justice Cheborion, said that this is an isolated decision. And probably it is. But I'd like to say that my research has seemed to suggest that the jury is not completely out on this issue. Why? I took the opportunity to scan the internet to see what other people are saying about Martha Karua. And in one review, this is what the author said. It said that from now on, ESCJ pronouncements amounting to a merit review of the court will be of no legal consequence and therefore unenforceable in Kenya. This is what one article put out there. So I think the jury is not yet completely out on that one. But what I would like to say for myself is that the decision of the ESCJ in Martha Karua and the Supreme Court advisory opinion of Kenya are at cross reasoning. Why? Because the ESCJ, in its decision, was very clear that it was not exercising appellate jurisdiction over the Supreme Court of Kenya. It's there. And the advisory opinion says exactly the same thing. It says that it applied what it called the principle of harmony, and that there is no vertical jurisdiction with the ESCJ. The two decisions are basically the same, but sending different messages. This is, I think, further evidence of that dichotomy as to who should be an apex court. But I'd like, as I move towards the end of my paper, to suggest that when we are talking about human rights litigation at the ESCJ, perhaps all along we have been asking the wrong question. And I'd like to suggest that it is now clear, and there's no question about it, it was settled in James Katabazi, that the court does not have a human rights jurisdiction. But the court has also made it clear that in interpreting the treaty, it will look at the treaty as a whole, with no particular article diminishing another in order to address the paradox. It is now clearer, if it was not the case before, that Article 27.2 is not the only article in the EAC treaty that addresses the subject of human rights. So the first question, and my questions actually are all drawn from the decisions of the EACJ. And I think they're better questions. The first question is this: can the objects and purposes of the community be achieved without the EACJ having a human rights jurisdiction? Article 8.1c of the treaty provides that partner states shall abstain from any measures likely to jeopardize the achievement of those objectives or the implementations of the provisions of the treaty. The Maseto case quoted this provision. Now, if this proposition is true, then why has there been a delay in creating a protocol on human rights? The second question is whether the EACJ should decline to hear matters involving the interpretation and application of the treaty simply because it refers to human rights as well. And I think the James Katabazi case has answered that. It's not always possible, I'd like to suggest to you, that you can have a pure reference to the court without an underlying human rights issue. So how do we manage this absurdity? I think that's a more relevant question. Finally, is it possible to have integration and political federation without harmony in partner states in the area of good governance? The James Katabazi case, the judges there found as follows. They said that it was palpably clear to them, and they had no flick of doubt, that good governance, and in particular the rule of law, was essential for East African integration. And that would be achieved by observance of Articles 6D and 7.2 of the treaty, which of necessity also includes the subject of human rights. I would like to suggest to you that the answers to all of these questions is no. It follows, therefore, that human rights is an inevitable part of litigation at the ESCJ, and it would be pointless at this point in time to reverse this subject. I'd like to make a few suggestions. The first suggestion, moving forward, is that the time has come. The time is now. Let's stop talking about it, let's do it. Let us create this protocol on human rights under Article 27.2. It is now. Secondly, to avoid conflict with the protocol and the decisions that the ESCJ has made, to the extent possible, these decisions must be codified in the protocol. Thirdly, that the time has come, and our friends from Yala are here, that the community incorporates the African Charter on Human and People's Rights as the EAC Bill of Rights, so as to have substantive law for litigating human rights in East Africa. Fourthly, and this is just a wild suggestion, the protocol can have opt-in and opt-out. Those who are not comfortable, just I won't litigate there. Let me conclude. There's still a lot of debate as to whether or not the ESCJ has human rights jurisdiction. This is almost a standard defense in any reference coming to the ESCJ. However, litigating parties have increasingly, through innovative advocacy, made the ESCJ a destination for the resolution of human rights matters on the basis of the interpretation and application of the EAC Treaty. There is a lingering dichotomy of expectations between the litigating public and partner states as to what the ESCJ can or cannot do. On the one hand, the litigating public aspire to have an ESCJ that operates like the defunct IACA, with a wide jurisdiction, while on the other hand, partner states favor a more limited jurisdiction awaiting political federation. This dichotomy, in my view, is likely to persist unless a protocol to extend the ESCJ's jurisdiction is made. The ESCJ, on its part, has engaged in progressive interpretation and application of the EAC Treaty on Human Rights matters, refusing to abandon its duty under Article 27.1 simply because Article 7.2 remains unresolved all these years. This has been referred to as legal diplomacy. My president likes to call it judicial diplomacy. In its judgment, the ESCJ has placed itself at the level of any other international court and has started to provide effective relief through appropriate remedies. The remedies themselves, however, have been measured, and this is the point, and I think it has been made. the ESCJ has not made very atrocious remedies. They have been measured and have not drawn excessive feedback, as was the case in the Anyang decision. I'd like to suggest to you that whatever the understanding of what the ESCJ can or cannot do in human rights cases, this paper has shown that the perceived thin line of human rights litigation at the ESCJ is not as thin as it used to be. I thank you.
We are going to definitely repeat that. That was a heavy paper. Moja, mbili, tatu. Asante sana. That is His Lordship Geoffrey Kiabure, Judge of the Court of Appeal in Uganda, as well as the Constitutional Court. Our time is well spent. Without further ado, we engage our panel in the Q&A session. Panelists, our time is spent, 5 minutes max for each question. I start with Lady Justice Anita Mugeni. Her bio is well crafted in the program, very rich, you will look at it. Justice Mugeni, your question is this. Given that the East African Court of Justice was initially established to address treaty interpretation and disputes within the East African community, how has the court navigated its limited mandate to address human rights issues, and what are the implications of this expansion?
Thank you, moderator. And I think all was said by previous presenters, but I'm going just to repeat it. As it is known, the ESCJ was originally designed to handle disputes related to interpretation and application of ESC treaty. This is under Article 27.1. And Article 27.2 said that initially the jurisdiction of human right was deferred to a future protocol, which has yet to be adopted to date. However, the court found ways to engage with human rights issues by invoking the principles of the treaty, particularly under Article 60D and 7.2. We saw this in James Katabazi and others. My colleague Cheborion gave a brief overview of the facts in this case. But just to summarize the court decision, the court made it clear that while it does not have an explicit human rights mandate, it can still address cases where violation of the rule of law threaten the core values of the ESC. That was in James Katabazi, and the presenter said from James Katabazi, so the court got confidence to handle cases or matters with human rights. And in other cases, like in Burundi journalists, this was also about human rights, which is freedom of press and freedom of expression. The court ruled against restrictive press laws. And again, it cited ES principles of democracy and good governance. And in Martha Karua, the recent one, the court also certified the court's willingness to review electoral and governance-related disputes, reinforcing its de facto role in human rights matters. Now, this expansion has both positive and challenging implications. On one hand, it has strengthened the judicial oversight and accountability in the region, giving individuals and civil society groups a legal avenue to challenge state actions. On the other hand, it has led tension with some member states. We talked at length about Martha Karua, who argued that the court is exceeding its jurisdiction. There are also some procedural challenges, like 2 months filing deadline. The presenter also talked about it. This can make difficult for human rights matters to be brought to the court. Ultimately, to conclude on this, I can say why the ESCJ has creatively worked within its limitation by invoking we are waiting for that protocol to be adopted, but in the meantime, the court succeed to handle these matters. But we are asking ourselves, the real question now is whether the court will eventually formally extend the court's jurisdiction to handle human rights, if this will happen one day, or while we are waiting, the court will likely continue to use these governance rules of law, arguments, and human rights principles and others, as it did this as a main entry point to address these issues of human rights. Yeah.
Thank you very much, Justice Mugeni. Mr. President Ramadan Abubakar. Yes, we can clap. The President of the Regional Bar, Ramadan Abubakar. Justice Mugeni speaks of tensions. So your question is this: how does the political climate within the East African member states impact on the independence and effectiveness of the ESCJ in adjudicating sensitive human rights cases? How does this political climate within the ESC member states portend for the future of human rights litigation? Over to you, Mr. President.
Thank you. Thank you. Thank you very much, Mr. Ogada. And to the good judge, that was a very brilliant presentation. And allow me now to respond to your question. And in terms of judicial independence, you'll agree with me that this is a key ingredient when it comes to dispensation of justice. Because without judicial independence, the rule of law is nothing more than a facade. And nothing more than a facade, and justice becomes a privilege rather than a right. The ESCJ being an integral component in the realization of justice, and for an effective court, it ought to be free from any political interference. But how does this political climate and political goodwill affect the court's effectiveness and independence of the court? First is, of course, the issue of funding. This has been an issue that has been lingering in the court since its establishment. And in fact, in terms of this particular conference, I believe it was to be held earlier, but for one reason or the other, it had to be postponed. And I'm sure one of the issues had to have been the funding. Even in terms of the cases that the ELS has filed and some of the cases that have been quoted here, you will find, for an example, is an election petition that we filed in 2021. The case is yet to be heard, and one of the reasons is, of course, the issue of lack of sittings due to the funding. Therefore, if there's political goodwill, the funding will, of course, be done. Secondly, is the issue of implementation of court decisions and this has been addressed in the presentation and, of course, by the earlier speakers, where the partner states do not have the necessary goodwill when there is high likelihood that decisions will not be implemented. And of course, the study that was captured by the earlier panel, a study that was conducted in 2018 by ELS, where implementation of the court decisions is at 47%. This is a study of 2018. Of course, there's need to do another one. And as the president of East Africa Law Society, I do undertake to make sure that another study is conducted so that we know in terms of where are we when it comes to implementation of the ESCJ judgments. Thirdly is the issue of the appointment of judges. Looking at the history of the court and what we have litigated on, some of the appointments are indeed political appointments. This is as opposed, of course, to a competitive process in some of our jurisdictions. And the East Africa Law Society indeed filed a case where Kenya had appointed a judge to the ESCJ, and we did challenge successfully before the Kenyan courts, Constitutional Court, the process of appointment of the judges. Therefore, this is an issue in terms of these political appointments that may hinder the dispensation of justice. Fourthly is the extended jurisdictional issue where Article 27.2 has, of course, been addressed by the presenter, the good judge. Fifthly is political goodwill, of course, or the lack of it, that has made the court remain an ad hoc court for many years, where judges are except the judge president and principal judge, the rest are part-time. Therefore, this limits the time available to handle matters and increase, of course, of backlogs. There's therefore need, of course, to have assistance to the judges, researchers, who will, of course, aid in their work. I think I'll end there in terms of the issues that emanate from your question. Thank you.
Thank you very much, Mr. President. Justice Koroma comes to us from the ECOWAS court. And from that vantage point, Justice Koroma, how does the ESCJ approach to human rights litigation compare to other regional courts such as yours, the African court, the European court, and what lessons can be drawn? Over to you, sir.
Thank you very much. I must first of all thank the East African Court of Justice for this invitation. And I thank the presenter for a very brilliant and eloquent paper, which has made my job very easy. Now, I come from the ECOWAS Court of Justice, where human rights has become one of its most enduring mandates. So clearly, for us, human rights is part of our activities. Now, from all the speeches I've had here, the East African Court of Justice has not got a direct human rights mandate. But my understanding is that it has been increasingly engaging in human rights issues, especially when those border around good governance, rule of law, and treaty violations. And to my mind, as judges, we should always think of the inherent jurisdiction of the court. So if, for example, you are dealing with treaty violations and an issue of human rights come into play, I believe it is your responsibility as a judge to make a statement, to make a decision, even if it is an obiter dictum. But you make a statement on that human rights issue. The other region, of course, the African Court of Justice has a clear and direct human rights mandate. Even individuals have access to the courts, NGOs, and so on and so forth, as long as there's a declaration allowing them to do so. For the ECOWAS Court of Justice, we had our direct human rights mandate in 2005. And from there, we have developed our human rights jurisprudence to such an extent that we cover almost all aspects of human rights. There's one interesting case of Hajaratu Mani against Niger, wherein the court held that forced marriage and slavery was contrary to human rights. And we awarded damages against the Republic of Niger in favor of Hajaratu Mani. And Niger actually enforced that judgment. In another case, in Serap against the Federal Republic of Nigeria, we heard that the right to education is a fundamental human right, and that Nigeria had the responsibility of providing education to its citizens. Again, Nigeria enforced that judgment. So we have developed in a lot of areas. There's another case in which we heard that the right to internet is a fundamental human right. So that when the Republic of Togo switched off the internet, stopping the citizens from accessing the internet, we ruled against the Republic of Togo, and the judgment was enforced, and they put their internet out. So this has been the mandate of the court. The European Court of Human Rights, of course, you know, has a direct human rights mandate. In fact, I recall, I think I have met with you there and the judge president. There, they have developed a huge body of jurisprudence on human rights, and such that most of our own courts, regional courts, Inter-American Court of Human Rights, all tend to learn from their jurisprudence. So, but one thing I will advise for the East African Court of Justice is to ensure that you have a direct human rights mandate, because human rights has become very important in our continent. And we should try to develop our own jurisprudence based on African realities. European realities are okay, but they are not African. They don't think like us. They don't behave like us. They don't even eat the food we eat. So in developing our body of jurisprudence, we must think African. In the case of ECOWAS, what assisted us in getting our human rights mandate was civil society. The bar associations in West Africa all mobilized their efforts and got the Council of Ministers and the Authority of Heads of State and Government to give the human rights mandate in the 2005 protocol. Thank you very much.
Thank you, Justice Koroma. Mr. Peter Muriuki, an advocate from Kenya, works for UNHCR. You come from a background of refugees, and the question then will be for you, what could you suggest as a contemporary human rights-based approach or approaches to human rights protection, and what will be the role of the East African Court be in that human rights approach to refugee protection?
Thank you very much, moderator and presenter. We start from a point of cognition that refugee rights are a part of human rights, and that international refugee law is just a subset of international human rights law, and that to guarantee the welfare and safety and the needs of refugees, recourse is always had to international human rights law. In this region that is East Africa, there is a mix of very good refugee protection practices and some that are not good. maybe I start off by saying that the statistics in East African region are that there are about 4 million refugees in the 8 East African states, and out of which 3 million are nationals of East Africa Party states. That is a significant data set that speaks to the fact that all East African partner states are producers and hosts of refugee. There are 12.4 internally displaced persons. UNHCR considers these persons of concern to our organizational mandate. And if you add the IDPs to the refugees, then you will see that of the 300 million East African total population that the Secretary General was talking about, a whopping 5% of East Africans are living in displacement. What does that mean? These are people who generally are relegated to the marginal areas of East Africa in almost all states, in the most unproductive regions that are climate change prone and very unproductive. They are relegated to exclusion from socio-economic services of the states that they are hosted in. And because we are talking about economic integration, sustainable development, and ultimate political federation, East Africa has to ask itself, how are you or are we going to attain the markers of sustainable development, of people-centeredness integration, when a whopping 5% of the population lives in the marginal, in the periphery of government planning and socio-economic service provision? And therefore, there is a case and a very great need for us to include refugees, not only for the sake of affirming their human rights, because like all of us, they have their human rights and socio-economic rights as well, but also because in doing so, it is congruent to the objectives that East African community has set upon itself. And you find that in this terrain, the East African community, you have some states like Uganda that have now come up with very progressive approaches where refugees have been granted the right to work, freedom of movement, rights to choose the place of residence, no cost work permits, particularly for East Africans, very progressive approaches that are going to allow refugees to integrate and to be included. Refugees are a group of people that infuse, a variety of skills, diverse skills, market approaches in the communities where they are hosted and where they live, and therefore confining them into limitations of freedom of movement, encampment, no work, no education access. I'm taking it to the extreme, but that is what it is in some of the states, is an inhibition to their industry and economic contribution to the East African community. And if we have to progress along the objectives of the East African community, the agenda we want, the agenda Africa, we want Vision 2063, SDGs 2030, we have to include refugees a lot more. What do I mean by inclusion? When we look at the East African Treaty, for instance, it has guaranteed certain socio-economic rights for its citizens, if I may use that terminology. The right to move across boundaries of partner states with very easy travel documentation, the right to establish, the right to reside. And sometimes we have asked ourselves, do you lose this right if you are an East African? just by dint of being displaced as a refugee. And this comes to mind because we find a lot of restrictions imposed on refugees who cannot travel, who cannot work, who can't engage in educational mobility or labor mobility within this region that is guaranteed for the rest of the residents of this region because they are refugees. So does the virtue of being a refugee dispossess you of rights that are treaty-based and treaty ring-fenced for the rest of the population? Perhaps this is the kind of jurisprudence that the civil society needs to precipitate by approaching the courts to see whether there is enforceability of the rights that avail to the rest of East Africans for refugees as well, and whether the constriction of these rights by national refugee registration is a violation of the treaty provisions. For instance, if you look at the East African Treaty, it also set an obligation for the partner states to enact common mechanisms of refugee management. The wisdom about having common mechanisms of refugee management in the EAC Treaty is security leaning. The provisions that talk about refugees are housed at the provisions or agenda that is security-based. That may not be very right, but even then, even that minimal requirement of common mechanisms of refugee management, 25 years later, we were celebrating East Africa as 25. A policy that was started by joint effort of the EAC and UNHCR has been in draft for more than 12 years. It has been on the road to citation to the Council of Ministers, and I'm happy that the leadership of that council is here, for the last 6 years. Is this realistic? What does this deprive the refugee in East Africa of? This policy was meant to become a standard of reflection so that national refugee legislations can be calibrated along the ideals enshrined in this policy. So it provides a standard for harmonization of laws and also asylum standards. When asylum standards are not harmonized across a region such as the EAC, and yet we are on the road to integration, and you have heard that the significant population that is refugees within East Africa are actually East African, what that drives refugees to do is to rove from one territory to another because of uneven protection terrain. So if it takes 3 years to be registered in Uganda and it takes 1 year to be registered in Tanzania, why would you as a Burundian refugee, for instance, not hop from the one country that takes 3 years to the one that takes 1 year? If, for instance, one refugee hosting state does not affirm the core principle, let's say, of family reunification, that if your family who had been separated from you during conflict can join you and become part of the family that in asylum, why wouldn't you go to where there is more progressive asylum policy? If one state allows you to work, like Uganda, why would you then be in the other 7 states that do not allow you to work of East Africa? So what is this? What this is creating also is inequity in asylum burden. There is asylum. The institution of asylum is held upon the principle of international burden sharing and international cooperation. And asylum equity, the burden is only attained when you have common mechanisms and common standards of asylum. So that saves, certain states from hosting disproportionate burden, refugee burden, while others are not preferred by refugees because they have very stringent and exclusive asylum policies. And we have been also wondering, is it a good case, civil society and bar associations, that ESCJ, is it the Secretary General, should be found as having not complied with a treaty requirement, obligation to enact common mechanisms of refugee management, and that must have been so important because it is amplified and repeated in the EAC peace and security, peace and security protocol. And you know, it also has other issues that come with it when refugees are seeking to move onward from one territory to another in search of better asylum. You know, they become vulnerable to trafficking, to smuggling. The court, we allowed the court because of its easy to approach mechanism, including the locus, the issue of locus, that anybody who is resident in the East African state can approach, because this is very protection apt for refugees. They can file references also, or be helped to file references in the court. We also are very excited by this jurisprudence. I'm not a practicing counsel now, but from what I hear and from what I read, that non-compliance with national laws that, you know, that a country has enacted can form fodder for litigation in the ESCJ as deviation from good governance and rule of law. How about these national, partner states of EAC that form very elaborate refugee legislation, national refugee legislation, and then flagrantly breach them or not comply with their provisions? Maybe this is a fodder for litigation in the regional courts. I see my time is up.
Thank you. Thank you very much, Mr. Muriuki. Our time is well spent, so that I don't upset our host, the registrar. We are going to take 3 minutes for the final question and closing remarks. I start with you, Mr. President. Jurisdictional challenges. What are the key jurisdictional limitations faced by the ESCJ? I know Justice Chabuire alluded to some of them. What are these jurisdictional challenges in addressing human rights issues, and how can we overcome this to strengthen the mandate of the ESCJ? Over to you, Mr. President.
Thank you. Thank you. And I'll echo what was presented by the presenter, because I have nothing out of the ordinary from the presentation. But just to say that in terms of Article 27(2), in terms of the where it was also read, I won't read it, but in terms of Article 27(2), where the protocol is expected to be enacted so that it can extend the jurisdiction, is yet to be enacted, and therefore there is need for operationalization of this particular protocol. Article 32, of course, as it was highlighted, where it expects, before a reference is filed, that you have to be within the timelines. As it was presented, indeed, the timelines may be short, therefore there is need for amendment and extension of this time, because sometimes when it comes to these human rights cases, there is indeed need to do some research and, of course, collect evidence. Therefore, I ask myself, if the timeline is 30 days to file a suit, then what about the timelines of hearing the suit? Ponder on that. Then, what needs to be done? My view is, and of course I agree with the presentation by the good judge, in terms of adoption of the protocol to extend the jurisdiction of the court to expressly handle matters human rights. And of course we can borrow from what is being done at the ECOWAS court, where they did this back in 2005. The other one is that there is need to amend the EAC treaty to repeal, of course, the issue of the 60 days and to extend this. And the other one is to continue creatively utilizing other treaty provisions, as it was done in the Katabazi case. This include Article 6D and 7.2 of the treaty, where there are good precedents on this. And the other one, and lastly, is of course assenting of the bill on human rights, which is still pending assenting. Thank you.
Thank you very much, Mr. President. On that issue of the bill on human rights, I have my issues with that, but we'll say it later. Anyway, Justice Koroma, in light of emerging human rights challenges such as digital rights, climate justice, and migration, you've talked of the Togo example, whereby ECOWAS says this is an international human right. You have to observe it. How can international courts such as the ESCJ adapt its jurisprudence to remain relevant and to be responsive to contemporary issues?
Well, the point of departure would be that, as has been expressed here, the East African Court hasn't got any human rights, direct human rights mandate. So if they haven't got that, then going into digital rights, migration, and so on, they need to broaden their mandate and be proactive. But one thing, as I initially said, courts have an inherent jurisdiction. When you have an opportunity of adjudicating on some issue, you try to do so. Because otherwise, for you to get that direct mandate to deal with all of these things, it's not going to be easy. What we are doing at the ECOWAS Court is we broaden our horizon. Digital rights have been adjudicated upon. Slavery has been adjudicated upon. Refugees have been adjudicated upon. So we try to do all what we can in order to broaden the human rights space. So I believe the East African Court should also be proactive. But what is most important is to try to broaden your mandate. Because the moment you have human rights mandate, then all other things will fall into place. So fortunately, I see attorneys general here. I see top government officials. They should try to ensure that you have that mandate. When you have that mandate, all other things will fall into place.
Thank you very much, Justice Koroma. Finally, go to Justice Mugeni, and perhaps we will invite a comment on the question, what strategies can be employed to build public trust in the ESCJ as a viable forum for human rights litigation, particularly among marginalized communities?
I think building public trust in the ESCJ starts with awareness. Many people, not only marginalized communities, don't even know the court, that the court exists. That the court can hear cases with human rights implications. We need a stronger legal education campaigns. We need from the court also translate documents using local languages which what you used to call mwananchi can understand, so that we make sure that people understand that their rights and the court roles. Beyond awareness, accessibility of the court is key also. We at the ESCJ has already taken steps by setting up sub-registries in partner states. By setting up those sub-registries, the court brings court closer to the community. By starting this rotational session, also the court try to bring the court closer to the community. We bringing a case to the court, you can file with no cost. There is no cost needed. This also removes the major financial barrier. However, there is a problem. I think court need to work closely with ELS, a problem of legal representation. because of technicalities, a layman needs a lawyer or a professional to be, to bring a case in the court. So we need also to expanding a pro bono legal support by working with the East African Law Society or bar associations within partner states. There is also an issue of credibility. People need to see that court decisions lead to real change in the community. Timely ruling, strong enforcement mechanism will build confidence. And finally, the court also need to partner with, as I said, civil society, media, and government to work together from the awareness and helping people to bring cases, also for the enforcement. From there, I think the ESCJ will be visible, accessible, and effective, and trust will follow.
Thank you very much. Professor Ruhangisa spoke of Madini. Judges have spoken, but she's certainly given us gems to think about. A hand of a clap for the good judge. It will be remiss of me not to allow Mr. Muriuki to give us his final word. He sponsored our tea today. Mr. Muriuki, final word. Way forward. I want to be in good books with you. Final word from you.
I think we all need to reflect that a significant population of Africans, East Africans, including its leadership at the EAC, at the presidency level, have been refugees at one point or another, and it is the curation, it is the protection of their rights that allowed them to become the leaders that they are today and the citizens that we are today. So refugees is not a population that we should ignore, because this segment of the population of East Africa has demonstrated that they can even occupy the bigger portion of the regional leadership in this bloc. So we need to ensure education for refugee children, right to work, the adherence to the national legislation that we have protecting and managing refugees, most of which is very protection apt, and to know that we need to allow refugees also to enjoy the socio-economic rights that are enshrined in the EAC Treaty and in the corpus of many other laws that we have, because it is the whole society approach, it is people-centeredness, and it is inclusion of everybody, leaving nobody behind, that is going to propel the integration that we have marked unto ourselves as East Africans, including refugees, who are a significant population.
Thank you. Final words, Justice Geoffrey Chabwire.
Thank you very much. I think I have covered the terrain. I have given the challenges. I have brought, and we still don't have. This protocol is an indictment on us, and it creates the dichotomy that I have spoken about. I think if we try and look at all the proposals that have been given, I think we can be clear, much clearer, on litigating human rights at the ESCJ. I thank you.
Round of applause for the good judge. Now that the bench is here, the question is this: what is the chapeau, the heading of Article 6? It reads principle. The term principle on any constitutional document is no ordinary provision. What does it mean for us? Article 6D identifies that any future human rights regime in East Africa has to be modeled around the African and people's and human rights provisions. What does that mean in terms of an identifiable core of human rights corpus? 6D read with 27. 27 talks of a protocol to govern human rights in East Africa. That is an obligation. What sort of obligation is that on the states now? And what does it mean for the states? It is not a mere suggestion. And to the members of IALA, when the treaty talks of a protocol, is your bill the same as a protocol? That's a question for you to ponder. I'll take 3 questions. 3 questions. I see 1. Second question. I see 2. Final question. Final question. Attorney General. 3. Protocol. I saw 1 here. Short and sweet. First question here. Your name and the person who you expect to answer your question.
My name is Fatuma Ndangiza, a YALA member from the Republic of Rwanda. And I want to start by thanking EACJ for inviting YALA in this very important conference. The question I have is linked to the issue you raised on interpretation of Article 6 of the treaty, in particular Section D, where clearly in the fundamental principles of the community, there is a provision on promotion and protection of human and people's rights in accordance with the provisions of African Charter on Human and People's Rights. In all the discussion of our panelists, you've been talking about EACJ lacking human rights mandate, jurisdiction mandate. And in my humble opinion, I'm not a lawyer, but when I look at this article and being a fundamental principle, I believe it gives you powers to navigate on matters of human rights. And again, when you look at the treaty, the entire treaty from preamble until the last aspects of the treaty, in all areas of cooperation, I can cite, for example, Article 121 on the role of women in economic development, and also Article 123 on cooperation in political matters. There are many aspects related to human rights promotion. I just wanted to know why the court cannot seize this opportunity, because I don't even understand, when you talk about human rights, is it something that is standalone? I thought the treaty in itself, in all its provisions, human rights is cross-cutting. So for me, I really think, as one of the panelists, from ECOWAS said, I believe the ball is in your court. You can see how you can utilize the treaty to also work on human rights jurisdiction. The final issue I wanted to raise, and this one I also wanted you to help in interpretation, it's Article 24 of the treaty, where it talks about composition of the judges. And then there is where they talk about the number of appointed judges should be 15, not more than 15, and to whom more than 10 shall be appointed to the first instance division, and more than 5 shall be appointed to the appellate division. So in my simple interpretation, I believe this would be 3 per partner states, which would imply only 5 partner states, yet we have an expanding community of 8 now partner states. So in my view, I believe this will require a treaty amendment. And this has been the elephant in the room. I'm happy that the council is here. Why is it taking so long to amend the treaty? This treaty was adopted when we were only 3 partner states. The community has expanded. There are so many issues, so many gray areas, including the mandate of the court itself. So I just wanted to know the roadmap of the amendment of treaty and whether the court, in your capacity, can advise both the summit and the council to fast-track the amendment of the treaty. Thank you.
Thank you. I think that will be handled by President Rama. It will be difficult to leave it to Justice Mugeni. So President Rama, you'll attempt that question for us from the member Yala Rwanda. The Attorney General here had a question.
Thank you very much. Thank you very much, panelists and Justice Chiriabwire, for your presentation. I have had the opportunity of reading the ESCJ decision in Martha Karua, and I've also read the advisory opinion of the Supreme Court of Kenya. And I agree with you, both of them agree that there is no merit review power with the ESCJ. The question that I have is what then is causing the complication? What is the issue that is causing the problem? And I think we need to really look at Article 27, read together with Article 30, and reconcile the two in order to achieve the principles in Article 6D, because I think the issue here is where a legal person can bring a decision to the East African Court of Justice. Any decision, I think that's what Article 30 says, and yet Article 27. So I think you need to help me understand what then is the problem. If we are both agreed you cannot review my decision of the Apex Court, what then is the challenge? Thank you.
Honorable Leji, who is to respond to your question?
Justice Chiriabwire.
Okay, thank you, sir. The last question, yes, the lady there.
Thank you, distinguished moderator. I'd like to, first of all, to appreciate and congratulate the presenter and the panelists for the insight. Also thanking ESG for associating the Office of the Ombudsman of Rwanda. I am the chairperson. I'm the ombudsperson of the Office of the Ombudsman of Rwanda. I have a comment and a question as regard the issue we are discussing on the competence of the court as regard human rights. In my view, it is about interpretation of the treaty, the provision, Article 6, Article 23, and 27. Because the court, as you all know, are the guardian of human rights. And I'm wondering how a court of East Africa has no jurisdiction as regards human rights. Because when we look at on Article 23 of the paragraph 1 of ESC Treaty, it states that the court shall be a judicial body which shall ensure the adherence to law in the interpretation and application and compliance with this treaty. When we talk about this article speaks it all, because when there is rule of law, good governance, you can mention there is a rule of law or good governance while rights of people are not respected. For me, the issue was restrictive interpretation of this Article 23, paragraph 1. Otherwise, there is this Article 6D. Also, when you look at the treaty and even the protocols, there are human rights. And for me, even though the treaty is not specific about human rights, the competence as regards human rights, but indirectly, It is the essence of the treaty and the protocols, human rights. And I think all cases decided on by the court are human rights based, right to property, right to freedom of speech. Those are human rights.
Yes.
I think you have the jurisdiction, but for maybe for the sake of clarification in the treaty, there can be an amendment. But without that, even before that, nothing can hinder the court to decide on human rights cases. Thank you.
Thank you. That was brilliant. We have the chair of ministers here and the judge president. I will hear from the minister, then judge president, and then we go to the responses.
Question number 2 is on refugees. It's very clear, I agree, that most of the refugee camps within the marginalized parts of the countries that are being established. And then you find out that true to the fact that they are not well facilitated, the areas are not well facilitated in terms of enhancement of human growth. But again, you find the bodies that are taking care of the refugees in these marginalized areas. Make sure the refugees are well taken care of, they are well facilitated. And then you imagine a situation on the very human right thing, you find the host community is equally suffering more than the refugee, because the body that is, be it a UNHCR body or whatever body, is taking care of the refugees by providing the most basic, which the host community around do not get provided. So, and you find in the spirit of human rights, the locals, or the people that is hosting the very refugees, seem to be having the challenge, and sometimes they would protest against the refugees. So in the spirit of protecting the human rights or doing the human rights, when do you draw the line between, because if the host community complain that the refugees around are taken care of and as we are suffering, and then that conflict is there, when do you draw a line between which human rights is which one in a case like that one? Thank you.
Monsieur le juge président, over to you, sir.
Yeah, thank you so much, moderator. Nasamani sana.
Asante sana.
First of all, I'm not talking about the human rights, because to me, what the Honorable Ndangiza said, and what the Honorable from the Ombudsman office from Rwanda said, to me it suffices. What I want to say is that this conference, if you look at the attendance, this has never happened in our 2 conferences. So that we have the chairperson of the Council of Ministers, the first Deputy Prime Minister of Uganda, and the Minister of EAC, the ministers from EAC, the CTC, the Attorney General, and the former registrar of this court. So the Secretary General sitting with me here, who is also, of course, I want to end by you. By the treaty, Secretary General is the accounting officer of the community. So let me inform you, when we talk about the amendment of the treaty, the Attorney General of the partner states, they are members of the high-level task force on amendment of the treaties. So it means on the issue of amendment of the treaties, it is within the docket of the Attorney General, who are the members of the high-level task force on amendment of the treaties, spearheaded by the CTC, who is here. So any matter relating to amendment of the treaties is within the docket of the Attorney General. Not only that one, the Attorney General are the members of the Secretarial Council on Legal and Judicial Affairs, which is the only Secretarial Council is a legal arm of the Council of Ministers. So all these issues of amendment of the treaties, the docket are here. So whatever we have said, if they agree, they can do it. Because the chairperson of the Secretary Council on amendment on legal and judicial affairs is the Attorney General of Kenya, who is here with us. The Council of the Community, who is organizing this meeting, is here. The Secretary General, who is the Secretary to the summit, is with me. The chairperson of the Council of Ministers, who convened those meetings, is with me. So to me, I think now we can do whatever we want, and the EALA is here. But in closing this one, let me talk about the case here, where Uganda paid $54,000, and the Secretary General paid $54,000 for a case which was filed by the Honorable Sitenda Sebalu from Uganda. When Attorney General of Uganda failed to provide the comments, which was the decision of the Council of Ministers, Uganda failed the case in the court, and the CTC failed the case in the court. And the community paid $104,000 because of the Attorney General of Uganda, who is not paid, it's not to this one. So who has not provided the comments, and the Secretary General who has not followed. So if you read the Sitenda Sebalu case, you can see that the community can pay all those amount of monies because of the Attorney General, but also because of the Secretariat. But because all of them are here, we can proceed the way.
Thank you. All of you are here. Wait, I'm told the CTC is here. Do we have the Council for the Community? There's a question that was here before we hear from the President. Where's the CTC? Yeah? Okay. There's a question from the member Yala Rwanda. We'll want you to advise us as our AG for the region.
What was the question? Can I have the question first?
The question was on certain amendments that are needed. Or we can go to the President as refresh. The President has answered it, eh? That's what I'm getting. Is there anything remaining? Perhaps the mic to her.
No, I just wanted to know the amendment of Article 24 of the treaty. It concerns the court and the number of judges, but also because there are so many provisions in the treaty that have to be amended.
Yes.
The roadmap for amendment.
Yes.
And the timeline of the treaty.
CTC roadmap timeline. Or do we leave it to you to consult? And we are told they are here. The President has told us they are here. Do you have a mic next to him? Thank you.
Thank you very much. The amendment of the treaty is canvassed under Article 150 of the treaty and sets out the time when there's a... First of all, it says that the treaty can be amended at any time by agreement of all the partner states. And then it says any partner state or council shall submit proposals for amendment of the treaty. The proposals have to be submitted to the Secretary General, who has 30 days to communicate the proposals to the partner states. In turn, the partner states have 90 days from the date of dispatch of the proposal by the Secretary General. And once that time expires, the Secretary General will then submit to the summit through the Council. So the treaty has elaborate procedure to follow in terms of amending it under Article 150 of the treaty, and we expect proposals to come in from partner states or the Council. The issue of Article 24, there is an issue there because Article 24 has set a cap on the number of judges that can sit on the appellate division. Just says 5. That's the maximum. As we talk now, the partner states are 8. So there is need to look at that provision. In fact, it is one of the proposals or the requests that came from the Republic of South Sudan when they joined to say what happens to Article 24, sub-Article 2. But there are also challenges there because then it means the question that arises also is, do you have to have a judge every time a country joins the community? How many judges are you going to have at the end of the day? If you have 15 countries, will you have 15 judges at the appellate division and then maybe another 15 judges in the first instance? The first instance actually puts it at 10. So the discussions are going on. And I would encourage that if there are any proposals to amend the treaty, they can be submitted to the Secretary General and they will be processed.
Okay.
So the window is not closed.
Thank you. Thank you very much. We had a question, Director Justice Chabwire, so that we finalize on this.
Thank you for the responses, and I'm particularly happy that over the period of time, it is now evident from the audience that there is support for the court to push the limit, push that line in terms of human rights, in terms of Articles 6D and 7.2. I think they're asking, why are you looking for more jurisdiction? It is there, you know? And that is what the court, that's the position that the court has taken. The court is no longer looking at 27.2 as the only provision relating to human rights in the treaty. It took some time, but remember, the pre-Katavazi cases are the post-Anyang Nyong decisions. The court came out of a very, very difficult time after Anyang Nyong. And slowly by slowly, it started to find its what? Its feet in terms of what does the treaty say as a whole, with no provision, one provision diminishing the other as far as protection of human rights is concerned. Now, but we still need a direct mandate, because remember, 27.2 was part of the original provisions during the negotiations. So I think also there is that legacy issue, a hangover, where in the discussions, human rights must have been a big problem in leading to 27.2 being provided for. And as I have said, the travail préparatoire in this area has been weak. I hope CTC and others can work to look up for these documents, because they contain a lot of information that informs why the treaty is what it is. Now, for Martha Karua, AG, Uganda, I'm also wondering what the problem is. I would like to speculate, but then I may get into trouble in the process. I mean, I come in peace. I have, remember, Martha Karua was a matter relating to state responsibility for courts. You see, because there is this, I would like to refer you to the draft articles on responsibility of states for internationally wrongful acts. And it actually indicates that a court can actually perform a wrongful act for which a state is liable. And I think that is where Martha Karua, ESCJ, was premised. And probably, and I come in peace, probably, Martha Karua advisory opinion was a comeback to that. Because when you look at the reasoning, you're hard pressed to, you're saying the same thing. So what is the problem? You know? So I think it is territorial, sir. It is territorial. People are still struggling over tough. As Justice Cheborian had said, it is not usual. We have the ESCOF, the Burundi cases, where the Constitutional Court of Burundi was also found to be liable under state responsibility, and we did not get that talk back from Burundi. So I think slowly by slowly, the whole scope of understanding will be achieved, that even when you talk about the state, you're not only talking about the executive, because that's the popular one. The draft articles also provide for state responsibility for the legislature. So it's also possible for them to be in violation of treaty. It also provides for possibility for judicial organs also to be in violation. So this is an area that is growing, and I think that is what informed the advisory opinion that we are keeping our tough. But I think when you look in the substance of the decision, it will not stop the ESCJ from once again, if a position is brought to the ESCJ, from making a decision very much similar to Martha Karua. Thank you.
Thank you very much. Ladies and gentlemen, a hand of applause for this panel. The Kenyan way. Moja, mbili, tatu. Asante sana. Our time is well spent. We have gone beyond what the host allocated us. May I say thank you to everybody for participating. Waziri, your question was not answered, but may I suggest that you share a table with Justice Koroma over lunch. He will provide you the ECOWAS answers. Thank you very much.
Thank you very much, Honorable Justice Kiriawire, for an excellent presentation. Evans Ogada never lets us down. Excellent moderation. And the panelists, you've done justice to the presentation. Now, as we close the morning session, I want to thank you all for your participation, but I believe the people who most deserve the lunch are the people who stayed in their seats since morning without even taking a coffee break. Now, the next session is the cross-border trade panel discussion. And we are going to look at the implications, its implications in the ESC, and to what extent the ESCJ and national judiciaries exercise their role in addressing NTBs within the ESC. I want to make a very special mention to the East African Community Secretariat, Honorable SG. We thank you very much for sponsoring this panel. And we hope that you'll be able, with your team, to follow this discussion. I know you have engagements this afternoon, but we've shared the live feed, and hopefully you'll be able to sign in and follow. Thank you very much. This is part of the good inter-organ collaboration, and we continue to hope that this continues in the future with all our other conferences and the activities of the court. So we'll be here at exactly 2 o'clock when the presentation is made. We are going to follow the same rules we've followed since morning. On the clock, the presenter will take the mic, start his presentation, whether the room is full or not. Thank you very much, and bon appétit.
It is with great honor that I join and welcome you to the 3rd Annual East African Court of Justice, ESCJ, Judicial Conference held here in the beautiful city of Kigali.
As we gather here today, we are reminded of the critical role of court plays in interpreting and upholding the East Africa Treaty and the laws of the community.
In the changing dynamics of our society, including digital technology, there is need to have a reflection on does the law that we have in place serve us?
The court is instrumental in upholding the rule of law through its interpretation, application, and enforcement of the treaty.
As we move forward, I propose that we focus on the following key areas. First, strengthening judicial institutions, especially regional courts, and finally, cultivating critical thinking about AI and ensuring its alignment with justice.
At present, the EAC has achieved to an extent legal, political, and socio-economic integration.
Notable stride in engaging with the East African Court of Justice by sending its judges to serve on the courts to handle regional legal matters together with their colleagues from other member states.
They even be aware that when we render our judgments, we don't go to see whether our judgments have been implemented or not. But I remember the Eastern African Society made a study to look at how our judgments have been implemented.
The treaty that establishes us allows us and the Office of the Secretary General in particular to investigate any issues that have been brought before the attention of that office, in this case my office, and pursue different mechanisms.
And we are actually using them to train even the rest of the lawyers so that they can be familiar with the rules of procedure and how things matters, like how things function at the East African Court of Justice.
Of course, being a unit that is relying for facilitation more on what every country remits, they need a better package.
And they play this role by ensuring that these decisions are implemented and enforced within the partner states.
There's a well-functioning online filing system. The decisions on costs are very user-friendly.
But unfortunately, over the years and over 25 years, we've created little kingdoms.
The East African Court of Justice, EACJ, is the judicial arm of the community established under Article 9 of the Treaty for the Establishment of the East African Community. Its role is to ensure the adherence to law in the interpretation and application of and compliance with the EAC Treaty. It was established in November 2001 and marked its 20 years in November 2021. During the 20th anniversary, the court launched its annual judicial conference in the Republic of Burundi and has henceforth been rotational in other partner states. The East African Court of Justice will this year hold its third annual judicial conference in Kigali, Rwanda on the 18th and 19th February. The judicial conference, under the theme Justice, Ethics and Enforcement of Decisions, a Judicial Pathway for Regional Development, will be followed by the annual rotational court session of the EACJ from February 24th to 7th March. Leading up to the conference, we set out to interview key stakeholders and users of the court and find out about the successes and challenges of the court and how it can continue to carry out its mandate effectively. We first spoke with the key government leaders who are important in ensuring the court works effectively.
Thank you. The Council views the East Africa Court of Justice as a critical institution in advancing East Africa community integration agenda. And as it is, it's purely a judicial body that is out to make sure the binding laws in the name of the treaty that is applying to all the member states are well spelled out, are well executed in those countries. And they also help a lot in terms of, it is a unit where when you are not fine on your side, and as a member state, and as an individual, as an institution in a member state, you have an option. And that option is East Africa Court of Justice. So for us, it is one of a critical structure institution within East Africa community because of its role that touch on justice, that touch on interpretation of the treaties, that touch on, a place where you can have your resolution settled. It is a place that is, if you have issues that you would want interpreted, there are better place to interpret a law and the rule of law is followed in that scenario. So for us, it is one of the most critical organ within the structure of East Africa community and the spirit of integration. It's actually the one that enhances all that put together. In my opinion, given the fact that this is one of the harms within East Africa community, and it is one of the critical harm in terms of dispensing justice, and it is one of the critical harm in terms of spelling out what the treaties are in every member state. We need to make sure they're always well facilitated, because if you look at the 8 member states that we have, we may have a case put at the headquarters where now we say the headquarters of EACJ is in Arusha, for example, and we have a case that would want it to be moved to a place like Kigali, for example, or Kenya, for example. They need to be facilitated in a way that the resources that would allow them to move from one place to another within the member states in terms of, facilitating the activities. And also, as a council, we would want to see a situation where this unit called East Africa Court of Justice is allowed to expel without intimidation by virtue of the membership. They need to be facilitated in whatever country they go.
I'd like to invite Honorable Justice Dr. Michael Mtambo, Judge of Appeal, Comesa Court of Justice, to come forward. I'd like to request Honorable Deng Nialgai, Honorable Member of the East African Legislative Assembly and from the Republic of South Sudan, to please come forward. I'd like to invite Mr. Felicie Mumvaneza, Commissioner for Customs from the Rwanda Revenue Authority, to come forward. I'd like to invite Mr. Benedict Msengele, Director of Customs and Trade from Trademark Africa, to please come forward and take your seat. It would have been preferable to make this presentable. Oh, apologies. I must have forgotten Ms. Jane Nalunga, the Executive Director of Siatini. My sincere apologies. Please come forward. Honorable Chief Justice Emeritus, I know it would have really been in order to make your presentation to a full room, but time is not on our side. I believe we have the most important people in the room, the people who are willing and looking forward to hearing your presentation. I'll now hand over to the session chair to please take it on from here.
Thank you, Christine, and good afternoon, all of you. Pleased to have you here before this topic on cross-border trade, and I think 90% of us here crossed the border coming here. So we are subject of this topic. What I'm not sure is whether we were also trading or not. But I'm told yesterday evening after dinner, some people went downtown to trade. So we are subject of this discussion. So we'll hear how NTBs will also affect us. And to do that is the immediate former Chief Justice of the Republic of Rwanda, Justice Faustin Teziliayo, who was also the Deputy Principal Judge of East African Court of Justice and a legal jurist and writer by his own right. Justice Teziliayo, please take the podium.
Thank you very much, moderator, for giving me this opportunity to talk about cross-border trade, more specifically with regard to the role of the East African Court of Justice and national judiciaries in addressing no tariff barriers. Just to reply to the registrar, the very important personality in the room are here. The Honorable the Chief Justice of the Republic of Rwanda, the President of the East African Court of Justice, distinguished ladies and gentlemen. It is a privilege. It is a privilege to have such an opportunity to talk about a matter which is touching to the life of people when we are talking about integration. I will start with putting my presentation into context with regard to the regime of no-tariff barriers in the East African community, and then I will deal with the role that are played by, or that ought to be played by the East African Court of Justice, but also national judiciaries in addressing the issue of no-tariff barriers. When we are talking about no-tariff barriers, it means that there is also other sort of barriers, like tariff barriers, that are among what we call trade barriers. According to the World Trade Organization, as of 2023, world trade volume and value have expanded 4% and 6% respectively on average since 1995, since the establishment of the WTO. However, a growing protectionism, trade tensions, geopolitical challenges are raising concern as they could potentially harm global trade and slow economic growth. It is posited that the global trade environment is becoming more uncertain to businesses due to the rise of protectionism, increased trade disputes, tariffs, and trade barriers. We know we are talking about, in East African community, we are talking about referring also to other regional economic communities. They are set up by the respective treaties. We do have also protocols for the implementation and different legal framework that is set up. But despite signing these agreements, setting up, for example, a custom union, as in our case, states retain enormous power to employ some measures other than tariff to retain control of trade and slow inflow of trade from other countries into their territories. So these measures include sanitary and phytosanitary standards. They include also packaging and weight requirements and other domestic regulations that are required of exporters or importers. So otherwise termed as no-tariff measures, those measures are considered as no-tariff barriers when they are not justified in the context of the subject trade agreement and are aimed at unfairly restricting flow of good or service from another country. In our context, in the East African community, we know that the mission of the East African community is to widen and deepen economic, political, social, and cultural integration in order to improve the quality of life of the people of East African through increased competitiveness, value-added production, trade in investment. And in this regard, as we have been seeing, the East African community integration agenda is guided by the treaty, of course, and in line of the implementation of the provision, the relevant provision of the treaty, they have been signing and the ratification of the protocol on the custom unions, on the common market, but also on the monetary union. So why then, despite this very important milestone reached in setting up, signing and ratifying this very important legal instrument, we still have this trade barrier? Why we still have this trade barrier that continue to affect the free flow of goods and services among partner states? So we see that even if on paper we have reached the stage of a common market, the trade, intra-East African community trade remain very low. It remain at only 15% of ESC total trade in 2023. So we see that no tariff barriers are common. They remain a major concern for the business community in the ESC region, and they add to transaction costs and remind the free movement of goods and services as enshrined, as I said, in the Common Market Protocol, but also in the Custom Union Protocol. I am not go through the paper that I have prepared because as far as the no tariff barrier understanding is concerned, I assume that you understand what a no tariff barrier is. In short, it is a tariff. I mean, it is a barrier which is not related to trade, but which is nevertheless undermining the free flow of goods and services in a given entity like the East African community. So these trade barriers have to be eliminated. In order to do so, the East African community has adopted some measures, mechanisms in order to eliminate these trade barriers as far as no tariff barriers are concerned. So we have some administrative measures that have been envisaged in order to deal with these no tariff barriers. But before that, these administrative measures are underpinned by the legal framework, because in order to deal with these no tariff barriers that are persistent, the EALA enacted in 2017 what is called the East African Community Elimination of No Tariff Barriers Act. And this act provides for the following mechanism: national monitoring committees established in all partner states, regional monitoring committees, the ESC time-bound programs on the elimination of no-tariff barriers, elimination by mutual agreement, but also other mechanisms within the said act. What is very important is to see how these mechanisms, the administrative mechanism, has been implemented. I have to point out that apart from the National Monitoring Committee, but also the Regional Monitoring Committee, National Monitoring Committee helped by national focal points, the Secretariat also has to come in, especially when the matter is escalated to it. And the Council of the Minister has also a role to play when the Secretary General escalates the matter to the Council of Ministers. And very important to point out is that there is a missing link. There is a missing organ that ought to be responsible for the, as far as trade remedies is concerned. And it was alluded to this morning that the Committee on Trade Remedies is yet to be set up. Yet it is a very important piece as far as administrative measures, mechanism to deal with no tariff barrier. So the Committee on Trade Remedy, which is to be constituted of a member qualified and competent in matter of trade, custom, and law, was anticipated to be a body designated to investigate disputes in the industry, recommend measures to prevent injury, and to ensure timely fulfillment of all requirements by partner parties to the dispute, while providing advice as may be necessary. But again, as I said, despite the enactment, the amendment of the Custom Union Protocol in order to set up the trade, this Committee on Trade Remedies, the ratification of the the amended protocol has not intervened yet. So I take this opportunity, of course, of the presence of the excellencies, the Attorney General, and also ministers in charge of East African Community Affairs in their respective partner states, to call upon on them, because it is not understandable that we are talking about enhancing regional trade, and yet we are not ready to set up some mechanisms that are required in order to speed up or even to grant some remedies as far as violation of the very important provision regarding the free movement of goods and services is concerned in our region. So let me go to the question then with regard to which role the East African Court of Justice and national courts have to play as far as addressing no tariff barrier. So the East African Court of Justice has an important role in addressing no tariff barriers related to dispute. We know that the East African Court of Justice is the judicial organ of the community, and we know that according to Article 30 of the East African Treaty, any person who is a resident of a partner state can petition the court even with regard to the trade dispute, and in our case, with regard to a no tariff barrier related dispute. So the court has had to deal with some disputes related to trade, and I will mention only two. One is Gralac supplier versus the Attorney General of the Republic of Burundi, and the case is about really goods that had to be conveyed from Tanzania in transiting to Burundi and Rwanda, and finally to Uganda, the final destination. The applicants in Gralac supplier versus the Attorney General of the Republic of Burundi contend that they paid all the requisite statutory and government levies, charges, and fees, and yet, in order to permit the lawful and the safe passage of the good through and out of Burundi. And the applicant case is that despite that, the goods were seized by the respondent at the border post, and the goods were given, according to the respondent, to needy people, and of course the goods did not reach their final destination. So they pray for another compelling the respondent to pay them, loss on track, higher on profits, on investment, but also on earnings. So the government of Burundi respondent alleged that the goods were not allowed to leave the country for security purpose. But the court find otherwise. The court find that the applicant had been given a green light by the Burundian Revenue Authority to transit for the transit of the goods, implying that they complied with the legal requirement. So the court ordered to pay for the loss, but it didn't grant compensation for special damages because they were not proved. Another case was alluded to this morning also with regard to a Ugandan citizen who, Mr. Kalari Stephen, versus the Attorney General of the Republic of Rwanda, with regard to the closure of the border between Rwanda and Uganda, and the case is about free movement of people, but also goods coming from Uganda that could not reach the territory of Rwanda because the border was closed. So I am not going through the facts of the matter, but decision was taken and the court declared and ordered that the respondent act of closure of her border point and blocking of access to the border point contravene provision of the East African Community Treaty, and that the respondent act in restricting freedom of movement of Rwandan citizens to Uganda against their wish is a breach of the provision of the East African Treaty. So I just picked these two cases dealt with by the East African Court of Justice. And we have talked about the challenges that the East African Court of Justice is facing with regard to, for example, the, my time is out. But I will take some few minutes in order to sum up. So we have talked about the challenges that the East African Court of Justice is facing with regard to its ad hoc nature, but also the constraint with regard to budget. And there is also another challenges with regard to these duplication really of the parallel mechanism to deal with some disputes, especially custom union-related disputes. So we discussed at length, I am sure, this morning what has to be done, and I am very glad that in this August audience, we have personalities that can push the matter forward. With regard very quickly, national courts. National courts can, of course, they are playing a very important role as far as the implementation of the treaty and related protocol is concerned. But the big problem, again, is that when it comes to one entry, which is the preliminary reference, we have seen that only, as the Attorney General of Rwanda pointed out in his keynote yesterday, only one preliminary ruling was issued by the East African Court of Justice, while in other jurisdictions, like in the European Union, you know, just for 2023, more than 500 applications for preliminary rulings were handled by the Court of Justice of the European Union. So that is one. But also when it comes to, you know, to address this matter, we know the problem related to backlog that we are facing. If we go for the edit that justice has been done, but also justice delayed is justice denied, we will see that this matter will not be disposed of as expeditiously as we could expect. Let me conclude. Let me conclude by saying that, yes, the East African Court of Justice is doing relatively well as far as addressing national tariff barrier-related disputes, despite the constraints that were mentioned by various speakers. Yes, national courts are doing their best, even if they have to go further as far as they are also empowered. And what is required really, is to empower the East African Court of Justice in order to be able to fulfill its mandate with regard to making sure that this ad hoc nature of its functioning is addressed. And what is required is also to make sure that decisions that are taken, of course, are implemented, and we have talked about this in the morning, this morning. And all in all, I may state that the East African Court of Justice, as a judicial organ of the East African community, has to continue to be empowered to play a more central role in resolving regional disputes, including trade disputes. And that its decisions are respected. And these will enhance, of course, the rule of law and trust between member states and their citizens, thus constituting a conducive environment for to creating or to increase intra-East African community trade. I may quote the former, I just wish to quote the former Secretary General of the United Nations Commission on Trade and Development, Mr. Mukisa Kituyi, when he stated, protectionist policies and trade barriers ultimately harm the very people they aim to protect by limiting access to market and stifling competition. So if we have to address this question, we have, of course, it is essential to build the requisite political will that provides the leadership, that provide resources, but also that provide commitment needed to effectively eliminate trade barriers and promote regional integration within our community. Thank you very much for your kind attention.
Let's give him a clap the way Ogada showed us before we went for lunch. 1, 2, Funga. Thank you very much, Justice Ntiziliayo, for that insight. Now I have very eminent discussants here. If you check on your booklets, you'll see their bios. Wherever they occupy those places as of right. So I'll start straight away with the Honorable Ndengai, who is a member of EALA. Now, Mheshimiwa, where you sit, the work of EALA, and what the presenter has told us, the problems you're encountering about NTBs, what do you think from your position can be done? How can EALA help so that we can either reduce or totally eliminate these NTBs?
Thank you very much for giving me this opportunity to participate in this panel. And I would like to start with thanking your Justice Nzelayo for this insightful presentation. I fully agree with you that the issue of NTBs is a consistent problem within EAC. And I'm really glad that you brought up the issue of the non-tariff barrier with regards to the Trade Remedies Committee. At this juncture, let me try to directly respond to the question, what is EALA doing? But I would like to take indulgence, if you allow me, to maybe add a reframing to the question. What is EALA doing, rather than what has EALA been doing? Because, of course, these NTBs, it's not just happening now. It has been a consistent issue within the community. You talked about the Trade Barrier Committee, the Trade Remedies Committee. Let me start to give you a little bit of background about this infant called the Trade Remedies Committees, and why I say it's an infant. This is a process that has been taking almost more than 10 years. Now, what is the Remedy Committee? It's basically an instrument within the Customs Protocol Union, whereby it is a committee that is supposed to be set up with members from each partner states who are proficient, as you said, in issues of trade and issues of law and issues of customs, so that they address the trade disputes that arise. Now, this particular, we all know that 2004 was the time that the protocol was approved or was passed. 2009, the summit members gave the permission to amend the protocol. Now, that particular Trade Remedies Committee falls under Article 24(2)A. And it says that this is a committee that will be set up, and it will be made up of 9 members, 3 from each partner states. Reason being, at that time, there were only 3 partner states. Thereby, you have 9 members who will sit in the committee to address the trade issue. Fast forward, by 2009, of course, and then 2016, we have the Burundi and Rwanda and South Sudan joined. So there was a need to amend And it's only one line. I need to amend that particular dispensation so that it allows for additional members to join as countries, as the community grows. 2013, 2014, the Council of Ministers gave directives to all the partner states to ratify. Nothing happened. Up to 2019. Now we're starting from 2009 and now we are in 2025. In 2019, when I was part of the Committee on Trade and Investment, we undertook an oversight to all of the partner states to find out what is the problem. Why are we having problem with the ratification of this particular article? We did an oversight. We spoke with all of the relevant institutions that are tasked with issues to do with the protocol. We spoke with the Justice Ministry. We went to and met with the members of Parliament. All of them, either they didn't know that they were expected to do it, or they didn't receive notification from the Council of Ministers, or they are working on it. Needless to say, all of them were very positive. We agreed they are going to make sure that these instruments are ratified and the instruments are given to the Council of Secretariat. Up to now, nothing has happened. The question is this: what is the reason for some of these delays? In our interaction with the members of Parliament and the traders when we were doing the oversight, one businessman came and told me, and I won't mention which partner states, he said, look, we all know about this ratification, but there is some people don't want it to be implemented. Because the committee itself is tasked with actually enforcement measures. It can have the right to actually enforce penalties, and he says that the business fraternity, sometimes they feel like maybe this is going to be an obstacle, so they are not happy and they're putting pressure on the technocrats and on the ministries not to ratify. Up to now, this is the situation. So we've got the Council of Ministers here, and I really think this is something that we need to address, because without having that mechanism that can assist in addressing the NTBs, because they have the enforcement mechanism, and that gives them the mandate to ensure that disputes that arise can be handled in one place and can be resolved. So this is something that IARA has been working on, and we will continue to work on it together with the Council of Ministers to really push the partner states for the ratification. Now, in terms of our mandate, of course, as I said before, our mandate is, we have got 3 mandates: sensitization. We also have a mandate of legislation. And in terms of legislation, pushing for this ratification is one of the responsibilities that we can do. In terms of also legislation, I would like to recommend also that IARA review the strengthening of the ESC Elimination NTB Act 2017 that you have mentioned. Now, this particular framework, even though it has the mechanism of looking at the legal framework, of looking at the NTB elimination, it lacks the strong enforcement. And I think that is what you said, that the missing link is this Trade Remedies Committee. So it's really important that this particular committee will go a long way in operationalization of the NTB Act of 2017. Because without that link, the enforcement is not there, and therefore people will continue to create and to manufacture NTB. Because if there's no deterrent and there is no enforcement, nothing can move forward. The other aspect for us as IARA, in terms of sensitization, that is one of our mandates. Now, educating traders and the border officials, I think is really important, because sometimes NTBs might be unintentional. It could also be because some of the traders are not aware about their obligations under the protocol. Maybe they are not aware of what they're supposed to follow and the documentation that they're supposed to have. So sensitization by IARA is really important so that we can educate the traders and all of the stakeholders that are in that space. In terms of also addressing or looking at establishing compliance and enforcement units. Now, this can work if the Trade Remedy Committee is implemented. To have the Trade Remedy Committee working together with the Secretariat in terms of having a compliance and an enforcement unit that can work seamlessly. So while the Trade Remedies Committee will be responsible for resolving trade disputes, it's critical that the NTB compliance unit and enforcement unit supports the enforcement efforts in a seamless, structured manner. What do I mean by that? The compliance unit should be responsible for identifying, documenting, tracking NTBs across the region. It will act as a centralized hub, gathering reports from traders and border officials, and when an NTB is reported, the unit can assess whether it requires administrative resolution or referral to the Trade Remedies Committees. Now, the Secretariat is already doing quite a lot of work in terms of compiling and reporting, but I think we need to do it in a seamless manner, and it has to be more comprehensive. So these are some of the things that IARA is involved and continue to be involved in.
Thank you very much for that lorry load of information. The problem now will go to those who are to implement the many suggestions she has given. Now, next I'll go to Justice Dr. Michael Mtambo. Now, the members or the partner sets of EAC don't just belong to EAC. A good number of them, in fact, most of them are in COMESA, others are in SADC, others are in IGAD, others are in ECAS, that multiple. So I believe the problem of NTB is not limited to EAC only, and therefore, it must be in COMESA. Most probably, it has been coming to court. Have you encountered that? And how have you been handling, as a court, matters brought to the court that deal with the non-tariff barriers?
Thank you very much. Firstly, let me appreciate Judge President for EACJ for inviting the COMESA Court of Justice to this gathering. It's a very good exchange of ideas, and we have learned a lot, particularly from Justice Kirabiro's paper about extending our jurisdiction and trying to find inherent jurisdiction, according to my colleague from ECOWAS, that the judges must use their inherent powers to find jurisdiction where it is not there. But let me confess that the COMESA Court of Justice is an outlier in this gathering, in that we have been strict to the letter of the treaty, not expanding our jurisdiction. And perhaps that's where we need to learn a bit. And Justice Rujeje, former Chief Justice of Rwanda, who was the principal judge of the COMESA Court First Instance Division, and he is the author of our locus classicus decision of Polito Pence versus government of Mauritius. He looked at how to tackle tariff barriers, but I think the principles in Polito also apply to NTBs. So we had a chance to look at this issue in 2016, when we just came on the bench. We were appointed in 2015, and there was a case from Malawi, Malawi Mobile Limited versus the regulator of licenses for mobile phones and government of the Republic of Malawi, where the investor from South Africa obtained a license to have telecom services in Malawi. And he never rolled out on time. So his license was revoked. And he claimed, the investor, that the revocation was a breach of contract by the regulator, which Judge Kirabwire, I think, tried to find aspects of litigation in a license for the judges to use their inherent powers. The investor argued breach of contract, license taken away, also argued inducing a breach of contract. A minister, attorney general, was accused of taking the license from this investor to give it to his friend. So that case went through the courts in Malawi. It went to the High Court Commercial Division, where a colleague of mine found that the applicant was successful just because the AG in Malawi did not go to defend the matter. So it was a default judgment. And the investor was awarded $65 million US, quite a hefty amount of money. But the government appealed to the Supreme Court, although not having gone to the High Court to defend. And the Supreme Court said, you investor, you as a claimant have a duty to prove your case. Although there was no defense from government, but you were supposed to bring evidence to show that you are ready to roll, you had the capacity. So Supreme Court reversed the judgment of the High Court and said no entitlement to the damages. The matter was then referred to the COMESA Court of Justice. And in the first instance division, these East African cases were argued. Fundamental principles, rule of law, good governance. And the issue arose as to whether the COMESA Court of Justice had jurisdiction in that matter. FID, following ESCJ decisions, which we discussed today, found that the COMESA Court of Justice had jurisdiction. But then there was an appeal to us, appellate division, and we reversed the FID. Our view was that the matter was a purely domestic matter about breach of contract in Malawi, inducing a tort, nothing about the treaty. So the matter ended there. And we've been attacked, we've been criticized by many people that we closed our doors to a lot of work. Well, ESCJ is getting a lot of files with their creative jurisdiction finding. We are just restricting ourselves to trade disputes. So some lady from Kenya came to my office some time back when I was in Malawi at the High Court Commercial Division as Judge President. So she was doing research on the regional integration. And she was asking me, you sat on the appellate division, which closed the doors for litigation, Malawi Mobile. Why? And so on and so forth. But anyway, we have come here and we are getting exchange of ideas. Possibly it's not too late. Maybe we missed the train in 2016, but now we have a new bench. We're having cross-fertilization. Judges from the ESCJ, some of them are now being appointed to COMESA Court of Justice. And we have one judge in our court who is doubling ESCJ and COMESA Court of Justice. So perhaps not all lost, and we will be creative in the future. But for us, our time has come up. We are finishing our mandate in June this year, and a new bench is coming. Perhaps they will look at our decision in Malawi Mobile and be expansive. Justice Rujeje was whispering to me about expanding jurisdiction after listening to Justice Kirabwire. Anyway, on NTBs, non-tariff barriers, we haven't had many of them, but I said that the principles governing the tariff barriers, which were enunciated by Justice Rujeje in Polito versus Mauritius, and also even Malawi Mobile versus Malawi government, and recently we have a case of Agilis versus Mauritius, which our FID just came from Port Louis and delivered a ruling saying that the attempt by Mauritius to impose a safeguard contrary to the rules was unlawful and violating the treaty, a barrier to trade. So, in terms of challenging non-tariff barriers, even trade barriers, the article which has been used is our Article 26 of the Commercial Court of Justice, which is similar to Article 30 of the EACJ, subject to some differences which will become apparent. So if you want to challenge the act of a government, they've imposed quotas or banning goods or roadblocks which are interfering with trade, or they have imposed sanitary measures, arguing that milk from Uganda is not fit for consumption in Kenya without proper evidence of testing and so on. Then a person can apply to the Commercial Court of Justice under Article 26 of the Commercial Treaty, which deals with reference by legal and natural persons, and this is familiar to you in your Article 30, subject to what comes later. So Article 26 says, any person who is resident in a member state may refer for determination by the court the legality of any act, regulation, directive, or decision of the council or of a member state. We call the member state, not partner state, on the grounds that such act, directive, decision, or regulation is unlawful. So in Malawi Mobile, the advocate was saying what they did by taking away the license in Malawi was unlawful. But we closed the door too early, saying there was no jurisdiction. Maybe we should have allowed the FID to hear the matter on the merits, and they could have come to the same conclusion we did. So, decision or regulation that is unlawful or an infringement of the provisions of this treaty. So you can come to the CCJ about the NTB, saying that it's unlawful or infringes the treaty in terms of free movement of goods among the member states. But then there's a proviso, which says, provided that where the matter for determination relates to any act, regulation, directive, or decision by a member state, such person shall not refer the matter for determination under this article unless he has first exhausted local remedies in the national courts or tribunals of the member states. So this is an impediment to people approaching our court, which is not there in the EACJ or ECOWAS, but it's in the treaty. So we have to apply it, to follow it. And in the Malawi Mobile case, we said that the litigant did not go to Malawi to exhaust domestic remedies. That was one of the reasons we said CCJ had no jurisdiction. But in Polito, Honorable JJ there, Polito, Mauritius has not domesticated the Commercial Treaty. So you can't go to Mauritius to argue about treaty issues. They will say, we don't know the Commercial Treaty, although they are members. They send ministers to meetings and stuff like that. And they say, we can't apply it. So in Polito, the litigant went to Mauritius and was told, we can't apply these rules from COMESA, not part of the law of Mauritius. So litigant then came to CCJ, where Justice Rujeje received them very well. and they won the case under this article. And customs duties which were imposed on goods from Egypt to Mauritius, in contravention of the agreement by member states to reduce the tariffs, those customs duties were refunded to the applicant just through judge's decision. So the NTBs can be challenged or under this provision of our treaty, Article 26. Now, the moderator asked me that members of EACJ, a lot of them are members of COMESA too, except Tanzania, which moved out of COMESA, but most of the members of EAC are members of COMESA. So which means that they have a choice to go to COMESA or EACJ. Now, if you have a human rights issue, obviously you can't come to COMESA because we don't have jurisdiction. We have said no. Until we expand our jurisdiction as per the advice of Justice Kiriabwire. So other areas you can choose to go to COMESA or EACJ. One case where there was that choice exercised is the case of Intersomac Uganda Limited versus Civil Authority Aviation of Rwanda. So both countries, the claimant from Uganda, respondent from Rwanda, but they chose to go to the COMESA Court of Justice, not the EACJ. And the moderator was asking me, is it meaning there's something wrong with the EACJ? People from East Africa choosing to go to COMESA Court of Justice, not the EACJ. And my answer would be, nothing wrong with the EACJ. Maybe it was simply a matter of choice by council where they wanted to go. I don't know the reasoning, but it turned out to be a very big mistake to go to COMESA Court of Justice because the reference was dismissed on the ground that there was failure to exhaust domestic remedies. If they had gone to EACJ would have said, welcome. What else do you want? Human rights, we'll give you. All right, so essentially, that's what I could say for now.
Thank you very much. Give him a clap. Now you've heard you have a choice. You can go to COMESA, you can go to EACJ. Now, Felician Mwamvaneza, Commissioner for Customs. We cannot talk about cross-border trade. We cannot talk about NTBs without talking about customs and borders, because that is like the epicenter where all these actions happened. In your office, where you sit, you must be experiencing a lot of this. Can we hear from you? How do you, maybe you have even an internal administrative measure of dealing with some of NTBs. How do you handle it? How do you think for going forward they should be handled? Please.
Thank you, moderator. Distinguished ladies and gentlemen, all protocols observed. Do we still have NTBs in the EAC region? The answer is yes. But do we have adequate institutional arrangements to address the NTBs that we have? I would dare say yes, even though that may sound very controversial. And I will say why I think that we do have adequate arrangements to address NTBs that arise from time to time. But before I attempt to share my ideas on these issues, allow me to share with you a story of my experience in Europe 18 years ago, a few years after I had started my career in public service. I traveled for a few months of work at the EU Parliament, and two experiences. One is when we traveled by road from Brussels to France, and we drove all the way until we arrived at our destination in France, while I was still waiting to cross customs and immigration with my passport in hand. I was told we had already arrived. The second experience is when we traveled again from Brussels to Germany by air. And I had the same experience. I discovered that the passport I was holding in my hand was no longer necessary when we got into the car from the airport heading to the conference room. But in both instances, both experiences, I never encountered any border, any migration point. But meanwhile, along the road, of course, trucks were crossing with goods, and people were crossing just like we had been. So up until that point, I had become aware that in the EAC, we do have the very famous stages of integration. Now, we are celebrating the 25 years anniversary. Now, from that experience, for me, this is about 18 years. If you asked me, have we made significant steps towards the ultimate vision and goal of integration, I do not know whether my answer would be yes. 18 years later. But before, again, I continue, let me say that when it comes to implementation of the EAC Customs Union Protocol, we have had very positive and significant achievements. That is for sure. When you see where we've come from and where we are, we have had tremendous success in that area, customs union and cross-border trade. But the challenges still remain, as I said. The answer is yes. Why is that the case? Now, one of the questions that was put to me earlier when I arrived was, what do you think would be the best way to address NTBs across the region? And do you think that the existing arrangements to address NTBs are adequate? I have just said that I think they are. But to what extent? Why do I say they are sufficient? They are sufficient within the context of the EAC law, within the framework that has been put in place. Now, we do have the legal framework, the treaty, and the protocols. We do have the institutional framework. We have different committees. We have even the Council of Ministers. We also do have the reporting mechanisms, including all electronic tools. So all these arrangements are deployed, and we see progressive achievements in addressing a number of NTBs. But why do challenges remain? Why do challenges remain? I think if I would give an answer to, or share my opinion as to why we still have NTBs, some of which last for too long without resolution, is precisely because of our legal framework, the EAC laws. we cannot address NTBs beyond the limitations that seem to have been deliberately put in place. If you read the treaty and different protocols, you find a deliberate effort to say that our integration will be progressive. Now, we do all understand why that was necessary. The progressivity is enshrined in our laws, ESC laws. You also see less emphasis on supranationality. Of course, with a lot of leaning towards preeminence of the national laws. Should we then be surprised that a number of NTBs will come up because of that framework, and that it will be difficult to address some of them because we have given a lot of leeway to national laws, to governments for understandable reasons, but this journey has become unnecessarily too long. This journey of achieving the ultimate objectives of the region and the benefits that are enshrined in the vision of our integration, because we chose that path, which has become long, not defined. How is this journey going to, how long is it going to take? It has a lot of broad principles. What do those principles mean? It remains the interpretation of partner states and whoever is trying to address issues. So for me, when it comes to addressing these issues, it's important that we recognize the limitations we have in our law. We all are familiar with the old adage that what you sow is what you reap. What you sow is what you reap. You cannot expect that we shall have the legal framework we have, and then once we have so many NTBs across the trade supply chain, then we become surprised. We should not. So I would suggest the following. One, since we are true to the ultimate vision and objectives of our integration, we should reflect on whether our legal framework aligns with that vision. Right away from the treaty to the different protocols. Number two, since rather we are serious with the benefits we want to reap from the integration, are we moving at the required speed? Or is the journey going to somehow tacitly seem to be the end? Because the journey cannot be the end. The destination should be the end. But how long is this journey going to take? But number three, can we realistically expect that we shall have it easy to address NTBs across the trade supply chain when the common market protocol is not implemented, when the monetary union is not implemented? Because there are so many obstacles in that area which we don't even discuss now. We don't discuss challenges with the payment systems. We don't discuss challenges related to a proliferation of agencies across the chain. I'll give you an example, and I don't think Rwanda was alone in this. So in 2021, we did, and there was a committee made up of different institutions in Rwanda, and they assessed the institutions on our borders. We found that we had 15 institutions at the border, because that speaks to bureaucracy and delays. 15 institutions. But the Prime Minister decided that we shall scrap most of them and only keep 3. Migration, for cross-border movement of people, customs, goods, and security for national police. And all the rest would find a way to work with those to streamline cross-border movement. Are we alone in this multiplicity of institutions that intervene in the supply chain? The answer is no. All the way from the port to the final destination, wherever that is. And it is difficult to address some of these when you haven't addressed issues of standards, common standards. And you cannot address the issues of common standards, which all these institutions that I'm talking about are there to try to serve, when you still have different laws with respect to trade and taxation and fees, because you haven't addressed the issue of the common market. And then, of course, you're going to have to bear with the challenges in the payment system and the delays it leads to, because you have not implemented the monetary union. So these are the key issues that we think we need to be talking about, because I took the liberty to interpret that statement. What are the best ways to address the NTBs in the EAC region? Reform the laws to reflect the ultimate vision of the tangible benefits to the EAC citizen, and then be deliberate about the journey that gets us there, and then again try to implement the remaining instruments that also result into a range of NTBs. But as to what we have, yes, then a practical question would be what the Honorable was saying. We can do awareness raising, so that the business community becomes aware of what is available, what the resolution mechanisms in place are. Because I believe most of them do not know that there is the Court of Justice, there's what I talked about in terms of how do you report and to whom and when. These things need to be taken into consideration. Thank you so much.
Let's give him a clap for that insight. Thank you very much. Thank you very much. Benedict Msengele, the Director of Trade and Customs, Trademark East Africa. Trademark East Africa is always associated with EAC, particularly when it comes to improving our borders, our weighbridge, and seamless movement of goods. Now, from your position, and with all the efforts you're putting to try and have a seamless movement of goods in East Africa, do you think there's a problem? And how do you think it can be solved?
Thank you. Thank you, moderator. Yes, it's true. Trademark Africa, which was formerly known as Trademark East Africa, has been associated with the EAC since 2010. And if you recall the history of EAC, by 2010 is when EAC was supposed to have a fully fledged customs union. By then, that did not happen, and Trademark was formed with the aim of reducing cost and time to trade within the EAC and improving business competitiveness. One of the first assignments was to do a study and see how we could have a fully fledged customs union in EAC. And by 2013, it was agreed that EAC was to adopt the destination model as a temporary measure before moving to a fully fledged customs union. Since 2014, when the destination model of the single customs territory began implementation, up to today, we are still implementing the same destination model. whereby clearance happens at the point of entry and payment of duties at the destination. Moderator, as you've mentioned, in addition to this, we supported ESC to build many one-stop border posts. I think by now we have 15 of them operational, and the Ngoli Maangi will make it the 16th. And when they were being built, they were built to serve the needs by that time. But since then, trade volumes have grown. And maintenance of some of those OSBPs have deteriorated. The number of frameworks which were set, some are operating efficiently, others are not. And therefore, there is need to relook at some of the interventions which were done by then and ask ourselves, in order to fully address the non-tariff barriers within ESC, what do we need to do? And picking from where the Commissioner Customs have stopped, when you look at the NTB's Act of 2017, it categorizes on what is referred to as NTBs within the ESC. If you ask me whether that classification is exhaustive, I would say no. Because when you look at the WTO classification of NTBs, anything which is not a tariff is classified as an NTB. But when we look at the aspects of the ESC, anything which is within the national legislation or policy is not defined as an NTB because it's governed by the national law or a policy. And therefore, we need to look at what supersedes each other, the national law or the regional law. And then if we have to fully address non-tariff barriers, then we have to address them holistically. If you look at the time-bound program for the ESC, by now we have only 11 outstanding NTBs. The resolution rate of NTBs within ESC is above 90%. And on average, it takes now, as per end of last year, around 88 days to resolve an NTB. But the intra-ESC trade has remained low and mostly constant at 15%. So are the NTBs which we are addressing the ones which are entering intra-ESC trade? And to me, I would say no, because there are many other trade barriers which are not addressed as per the provisions of the NTB's Elimination Act of 2017, which needs to be addressed. And if we were to move from the fragmented implementation of the customs union and we move to implementation of a fully fledged customs union, where we have free circulation of goods and services once they enter the single customs territory, then we will be eliminating most of the trade barriers. And one way to move forward to that is to start thinning our borders. And how can we thin our borders? We can thin our borders by ensuring most of the clearance and verification activities happening at the internal borders within the single customs territory happen before the border. And then we start moving to the no-stop border, where no clearances is happening within the borders. ESC tried to do that through the Authorized Economic Operator Scheme, but this scheme only takes care of customs matters. Other agencies, like the ones dealing with SPS and standards, are not part of that Authorized Economic Operator Scheme. And once the goods reach the border, therefore, they will have to stop, they will have to be verified, and they can take many days at the border. And therefore, we have to look at our regional versus national interests and move towards implementing a fully fledged customs union. I'm aware late last year, the commissioners of customs agreed on a blueprint towards operationalization of that, which is supposed to take around 2.5 years. But this will require adequate political goodwill, because most of the NTBs which are entering intra-ESC trade are championed and lobbied for by the private sector within the national territories. And therefore, if measures could be taken to sensitize our private sector to know that there is a bigger good if we are to eliminate trade barriers and stop protection at national level, then we'll be moving towards the right direction. And again, when we address these trade barriers, we need to ask ourselves, removing all of them, will it increase intra-ESC trade? Again, when you look at what ESC trades, all the exports within Africa, 50% are among ESC partner states. And therefore, the issues of addressing our productive capacities becomes critical if we need to increase our intra-ESC trade. And therefore, Trademark, in its third strategy, plans to support ESC and other regional economic communities to address trade barriers along 3 spectrums. 1, trade in services barriers, because goods move through services. So we should not focus only in addressing trade barriers on goods, but also trade barriers in services. In addition, most of the investments we attract within our region are for export production purposes. And therefore, we have also to facilitate investments and therefore address also the barriers which are there in terms of investments. If we couple addressing barriers in the 3 areas and make East Africa community a single customs territory, then we will start realizing the benefits of regional integration. But if we continue implementing all these stages of regional integration in a fragmented matter, addressing trade barriers alone will not change the current status of intra-ESC trade. Thank you.
Thank you very much. A big clap for him. Has also given us a lot of hope. Now, my last discussant, Jane Nalunga. You had an organization that has a lot of data, a lot of information, and a lot of statistics on cross-border trade and the challenges that go with it. Now, this data and all this information, what is it talking to? What is it telling us? Could you please tell us something about that?
Okay. Thank you so much, Mr. Okubo, for giving me the floor. And I would also like to thank Honorable Justice Faustine for a very good paper, very excellent paper on NTBs. I would also like to thank the organizers of this conference for giving me the opportunity to be here. I'm from the trade fraternity, but I have learned a lot from the legal fraternity, although sometimes the language was almost like Latin. But I think we need a lot of conversation between the legal and the trade fraternity. Now, regarding the issue of NTBs, because the NTBs, as has been pointed out by the previous speakers, they are reducing because there are a number of mechanisms to address them, but they're also in a way increasing because also they are reporting frameworks. But I think what's really important when we are talking about NTBs is the fact that it's a perennial problem. They are a recurrent future. Today it's about maize, another day it's about milk, another day they are roadblocks. So we need to address that, not the numbers really. And I think the persistence of the NTBs raises the question whether what we have in place, the mechanisms and the legal frameworks to address them, whether they are really, really working. But I think before I look at what needs to be done, I think I want to underscore the importance of addressing NTBs. NTBs affect our trade, you know. They affect our trade. They affect investors. Anybody can't invest in a community where it's unpredictable, where anything can happen. Today you are taking milk somewhere, tomorrow they are telling you don't bring the milk. So it's important to address them. And they also affect everybody across the value chain. When a country stops maize, for example, it affects the entire value chain from the small-scale producers. So it's important that we address the NTBs. And I wanted to add on to the issues which have been raised here on the way forward on how to address the NTBs. Honorable Denk, my sister there, has raised the issue of awareness. And this issue has been raised a number of times, that we need to give people information. There is an assumption that people know what's happening. People don't know what's happening. All stakeholders should be provided information. We are working with Trademark Africa on the maize value chain, on the borders of Eregu border. And it's incredible that people don't know the standard, yet they are dealing in maize, you know, the maize standard. So providing information, building capacity is very, very important. We also talked to a number of people at the border posts, and what we found out was that even customs officials were not aware of the protocols, the customs union protocol. They were not aware of the simplified trade regime. But even the cross-border people themselves were not aware. So I think it's important to build the capacity to provide information. Yesterday, again, there was an issue which was raised about explaining the benefits accruing from, in fact, the gentleman, that Benedict has also raised that issue, you know, looking at the bigger good. What's the bigger good? We need also to provide people with benefits accruing. Even if you make a decision as a legal fraternity that an act is unlawful, it's infringing on a certain provision of the treaty, I think it's also important to show them that if you if you implement, you know, that law properly, there is a bigger good. The issue of changes in some amendments in the law has also been addressed a number of times here, especially the cap of 2 months. I just wanted to refer back to the case which has also been referred here, which also Honorable Justice Faustin has also raised, the case of Kalali Stephen about the border closure. What's interesting is that my organization, together with other organizations, we lodged a public interest litigation case regarding the border closure between Rwanda and Uganda on behalf of the women cross-border traders at Katuna. But our case was not considered. It was determined on the fact that we had logged in after 30 days. So it was dismissed on those grounds. But for the 30 days, we're looking for, you know, collecting evidence from the women cross-border traders. So I think it's really important, and I want to add my voice to the call to address such anomalies. But what I also saw in this case, that the Kalari and Kalari Stevens case was determined after about 3 years. That's also, I said, wow, 3 years and you are waiting for a decision. So I think those are some of the issues which need to be addressed. But talking about cross-border traders, a significant proportion of our cross-border trade is undertaken by informal cross-border traders. And we see them at Elegu, Katuna border, and all these borders. And there is a lot of injustice. So many NTBs there. You know, I have talked about the trade regime, the simplified trade regime. Some officials know, but they take advantage of the cross-border traders. So I think when we are looking at a legal regime which can help, we need to be able to see whether it can be able to work for the women. I was reading somewhere about the small claims procedure. Is it possible also to have a small claims procedure for cross-border informal traders? Because at the borders, that's where the remedies are really needed. The issue of the Trade Remedies Committee has been, I had it here, I just want to add my voice there, that we need it. If we are to do serious trade in the region, we need a dispute settlement mechanism. And I think here, I want us to learn from the WTO, the World Trade Organization, their dispute settlement mechanism. The World Trade Organization is referred to as an organization which has teeth, that when you compare to all other international organizations, that it has teeth, it can be able to bite. And the biting is because of its dispute settlement mechanism, you know. And I think we need to learn from that mechanism because it has a specialized dispute settlement committee with a very specialized trade specialist in trade and law. And I think this is what we need. We need lawyers who are also specialists in trade to be able to handle these trade disputes. Why am I saying we need trade specialists who are also competent in law? Because the trade landscape is so dynamic, very, very dynamic. Yesterday, there is somebody who raised the issue of digitalization. Our economy is becoming more and more digitalized. We are talking about e-commerce. But again, our economy is going green because of climate change. We are talking about green transition, green industrialization. And also, we're also talking about human rights and environmental rights. As East African countries, we are part of the UN Binding Treaty on Business and Human Rights. So all those issues are implicated in the way we do our businesses. So that committee, whether we go back to the Trade Remedies Committee or whether we form another mechanism under the East African Court of Justice, but we need a separate committee to address that. And I think it's important that such a mechanism, which is specialized, will ensure timely disposal of disputes, but also effective remedies. I want to refer back to the issue which Honorable Chiriowa you raised, that there must be consequences for doing wrong things. And I think you have been depending so much on the goodwill of the partner states. I saw one time our presidents had to meet, the president of Uganda and Kenya, to talk about the NTBs. Goodwill is not part of the balance sheet, you know? So we need to have a cost when it comes to NTBs. And for me, I think that two pillars of an effective trade dispute settlement is about timely disposal of the dispute and an effective remedy, a remedy which can be enforced. And that goes back to what I said about the WTO, that it has teeth. You know, in the WTO, you take a case there, even if it's a country like Uganda against the US, you get a remedy, and in timely. So I think if we are to look at addressing NTBs, but also ensuring a smooth flow of trade, you know, we need to have a dispute settlement mechanism which is effective. I think I will stop there. Thank you very much.
Thank you very much. I think this committee has really kept you awake, and I was observing almost nobody was dozing. Nobody was dozing. Let's give them a clap again. So now I need to open the floor. Questions, comments, additions, subtractions, contradictions. You're welcome. Are we okay? Oh, let's give them a clap then. Okay, there's one there. Sorry.
Thank you very much, Chair, for allowing me the floor. This is Don Dare from the Pan-African Lawyers Union. Much as they say that to a person with a hammer, every problem is a nail, and therefore, to a lot of the legal professional-oriented people in this room, we tend to gravitate rather quickly to the recommendation that the problems that we have can only be resolved by more law, more amendments to the treaty, more provisions in the protocol, more regulations, and so on. I'd like us to stop and really think of, and the Honorable Justice Kathurima Mtwinoti touched on this in the morning, Pacta sunt servanda, implementing the provisions of an agreement that you have agreed upon in good faith. If we implemented what we had agreed upon in good faith, would we really need so much law? Additional laws to tell you what you meant, if you meant it in good faith? So some amendments certainly are necessary, but how many of these are really necessary? Which brings me to the question of posture. And I'd say that as Pan-Africanists, and that's what the Global Pan-African Congresses were good for, as Pan-Africanists, each of us step outside of our title, our portfolio, our honorableness, our His Excellency, and become ordinary Africans sitting round the oak tree or the mugumo tree, talking as individuals, and tell ourselves, if we did that posture, how many problems would it solve? Because having titles and having offices and so on is leading to a block, an inability to have a solidarity with each other as human beings and to solve our problems practically. As somebody who has followed the EAC closely, I was an activist under the NGO Coalition for East Africa, NGOSEA, from 1996, when we were engaging governments on the text of the 1999 treaty. By 1999, I was working for LSK and part of the LSK contingent to the conclusion of the treaty process and its implementation. And in 2002, I arrived in Arusha to do our part, the citizen part in implementation. So we have been there throughout. If you attended a sectoral council meeting in 2005 and went away and came back, and 20 years later, in 2025, you're attending the same sectoral council meeting, what would you notice that would be different in the attitude of the role players, in the posture of the role players, in their approach to whether we need to speed things up or slow things down? A huge thing has happened there. A huge thing has happened there. You go to the meetings there now, there's hostility, there's arrogance, there's use of very undiplomatic language. There's this approach that me and my delegation have come here to defend ourselves and to only agree on things that we think are beneficial to us in the short term, rather than the brotherly, sisterly approach we had with the first cohort, that were like, we are brothers and sisters. It was wrong that we divorced or that we separated. It is good we have reunited, and we need to rush to catch up on lost time. That is missing. And that's a posture issue. That will not be resolved by more law. It will be resolved by a change of attitude. Now, when we come to this question of sovereignty / political will, that we are lacking political will to move on A, B, C, D. Again, I would like us to disaggregate it down to, within the partner states, which ministry is the problem, which department is the problem, which section is the problem, and sometimes which individual is the problem. Because sometimes there are problems that are created by individuals, either out of ignorance or malice or a sense of hurt or a need to revenge against your counterpart. Then the entire state is blamed for it. And one other thing we need to look at is one of the evolutions of the EAC over the last 25 years, especially the last 10 years, is this informal amassing of massive power in the middle bureaucracy of our countries. A lot of power has informally over time been amassed by our mid-level bureaucrats. So they are the ones that now decide. And sometimes even the heads of state can decide on something clearly, and they veto it in implementation. Who gave this power to these unelected people? Who are they accountable to? Who are they accountable to? We have elected officials. If my minister says ABCD, she's been elected or has been directly appointed to a political position by a person who was elected, leave alone the quality of elections, but they exercise legitimate political power drawing from the people. So when they decide, they decide. They need layers of bureaucrats to help them. But we've ended up with a system now where at technical officers level, not even at permanent secretaries level, at technical officers level, we have some of the most amazing debates and decisions. And then they say, and there's nothing you can do. I can veto my president. As a people, as Pan-Africanists, remember that the last two known global Pan-African conferences were held on our territory. 1974 in Dar es Salaam, 1994 in Kampala. Let's go back to being Pan-Africanists. Remember that we are racing against time in a very hostile world that wants to finish us. And we need to be fast-tracking things, not slowing things, especially based on the small egos, small fragile egos of unelected middle-class bureaucrats. Thank you.
Thank you very much. Mheshimiwa, you want to comment on that?
Thank you.
After her, we'll come to you, Mheshimiwa.
I think it's not working. Okay. The previous speaker, I really have to thank you for bringing up this issue of us being bogged down with so much information that we actually are blinded, that the solutions are already within what we have. And I'll just take the simple example, again, coming back to the Trade Remedy Committee. Something that requires an amendment of only 2 lines. How can we explain that it has to take more than 15 years? Something definitely is not right. For me, I think what we are suffering from is analysis paralysis. We are so paralyzed with all the information. One thing EAC is fantastic about is collecting information, analyzing, presenting recommendation. Even the Common Market Protocol, it's a voluminous document. It's huge. And I bet you, even the implementers of the articles there are not aware of the depth of the information and the fact that we have not even implemented it. The gentleman from Trademark was saying, we need to get away from this fragmented way of implementing our laws, because there is so much quagmire that the solution is right in the middle, and we are just leaving it aside, but we want to do other committees to address an issue that has already been related to. So I think there is a need to go back to the drawing table and really look, what kind of integration are we looking at? What are the protocols, the documentation, everything that we have already talked about, addressed, and put recommendation, and try to implement it instead of reinventing the wheel. Because it is like you move 2 steps and then take 5 steps. Of course, we have achieved a lot, as my brother said earlier. It's not the same like 10 years ago. Goods can move, of course, much faster. Documentation can be addressed much faster, but there is a huge gap not only from the implementers, but even the fraternity and even the stakeholders. How much do they really know? Even for us as members of parliament, this opportunity actually to attend this conference, there's a lot of things that I didn't know about the court. And I am a legislator. So what would you say about the common person outside? So there's definitely a need to go back to the drawing table and address things from the very beginning, look at what we already have and use that to implement so that we can get the integration going. Thank you.
Thank you for that comment. There.
Thank you very much, moderator. I just wanted to build on what my colleague is talking about regarding the implementation of recommendation from the work of the Assembly. I may say that the report she was alluding to on the Trade Remedies Committee was debated and passed by the Assembly in 2020. And when you go through the report and see the recommendation that was adopted by the Assembly, was clearly and timely oriented. I may give you one of the example. The first recommendation said, the Assembly to urge the Council of Ministers to urge the partner states to conclude the process of ratification of Article 24(2)A of the Protocol on the establishment of the East African Customs Union and deposit instrument of ratification with the Secretary General by 28th February 2020. That was timely clear that the Secretary General was able to follow up and make sure that that recommendation will be implemented by the February 2020. So I'm glad that today we are with the Council of Ministers, we are with the SG office, and we are all together here. And if the SG could now follow up and see what is now going on, why partner states have not been able to implement, what is the problem, so that we can resolve and be able to perform well and to let this community move forward. Thank you very much.
Thank you very much, 2020, and now we are in 2025. Nothing has moved on. I'm sure you know where to follow it up. There being no other questions, thank you very much for being patient with my very well-grounded team. Let's give them that clap. We said 1, 2, Funga. Thank you very much, but Funga doesn't mean 3, eh? Something.
Thank you very much. Mr. Yifnali Sokubo for excellent moderation, retired Chief Justice Nezidiayo for a good presentation, and all the panelists for your contribution. The mode of operation today is working coffees so that people have time to go and integrate. We did not come to Kigali only to attend the conference, but to also see what Kigali has to offer. So with that, I would like to invite the session chair and presenter for session 8, Ms. Akrit Karel from UNESCO, to please come forward. I'd like to invite Honorable Lady Justice Aisha Naluze from the Judiciary of Uganda to please come forward. Ms. Stella Murungi from the Ministry of Justice, Republic of Rwanda, kindly come to the podium. Ms. Florence Ogonjo from Strathmore University, kindly come forward. And Mr. Eric Shirimpumu from the Institute of Law and Development in Nyanza. He's the Vice Rector in charge of Administration and Finance. I would like to draw your attention to page 15 of the program that gets into detail on the bios of our panelists. The only bio that is missing is that of Honorable Justice Aisha Naluze. As I did mention, she's a judge of the High Court of the Republic of Uganda. And as she contributes to this panel discussion, we'll be able to get a bit of insight on her work. I would like to also give special mention to the sponsor of this panel, UNESCO, and we are grateful for your support. So with that, I'll hand over this to you, Akriti.
Thank you, Christine. Can you please show my slide? Yes, thank you. Good afternoon, dear respected honorable justices and respected delegates. I am Akriti Karel, Communication and Information Specialist at UNESCO Regional Office for Eastern Africa. To set the context of this session, I would like to give a brief presentation on UNESCO's global program on AI and rule of law. So why AI and rule of law? So in this time of rapid digitalization and emerging technologies like artificial intelligence, courts today are facing growing challenges such as AI-related threats, online disinformation, hate speech, and cybercrime, among others. Many courts also struggle with a large backlog of cases, causing delays in justice for people waiting to hear further verdicts, often leading to delayed justice. So we all know that justice delayed is justice denied, which is also a human right issue. To address this issue, UNESCO developed a Judges Initiative program that specializes on international training to strengthen the legal system. This training helps judicial actors understand how human rights apply to digital issues and ensures the responsible use of AI in justice system. UNESCO supports judges, lawyers, and legal professionals in understanding the impact of AI on human rights through international and regional frameworks. So our approaches includes conducting in-person training sessions, national and regional level trainings, providing free online courses for legal professionals and civil society. UNESCO acts through raising awareness, standard setting, capacity building, policy advice, and international cooperation. UNESCO has established different MOUs with regional courts, prosecutors, and networks, including East Africa Court of Justice, African Court on Human Rights, People Rights, ECOWAS Court of Justice, and others. So these partnerships strengthen judicial training credibility, best practice exchanges on freedom of expression, access to public information, and journalist safety. In November 2020, UNESCO surveyed 1,265 judicial operators from 100 countries to identify the key areas of AI and rule of law that training needs. And key findings Sorry. Key findings showed that judicial operators had strong interest in understanding AI systems and their legal implications, recognized the need for specialized legal training on AI, and judicial operators were both interested in AI as an assistive tool in legal systems and also broader societal impact. So following this survey, UNESCO conducted another survey in 2023. We surveyed over 500 judicial actors from 96 countries on the use of AI in judicial system. And the key areas that were surveyed were use of AI in judicial system, perceived risk, institutional guidelines, trainings, and need for regulations. The survey showed that 44% of respondents used ChatGPT and AI chatbots for work-related activities. And judicial operators stated that they use ChatGPTs and AI tools mainly for 43% for searching, 28% for document drafting, 14% for brainstorming, and 5% said explaining context. So, yes. And responses identified risk associated with AI chatbot use in legal context. 27% said quality of the output, 18% said data protection, and 18% also said copyright issues. So 9%, so this is quite interesting. Only 9% of judicial operators said that they have received training or have institutional guidelines in place. And 92% of the respondents called for a UNESCO guideline on AI use. So now we are aware that AI is transforming the judiciary by improving case management and decision making, but the lack of global regulations raises concerns about fairness and accuracy. And the EU AI Act emphasizes that a unified framework is needed, as some countries have their own guidelines while some do not. So a unified framework is needed to prevent risk and biases posed by AI. Following this, the UNESCO developed the guidelines of AI in judiciary, and this guideline is also a follow-up on UNESCO's recommendation on ethics of artificial intelligence, which is a comprehensive blueprint for building regulatory system on the values and principles of human rights adopted by UNESCO's 103 member states in November 2021. So there are three main components of the AI and judiciary guidelines, and the first one is a principle of the AI system. And these principles are guided by human rights aspect. There are 11 principles, as you can see: safety, information security, protection of human rights, and others. And second is the institutional level guidance. So this talks about the quality assurance, testing of the AI system before its deployment, risk management systems, cybersecurity, performance evaluation, and access to capacity development. And the third one is the individual level guidance. This is applicable mainly to computer operators, staff of judiciary, as it focuses on capacity development on using the AI system, such as AI awareness, AI literacy, verification of output provided by AI system, among others. So I'm just going to go through the slides. These are some of the activities and publications that UNESCO has conducted in the AI and Rule of Law program. We have held webinars, national level and international trainings, and we also have MOOCs and have published publications. So this is from the MOOC. These are some of our webinars. And this is from a national, regional, and global training. And that's it. Thank you for the presentation. Oh, my. Okay. So I will now straight away go into the panel discussion. And to start my panel, I would like to first direct my question to Lady Justice to understand the role of AI in judicial efficiency and fairness. So, yes, Lady Justice, from your judicial experience, how can AI-powered tools be most effectively used to enhance judicial efficiency and decision-making in East Africa? And what practical ethical guidelines and safeguards are needed to ensure that AI in Eastern African courts promotes fairness, protects human rights, and improves access to justice for equitable regional development?
Okay, thank you. Thank you very much, Madam Moderator, Presenter. Since we are running out of time, I'll also be very fast like the presenter. Yeah, AI is very important for the improvement of access to justice and the legal processes, the judicial processes. So AI has been incorporated in most of the judicial systems into the existing technologies already in place. For instance, in Uganda, we have the ICMIS system, that is the electronic court case management system. I understand in Kigali, they have the integrated court case management system. So AI has been incorporated in the judicial system to help in the case management process, the e-filing, the case distribution, and case processing. So, yeah, we have a number of countries as well that have incorporated AI in their system. For instance, Tanzania, it uses an AI system that is used to transcribe and translate texts, which helps in the administration of the justice system. So to answer your question, what can be done to make the power tools, the AI tools? These tools include so many information AI tools like the ChatGPT, we have the Gemini, and the most recent being the DeepSeek, which is still facing a lot of resistance from so many countries because of its data challenges. And as of Monday, Elon Musk announced he was introducing the best AI system in the world. So I don't know if it actually happened on Monday. I'm yet to find out. So for us to improve on these AI tools, we need to enact policies for the usage and applicability of these AI tools for the judicial officers. Applicability in a sense that the AI has a challenge with the issues of transparency and fairness. So we need policies in place to help mitigate the issues of transparency and fairness. And then another issue would be the subjecting judicial officers to continuous training in the AI tools. Yeah, a lot of capacity building programs need to be put in place to help the judicial officers know the applicability and the use of the AI tools. And then we also need to focus on the AI tools online courses. There are so many of them online from the European Council. So if we could take advantage of this, it is going to help improve our understanding and applicability of the AI tools in the judicial system across the East African region. And then we need to create a mechanism of information sharing. For instance, like this gathering today, we need to do a lot of benchmarking from our colleagues who have really implemented AI, like Tanzania. Yeah, so a lot of networking, information sharing, and networking, which is going to encourage a lot of collaboration among the East African community in regards to implementation of the AI tools. Yeah, so to answer the question of the ethical safeguards
of these AI tools, we need to establish clear guidelines to ensure accountability of the AI tools. There are no clear guidelines because we are relying on the AI to do most of this work. For instance, the research, some countries have gone ahead to also use AI. For instance, Morocco uses AI to analyze evidence and then predict a sentence that is going to be passed. So we need a lot of accountability policies to be put in place to be able to minimize on this issue. And then the issue of privacy and information confidentiality is very important, ethical safeguard when using AI tools. There's a challenge of, in case of a judge who's handling the matter, there could be a challenge of profiling a judge. And then there could be a problem of personal information going out. That is most of the challenge that is being faced in regards to implementation of the DeepSeek AI system, where a lot of countries are scared and asking how are we going to safeguard our documents, our information. So countries like South Korea, Italy, and France have really challenged the implementation of this AI system. So it is still under scrutiny. So another issue would be developing systems that provide clear and understandable explanations. Most of the AI tools are not actually accurate, like they don't reflect reasoning. Because you feed in information, the system analyzes and comes up with either a verdict or gives evidence analysis. For instance, the ChatGPT and the Gemini, you just feed in and it gives you a host of information. So it is up to you to sieve out and see what is important for applicability. So it is very important to ensure that systems are in place to minimize this. And then ensuring that AI systems are designed to minimize biases in decision making. For instance, there is a bias in regards to gender and racial discrimination. For instance, there's a case that happened in the US. A pregnant black woman was arrested based on the description that was given through the AI system. So most of the AI systems use historical information. So if you chip in and enter a search and say, give me a description of a thief, they would bring only black people. So that is a bit biasing. So it is very important to minimize reliance on this because of that historical data. Then another issue would be to regulate, to have regular auditing and vigilance of these AI model tools. Through maybe the civil society organization and the academia, we should constantly check these tools to ensure they are still applicable if anything has changed. So the question I would leave you with is, are the robots already judges? Are they ready to judge? So judicial officers should be cautious when applying AI tools, taking into consideration the procedural laws and the facts of the case. Otherwise, the procedures would be ousted if we really rely on AI as is. Thank you very much.
Thank you, Lady Justice. So thank you for your insightful feedback. It seems like we're still at basic level and there's so much to do. So with this, I move to Mr. Eric. So Mr. Eric, how can legal education in East Africa be adapted to equip future legal professionals with the necessary understanding of AI and its ethical implications for the region's development, also including teaching methods that cultivate critical thinking about AI to ensure its alignment is with justice and fairness?
Thank you so much, moderator, for the question. As you mentioned in the presentation, AI is changing legal practice worldwide, and I think East Africa is not an exception. So much the AI helps, and the AI tools can help in doing legal research, doing contract automation and dispute resolution. It is very important that legal professionals knows that these tools, the AI tools have opportunities, but also have ethical challenges or ethical issues. So in that regard, legal education should intervene and provide, equip lawyers with knowledge and skills that need to navigate legal, ethical, and regulatory landscape. So to achieve this, it is important, or it is actually a must, if you look at the trend, that it is important to integrate AI and law into the curricula. Days are gone when we could teach laws and focus on law courses, but omit these new technologies or these tools that are embedded in AI. So it is important that we start, as we teach law courses, we also include the AI skills so that our legal professionals can get that technology that will help them. It is also important for legal education to provide practical AI trainings. The AI tools are today, what is here, what we know today may not be the one that will be tomorrow. So it is important that in the legal education we involve the practical trainings on AI so that our legal professionals get exposed to this AI and see and get hands-on on them. It is also important for legal education to emphasize on ethical and regulatory issues. The training should focus on AI bias, data privacy, accountability, and ensure legal practice. For example, you are doing a research, and then maybe you are looking you are doing a research on law cases. Then you give an order to the AI to look for a similar case, and it brings you information. So, who is the owner of that information? Is it AI that has produced that? So, that AI has been constructed or built by an IT, but for a legal profession to use it, it needs to get an understanding of how it is being done. It is also, the legal education also should support AI policy and regulatory development, because the AI, as I said, it is being produced by IT, but the regulatory will be done by the legal professionals. So for them to be able to regulate them, they need to get that deeper understanding of the AI and what they produce. So by that, by those few examples, it shows that nowadays and for the future, there is no way we can go away without integrating AI into our teachings. If we don't do that, then we are not producing the legal professionals that the legal market needs. If I give you an example, it's when I was attending a course on AI in Nairobi, I think in last November,
they introduced to us ChatGPT, is it? And at the end of it was a 3-day course. At the end of the training, I put in the AI to produce a report of the training I attended. Simply give an order, could you provide a report of a training on AI that held in Nairobi from this date to this. In less than 5 seconds, I had a report. The work I did was to put a signature, but it had done so. If I had to do it by myself, probably it could have taken me 1 hour or even more. But I had my report in less than 5 seconds. So the same, if you look at, I'm not a lawyer, but I assume, I know that judges, when they are making the judgment, when they are using a case law, they may read even 5 case law or even more. So I would expect that it would take someone like a week or more than, or even more, to read all those case laws. But with AI, you just order, you put what you want to put, and then it reads everything and brings you the summary. Your work remains to read and go through the summary it has given you, saying in the case of this and this, they did this. In the case that happened in France, they did this. So if you don't do that, then we will not be producing the legal professionals that the market needs. And there is a saying that someone said that it is not AI that is going to replace the lawyers. Instead, it is lawyers who use AI who are going to replace those who don't use AI. And it is clear, if I would go to my lawyer and maybe give him a case and say that will take a week to analyze it, when I could go to another and say, okay, give me 5 minutes, I come and tell you what is there, I would prefer to go to that one. So that's why we can't go away from the AI. And in addition to that, we need to produce the professionals that the legal market needs. If I go to the second question, well, which says what the approach that could be used, the approach to cultivate the critical thinking about AI, the approach that could be used, I would say in one word that they are hands-on. I mean, they will be to teach to teach the AI. We need legal education needs to use the case-based learning, where, because as the justice said, sometimes they may come up with bias. So by looking at some cases that have been have been done using the AI, we can see where the bias is coming from. There is also the approach that legal education should apply another one would be to apply Socrates questioning. I mean, encouraging structured debate on AI liabilities and ethical concerns. We need also to promote interdisciplinary collaboration. Legal education is being taught by lawyers, but in this time we need also the people from the IT or the developers of AI to be part of the teachers in this domain, so that we don't intend that lawyers are going to develop the AI, but we want to know if the AI is producing this, what is it behind? It is very important that the lawyer also understands that. Because as we said above, the developers will develop AI, but the lawyers will need to set up regulation about the AI. So they need to, for them to be able to do that, they need to have that deeper understanding. We also need to consider the incorporation of simulated scenario, AI scenario, that is use mock-up trials, AI-driven legal exercise to test the technical dilemmas, to enable legal professionals to identify ethical dilemma, test IT limitation, and develop safeguards to prevent injustice. We need also to focus on the ethical and the policy-oriented learning to teach our legal professionals IT governance, transparency, and the accountability. So, in brief, I would say that the legal professional, the legal education needs to embrace the teaching of AI and integrate into the normal curricula it used to serve, because in nowadays and the future, the normal curricula will not be enough for someone to work professionally if he doesn't have these advanced technologies. That's what I can say on the question you asked. Thank you.
Thank you, Eric. And also for suggesting that AI can be our bench assistant. Thank you for your valuable feedback. So we've heard from the court, we've heard from the education institution. Now I move to my third panel, Ms. Florence, and would like to understand the legal and ethical balance of AI-driven justice. So my question to Ms. Florence is, how can East Africa balance AI innovation in the justice sector with ethical development and rights protection? And what are the key challenges in ensuring accountability for AI-driven decision in judicial processes?
Thank you. Oh, thank you so much for the question. As this futuristic panel has been given an opportunity to almost close the day out, it is my hope and humble request that you justices and those in the legal profession will aid me in answering this question to an extent, and also that I will give you an opportunity to stretch in answering this question. So I have 4 key scenarios where AI ethics comes in as a point of question in these different scenarios. So I will give you the scenario. I will ask you whether you think that scenario is true or false, as is in your nature as judges to determine things. And your exercise to stretch will depend on which hand you decide to use. You can use your left hand, you can use your right hand. So by unanimous decision, we will see whether any of these ethical situations or scenarios actually exist or whether they are true or false. Also in keeping with the fact that AI, when you use AI, sometimes it's accurate, sometimes it's inaccurate. So the first scenario relates more to the side of the bar. So the scenario is that a legal attorney decides that in their submissions, they will use 10 cases to justify their position. And in 9 out of those 10 cases, all 9 don't exist completely. But then the advocate still submitted them before the judge. So, is this a scenario that you would say is true or false? Show of hands. True or false? True? Okay. False? How many of you think it's false? Okay. About 3 or 4. All right, the second scenario. A judge decides that in a case, this was a sensitive case, it was a case of assault, and because he was a bit tied on how to respond in this judgment, decides to ask ChatGPT to define what consent is. ChatGPT gave the response, and he decided to include that response in the judgment. So is this a scenario that would be true or false? For true? Okay, false? Okay, I'm hearing a lot of falses and also majority hands say false. Third scenario, a judge in a case that was seeking stay of imprisonment during a trial, this was a criminal case, decides that his hands are tied and he's not sure what the judgment should be, and decides to ask ChatGPT what to do and also give him references for cases that would help him justify his judgment. Is this a scenario that is true or false? For true? Okay, none. For false? I'm hearing falses again and majority false. So the last scenario, a judge again, in a case for an autistic boy, it's on a medical funding case, also again decides that his hands are a bit tied, and because this is a new area or case for him, he's not sure what the judgment should be. So decides to also ask ChatGPT what the judgment should be, having given ChatGPT the evidence that was laid out by both cases. So in this scenario, is this kind of scenario true or false? For true? One true. For false? Okay, majority false. So I've seen about 3 or 4 truths. So out of all these 4 scenarios, tell me, do you think any of them has ever happened in the continent of Africa? Yes? I've seen one yes, no? I've seen a no and majority no's. So, astoundingly, all these cases are factual cases. They have happened. So the first case that we had was actually a case from South Africa, where a legal attorney submitted 10 cases. 9 out of the 10 cases didn't exist. The case is the case of Mavulanda versus ME Department and Cooperative Government and Traditional Affairs. Recent case, January 2025. The second one, on the definition of consent, was also true. A judge in Pakistan actually decided to ask ChatGPT in the case of Abdul Muazi versus State about the definition of consent, and he included it in the judgment. The third case was also true, a case in India. The Punjab Court of Haryana, the Punjab High Court of Haryana decided that to ask ChatGPT, where the judge Anup decided to seek counsel from ChatGPT on the latest update on exhibits of human-level performance on various performance, professional, academic benchmarks in trying to decide on the stay of imprisonment during a trial. The third one on autism was also true in Colombia by a judge, Juan Manuel Padilla. So as you can see, in these instances, elements of ethics come up, not just AI ethics per se, if you look at it, but also in considering it within your own context of the code for judges for ethics that come up. In terms of impartiality, in terms of fairness, those elements that clearly come out. Those principles established for the code of conduct for judges similarly apply when you're using artificial intelligence or in considering AI ethics. Because in and of themselves, they transfer to one another. Because ultimately, AI is a tool and remains a tool that is meant to be used for the benefit of human beings. But how it is used sometimes depends on who uses it and how it's used. Now, for all these instances, it is merely because we cannot ignore the fact that AI is being leveraged in different sectors, and particularly within the judiciary. Because truthfully speaking, it does aid and it does help in case management, in narrowing down legal research. It helps in those significant areas. And to a certain extent, for those who are slightly more ambitious, it helps with things like predictive analysis, though that also has its own ramifications and problems and is yet to be fine-tuned. So technology will continue to evolve and won't necessarily wait for us to catch up, either in terms of policy, in terms of regulation, in terms of how we internally use it within our different sectors. So with that, AI ethics plays a significant role in establishing different legal key elements, especially in attribution of responsibility. When you decide to leverage ChatGPT for a judgment, for example, who bears the responsibility or the outcome? Is it your outcome as a judge, or does it become ChatGPT or the AI system? And then we have an interesting element whereby Lady Justice had mentioned, are we having now AI becoming the judges? Do we really need to get rid of the judges as they are? Or should there be a balance where, once again, AI is used as a tool to help and to benefit and not to replace? Another key element that comes out is the lack of transparency. Now, for most of these cases, the only reasons why we know that they use ChatGPT was because the judges, they themselves say that they used it. For the advocate who used 10 cases, 9 out of which were all false, of course, for him, he decided to really deny that he had used any of these cases. And so for that, elements of transparency come out, in that we consider the fact that AI systems use complex algorithms and machine learning tools, basically technological tools that are slightly more advanced. And they lack elements or components of transparency within them. And even as users, to a certain extent, we lack elements of transparency in what we use. Because there is really no harm in using ChatGPT for certain things, for as long as you as a human being can corroborate what it is saying. Similarly, for the lawyer who decided to use cases that were generated by ChatGPT, it would have been as simple for him to verify, okay, you've given me this list of cases. Do these cases actually exist? It was as simple as that, and asking that, but that wasn't necessarily done, which then goes back again to the kind of ethics that exist for this. We currently don't have specific protocols or policies for using a generative AI or AI in and of themselves. In as much as we are still learning and adopting to the use of AI technologies, we have our other counterparts in the West who, in as much as they're also grappling with these issues, are coming up with specific systems and protocols that are enabling their own judicial sectors to be able to, yes, leverage artificial intelligence, leverage generative artificial intelligence, such as the ChatGPTs, the Geminis, but within specific boundaries and barriers, with specific protocols created, because at the end of the day, it is technology that also helps. So should we sit and wait until things get really, really bad and we have more than one case within the continent or within just East Africa before we set specific parameters and protocols? Or should we sort of be ahead of the curve? Even if it is not a complete priority as of yet in terms of the use of technology or adoption of technology, wouldn't it be beneficial to have specific parameters and protocols? Because I am sure, I won't ask you to raise your hands, but I'm sure a big majority of us to a certain extent have used ChatGPT or have used generative AI elements in one sense or the other. So in answering this question, I would say the significance of AI ethics goes into the significance of the ethics of how generally judges operate, generally lawyers operate. Those two go in tandem with each other, because ultimately at the end of the day, it is based on how you conduct yourself in the use of these technologies and how they're able to be either beneficiaries or barriers to things like access to justice. So that's basically how I'd respond to the question.
Thank you, Ms. Florence, for nicely putting the answer and for your engaging presentation of my question on advancing AI innovation in justice sector. So now I move to my last panelist, Ms. Stella. Ms. Stella, let me ask you, focusing on practical implementation, how can East African countries leverage lessons learned from Rwanda's digital justice transformation to ethically integrate AI, improve access to justice, and build public trust by addressing concerns about privacy, security, and biases?
Yes, thank you, moderator. From the on behalf of all the technologists, I think I've had 2 days of hearing Latin. I think the predecessor said she was just hearing Latin. I think we were on the same boat. But however, for you, you have only 30 minutes to listen to my Latin or our Latin as the panel. So now, when it comes to the practical way of looking at the best practices of what Rwanda has already done in regards to integrating AI, so I think the very first element is about governance. And I think also Honorable Justice Kayobera kept saying we are all here. We are all here indeed. So meaning what Rwanda has done is about the governance and also investing early on in digital solutions or infrastructure. So what do I mean by that? So for the justice sector in particular, they're very closely and neatly coordinated, meaning all the justice sector members, including public sector, private sector, as well as the civil society, as well as actually the development partners, were all closely coordinated. And what has that done? That means that we put everyone all together in one place, discuss, and then come up with solutions. Mostly, when it came to digital transformation, I think that's what we're starting with, and then moving to the AI, because we had very manual processes, and that's when the implementation of the integrated electronic case management came to place because of that togetherness, but also the laws that were changed in order to enable an environment where now we can implement digital solutions as opposed to the way the traditional justice was delivered. So, meaning the lawmakers come together and we change the laws and be able to implement the solutions. So, meaning when it comes to also AI, integrating AI, I think sometimes we think it's something that is far-fetched or it's a buzzword. Actually, in reality, AI started back in 1950s. So it's been around for quite a while. And it's just now surfacing because, you know, now the entire world is closely as well coordinated. And there's also social media, there's the openness, open data, and also a lot of knowledge and resources due to the internet openness. So when it comes to also AI, I think it's high time we still come together, lawmakers, industry, judges, prosecutors, investigators, academia, we come back and now really start fast-tracking on the laws or the guidelines that we put in place for this AI to be enabled. I think we've had various, from my panelists as well, to look at, you know, the ethical guidelines. Are they in place? What are we doing about that? And also, all the cases that were mentioned here, and the way we are using ChatGPT, we like it or not, we are actually using it. But however, have we regulated that? Or have we put in place guidelines on how to use ChatGPT, on how to anonymize data if we are putting in our, you know, all the evidence? So there's a lot to do when it comes to coming together, and also the multidisciplinary, I think it was mentioned as well. So how do we come together, bring in the politicians, bring in the lawmakers, bring in academia, startups. So we need to also work with startups, because when you look at it, the OpenAI, where they're using ChatGPT, all the competition that is going on. There's DeepSeek, I think it was mentioned. There's a whole competition that is going on, but with these big tech companies. And they produce or they give us products and we implement or we use them knowingly or not knowingly. So meaning then it's high time we really come together, individual countries, individual judicial or justice sector entities to now shape either how we consume the already made solutions and how we also work with our private sector and startups to develop our own solutions. That now we know very well that the data that is input, because AI is about the input and then what's the output, right? And also it can be by coding certain rules or having a code that learns on a large data sets. So all that we need to really be intentional on how we chip in. So when it comes to laws, of course, the European Union or the EU Act, AI Act, has spent, I was discussing with my friend here, he has spent almost 12 years when trying to battle and how to sign off that act. However, we can still leapfrog, so and make the laws quicker, guidelines, ethical guidelines quicker, come together, involve our private sector and startups to develop our own tools, but also put in guidelines on how to use the existing tools. So that is one way of the governance aspect, but also investing in digital solutions. Because when you look at Rwanda, we had invested in the IECMS, whereby, everything is paperless. So you can start following up your case, working on your case, even when you're in Washington or when you're in Nairobi, and it's seamless. So that investment happened in 2016. And because, of course, the leadership, and I see former Chief Justices both seated together, with the incredible leadership, this was put in place and implemented at a high speed. So fast forward in 2020, COVID hit, and for us, we had to continue working. The courts continued, everyone continued working because we had invested early on. So it's the same way with AI as well. However much we don't think it's a priority, or we think, it's there, but it's for the technologists. No, it's for all of us, because you can already see the analogy. So meaning, right now we need to really invest and make it a priority. And I like that already in our headline, the local news, it has a headline saying, Chief Justice, of course, Honorable Chief Justice Domitira Mtaganzwa, calls for ethical adoption of AI in judiciary. So that's a headline already. So meaning there's pressure, of course, on our side, but also on the justice sector operators to now sit together and look at all those loopholes that we have and try to implement. Now, maybe the other part is also, of course, building capacities. And this is where we're already working with UNESCO. We're in talks with UNESCO and the GIZ to see how we can expand the training that happened in Nairobi to the judicial operators, but also other justice sector members. So how do we build capacities to inform, the lawyer, to inform the judges on how they're using the ChatGPT, to tell them what are the ethical guidelines that are supposed to be followed for them to really use these AI tools and models in a more ethical manner. So there's that knowledge, to have the knowledge, because of course knowledge is power, but also how to use it to your advantage, so that Eric doesn't go to only the one who is using AI, but also everyone to be able to use them properly. And of course, public awareness, because most of them, we really don't understand what AI is. It's a black box. So how do we demystify that using, institutions like ELPD, where they teach different lawmakers about AI, or even the legal professionals. So now, once we have that, we've come together, we've invested, we've created the capacity building, public awareness. How do we now sustain what we have and continuously innovate around that area? So, and these are all I think, call to actions, and I feel like also the previous panel was about implementation. So we have AI policies in place, most of the countries, member state countries, I think we have them. So how do we go back and now start to implement, not to leave it only the Ministry of ICT and Innovation and the technologists, but also get involved, because you can see at the end, it also affects your occupation, meaning, judgment decisions that are made just because someone is using probably an AI that is not that ethical. So now when it comes to trust, as I conclude, it's also the same, because here we are using the building blocks that we already have and apply speed. So now we already have the data protection and privacy law already in Rwanda, and I presume all the other East African countries have the same. But now how do we go back and look at it and be AI specific? Probably have articles that are AI specific for data protection. And that's exactly what we now need to do, so that that law is used during, let's say, procuring or developing the AI tools and solutions, but also have a human oversight on that. How do we then combine the human-machine element so that we know that all the inputs that we are putting in the models will come out, because there's a human oversight, but also there's ethical development of the AI models. So I think, lastly, since we are all together again, it's now cross-border collaboration, meaning we collaborate now not just individually, because all the best practices that I was talking about, it can't happen individually. It is happening, and it's been happening in individual states. But now how do we come together to create regional AI frameworks or guidelines, ethical guidelines that we all follow, so that, yes, we're going to wrap up. So that now, let's say you have a case of where someone used, I don't know, deepfakes, and it's crossing the border and probably is impersonating the president in the other country. So how do you deal with that if the judge in the East African community from Rwanda or from Tanzania, they did not understand or don't even have the laws or the guidelines in place to shape their decisions? So with that, I think we really need to start seeing how to come together and shape the future of AI use cases in our justice sector. Thank you.
Thank you, Ms. Stella, for your valuable insights. And with this, we have to wrap up the session. And I would like to read out the summary takeaway of this session and also the way forward. So East Africa needs to enact policies and regulations of the use of AI tools at the court, develop AI system which is not biased, which means that we need to train data, capacity building for judicial officers, access to AI tools, online courses for judicial officers, judges of East African Court. We need to raise public awareness on AI with legal professionals, establish clear guidelines of the AI tools, opportunities for exchange and network. And educational level, it is important to integrate AI and law in the teaching curriculum, practical AI training for legal practitioners such as AI ethics, AI bias. And we also need to promote interdisciplinary collaboration to promote AI in education. And AI ethics is important in attribution of key responsibilities of the AI system. And most importantly, multi-stakeholder engagement is necessary on developing and investing for AI solution for every East African country, and also cross-border collaboration of East African countries is needed to create a regional AI framework and strategy. So, I mean, we are out of time, but please feel free to ask questions to my panel. Maybe we can take one or two very short questions. And thank you, East Africa Court of Justice, for this opportunity to discuss AI and harnessing the power of AI for social, sorry, sorry, thank you for the opportunity. Okay.
Thank you very much, Akriti. Thank you to all your panel members. I'll just take one question in the interest of being fair, and then we close it.
Thank you very much. I'd like to thank the panel for that expose of AI, especially in the area of law and courts. I was tickled by Justice Mutambo from Malawi. He said, why aren't you talking about it? I think he knows this is an area I'm personally studying. One of the reasons, I don't want to say too much because my conclusions are not yet out. But I wanted to flag the following and say that the use of AI is all about data. If you have bad data, you have bad AI. And therefore, one of the issues is that we have had, I think there was a case in the UK where a lawyer had to be sanctioned because he cited a non-existing case to the court. And the reason why he used it is because somebody else had cited that non-existing case, and therefore it was in the public domain. And therefore, the data mining picked it up, and therefore it becomes something that is used. So I think we need to be, in addition to all that you have said, I think we need to come together, especially in this region, to see how we can make available data that is easy to mine regarding our decisions, our laws. We may need to come together with a working group. We're doing something small in Uganda. It is still a little bit under the radar in order to achieve this. But I wanted to caution that one of the ethical issues is that you need to cross-check the data that comes out of the mining, especially about the cases that are out there. I've used the same question for ChatGPT, and it came out with a 0 result, and I've used DeepSeek, and in 38 seconds, it produced decisions that are on Yuli in Uganda. So you can see that kind of thing. But also, perhaps perhaps we can have a working group for this purpose. The other thing which I want to flag is we may be also moving into areas where we are going to have AI lawyers and AI judges. And this is an area which we need to think about. I'll just flag 2 in the United States. There is an AI tool called Do Not Pay, which is available to pro se, that is self-represented litigants, and has been doing very well. Actually, in one state, they took it to court for practicing without a practicing license. It won. There's also another one called Lisa. So there are some threats there. And so these are areas which I thought I would just share very briefly, but also call for an opportunity perhaps to have a think tank which is limited to our region so that we can have more accurate data. Thank you.
Thank you very much, Honorable Justice Kiriawire. You've given us some good recommendations that we'd really have loved to include in the communique. Unfortunately, due to time, we will not be able to include them now, but be sure that at the end of the conference, we'll find ways of including them. Honorable Chairperson of the Council, your position as the chair comes with a lot of privileges, but most importantly, as a way of expressing our sincere appreciation for you attending this conference and being our greatest, I could say, champion. Henceforth, I'll just give you the opportunity to ask the last question.
Thank you, Registrar. Actually, the reason why we are here is because we hear you people, we hear the networks of the community speak of integrating even ourselves. So away from integrating the community, we also have to integrate ourselves as institutions that are within the organ, or the organs within the community. My concern always when the technology is spoken, and we always watch the media, we know what institutions, everybody's moving from the manual bit of engagement to quick, fast tracking processes. Now, the other concern I have is hacking and technology is becoming synonymous. How do we safeguard the information that will continue being safe, accurate, and consistent and flowing in the midst of the very things that are happening in the world of technology? That was my concern.
Thank you. I'll request Florence to please respond to that question.
My response to that would be with respect to the fact that a big part of it goes into data governance issues. A big part of it goes into data security and data privacy issues, and then holistically looking at it in terms of cybersecurity. So if you look at it like that, you'll notice that within the regional countries that we have, most of them already have data protection laws, which outline specifically parameters for data protection, give very succinct principles in terms of data protection, in terms of data privacy and how data should be managed. It also gives specific parameters on cross-border data flows and how that is managed. Now, the cross-border data flows element is still a bit rocky because integration, again, we are still finding our footing on it. But even with that, it's also considering the fact that we already have the institutions exist in terms of our respective data protection offices, as well as our cybersecurity offices. I will speak for Kenya. We already have a cybersecurity law, which has been in existence for a while and gives very specific parameters with respect to cybersecurity, use of computers, use of data with respect to different applications. Some elements of it are not necessarily AI specific, but you can infer from the laws that exist. So we already have specific institutions that exist that are in place. We already have the specific laws that are in place. One thing that remains a challenge that I've had throughout the 2 days is an element of implementation or the extent of implementation. How functional our institutions in terms of implementing the specific parameters that have been highlighted within the specific policies, legislations that we have. Even with that, are the other sectors also collaborating or ensuring that they are adhering to what already exists in the policies and principles? Because you can have legislation that exists even for East Africa, but if it is not implemented within the specific sectors in which it affects, or within the specific institutions that are supposed to enable policy, guiding policies to go out, then there becomes a slight limitation in terms of verifying or addressing issues of data privacy, data breaches, or cybersecurity laws. So that's basically, your concern is addressed, but not fully addressed, just dependent on how well we do with our implementation purposes.
Thank you very much. Please give this panel a big round of applause. Thank you very much. And I will now release you to go back to your seats, and we'll go to the final session. So quickly, I'll ask the people handling the stage to please move the podium right to the center. So as we conclude, allow me to just share a few of the highlights of this conference in terms of resolutions The conference recalled the ESCJ's pivotal role in reinforcing integration, fostering the rule of law and public trust, as well as promoting business and economic growth within the ESC. The conference recommended that the ESC should adopt a robust sensitization program in the region to encourage states, individuals, and institutions alike to utilize alternative dispute resolution mechanisms. The conference lauded the initiatives undertaken by the African Chief Justices ADR Forum aimed at enhancing national and regional courts' use of alternative dispute resolution mechanisms. The conference recommended that the ESCJ should enhance its collaboration and cooperation with national judiciaries so as to encourage cross-learning, innovation, and deeper integration and development. The conference recognized the concerted efforts by the court stakeholders to support and insulate the court from political backlash. It also recalled the central role of the Council of Ministers in giving impetus to partner states to uphold the provisions of the treaty and implement the decisions of the ESCJ. The ESCJ was also encouraged to enhance its reporting to the Council with the aim of enhancing implementation of its decisions by the partner states. The Council is called upon to establish sub-registries in the Republic of South Sudan, the Democratic Republic of Congo, and the Federal Republic of Somalia, so as to ensure accessibility to the court by citizens in these partner states. The ESCJ has also been urged to work closely with the ESC Council of Ministers to establish a focal point desk at the ESCJ and in the partner states for the monitoring and of the implementation of its decisions in the partner states. The ESCJ was also urged to enhance its sensitization and awareness drives amongst advocates and relevant stakeholders on the need to collaborate in the monitoring of the implementation of its decisions. The ESC needs to fast-track the adoption of the Human Rights Protocol in accordance with Article 27(2) to expand the jurisdiction of the court on human rights matters so as to expressly deal with human rights matters. There is also need to ensure that the ESCJ is well-resourced so as to make sure that it undertakes its core mandate as well as operate efficiently and independently. The ESCJ needs to enhance its use of technology and embrace ethical and innovative digitization that aligns to the principles of justice and the rule of law. There is also need to utilize the ESCJ's jurisdiction in adjudicating matters on refugee protection and displacement. The ESCJ and the regional courts have been encouraged to collaborate through the conclusion of MOUs for purposes of information sharing, experience sharing, as well as collaboration in terms of training and other areas. The ESCJ has also been encouraged not to ignore the critical role of AI as an emerging area in law and should develop ethical safeguards and guidelines on the use of AI for its judges, its litigants, and other users of the court. Kindly, I would like to beg your indulgence at this point and state that we were still building this communique. However, these were some of the key highlights. And by the end of this week, you'll have a full and comprehensive communique from this conference that will be put up on our website. I'd also like to state that all the papers that have been presented during this conference will also be uploaded to the ESCJ website. Now, before I conclude, I want to also take cognizance of the East African Law Society. We've been honored by the presence of its recently elected president, as well as the CEO. All the beautiful graphics that you have seen at the conference was sponsored by ELS. We really appreciate the partnership that we have with you. In addition to that, and emanating from this conference, the ESCJ, together with advocates from the region, are going to hold a bar bench forum on the 10th of March here in Kigali at the Marriott Hotel. And we believe this is another platform that is going to allow positive engagement between the court and its key stakeholders. There'll be more information shared on our website, and if you'd like to participate in this forum, please do not hesitate to drop me an email. We now come to the end of our session. Once again, I wish to say thank you very much for all your participation. I know some of you had a lot of other pressing needs in your offices, but you've been consistent in staying through the conference. On that note, I would like to invite Dr. Stephanie Rothenberger, the Director, Rule of Law Program for Anglophone Sub-Saharan Africa, Konrad Adenauer Foundation, to please give us your brief remarks. Thank you.
Justice Domitilla Muka-Dagawansa and Chief Justices from the region. Honorable President of the East African Court of Justice, His Lordship Justice Nestor Kayobera, Honorable Ministers and Attorney Generals present, Distinguished Secretary General of the East African Community, Distinguished Chairperson of the East African Community Council of Ministers, honorable judges, in the interest of time, all protocols observed. It is a great honor for Konrad Adenauer Foundation to be on board of this unique and important judicial forum for the third time already. Also, on behalf of all the other supporting partners, namely the Raoul Wallenberg Institute, UNESCO, UNHCR, Pepperdine University, the East Africa Law Society, the International Commission of Jurists, the Africa Chief Justices ADR Forum, and the Africa Judges and Jurists Forum, I would like to express my deepest gratitude to each of our esteemed delegates, panelists, moderators, and guests for your presence, your insights, and your unwavering commitment through our last 2 days here in Kigali. I would also like to especially thank our Rwandan hosts and friends for their hospitality. For me, it is very special to be here in Rwanda, as it is the country, and allow me this personal remark, where probably my very personal history with Sub-Saharan Africa started when I came here in 2014 as a civil servant for a German parliament on the occasion of the commemoration of the genocide, together with the vice speaker of German parliament. And I think it was then that the desire developed for me to come back to Sub-Saharan Africa and make a contribution with regard to the rule of law wherever possible. So I came back with the Rule of Law program, and I'm proud and happy to be here and to represent the program that has been fostering the rule of law, democracy, and human rights in the region for nearly 20 years now. One of the main pillars of our work is the independence of the judiciary, and I'm not telling you any secrets. There is no strong and stable democracy without strong and independent judiciaries, and this is one of the main topics we work on. So I cannot imagine a better partner than the East African Court of Justice and a better forum to give support to than this outstanding legal conference. So I think Justice Kathurima put it very rightly when he said that this conference is a fundamental mechanism for solving the problems that the court is challenging by bringing together not only EACJ itself, but also regional and national judges, high-ranking representatives from national governments and from EAC organs like here our chair of the Council of Ministers, for example, to find answers and solutions to the most pressing challenges and problems the EACJ is facing, and which are thus also challenges for the East African community as such. If we speak, for example, about the tension between supranationality and sovereignty, that was touched upon very profoundly here. Over the past 2 days, we have navigated critical discussions that reflect the depth and complexity of justice in our time. From interrogating the dilemmas faced by regional courts due to their unique position, especially but not only when it comes to the implementation of the decisions of the East African Court of Justice. The outstanding role of the court in protecting human rights, and in this context, of course, also mentioned several times the need to raise legal awareness among citizens about this pivotal role of the court. To the pressing need for accessible alternative dispute resolution mechanisms, or the dire situation with regard to budgetary allocations to the court, which is why this beautiful conference could not be held in the last year. Just to name a few of the critical topics that were touched upon during this conference. The contribution from this very lively exchange have illuminated both the major shortcomings, but also the opportunities that lie ahead. And it has become obvious how essential this forum has become, and that we are not running short of topics that require profound and inclusive discussion by the variety of stakeholders gathered in this room in order to create a deeper level of mutual understanding. A mutual understanding and also support that is a prerequisite for the EACJ and regional courts as such to be able to unfold its unique, transformative powers in the interest of integration, economic growth, peace and stability in the region. The Court of Justice of the European Union, that was also mentioned numerous times during the discussion, is often times described as the engine for European integration. It has played a crucial role in shaping and harmonizing European law, often taking the lead in advancing legal frameworks that have deepened regional cooperation and cohesion. And I believe the East African Court of Justice can also be, and it may be already, the engine of East African integration. By interpreting and applying regional laws with courage and foresight, and we have seen from the impressive speech by Honorable Emmanuel Ugurashibuya that there are numerous examples of decisions like that, it can in fact drive the East African community towards greater unity, stability, and legal harmonization, fostering not only economic growth, but also the rule of law and the protection of fundamental rights, and thus social and hopefully also political cohesion. I'm deeply grateful, and I think I can also speak for our whole community of supporting partners here, to His Lordship, the President of the East African Court of Justice, Nestor Kayobera, and his wonderful team, first and foremost, the Acting Registrar, Christine Mutimura, that we could come together in this crucial and so diligently and wonderfully organized forum for an in-depth, open and constructive, comprehensive dialogue. And Judge President Nestor Kayobera is right. This conference has developed into a unique forum. It is growing into kind of an institution here in the region. And I heard it so often throughout the last 2 days, like, oh, now that the Attorney General is here, or now that the chair of the Council of Ministers is here, or the CTC, let's bring up this problem and find a concrete solution. Everyone is here, like you said, Judge President, so let's do it. I think this is a wonderful spirit, and I am amazed by the numerous ideas that were brought up for very concrete improvements around the work of the EACJ, and the East African community, like, for example, an extraordinary session of the Council of Ministers on the work of the East African Court of Justice. I can feel a very strong commitment to really create a tangible impact here, and the opportunity is clearly there, of course, depending also on political will. And we as Konrad Adenauer Foundation are happy and look forward to be on board of this forum also in the years to come. And I also would like to mention in this context our tripartite judicial dialogue between the African Court of Human Rights, the EACJ, and the ECOWAS Court of Justice, which complement these two conferences, like the Judicial Conference of the EACJ and our tripartite dialogue, complement each other. And I think it was also mentioned, the wheel does not have to be reinvented, but the organizations and institutions can borrow from their experiences and best practice. So I think that through these two mechanisms, a lasting impact can most probably be created if properly used. In closing, let us remember that the rule of law and democracy are no static achievements. They are living principles that demand constant vigilance and renewed effort, especially in an era which is marked by deeply worrying political pressures, global uncertainties, and a worldwide increase in armed conflicts. The responsibility of legal custodians and of those who stand up and who are committed to fostering the rule of law has never been more crucial, be it in Africa or worldwide. Thank you all for your dedication and your passion and your steadfast belief in the transformative power of justice and the rule of law. I look forward to the continuation of this important forum and its growing impact over the region. Thank you very much.
Thank you very much, Dr. Stephanie, for your remarks and for your continued support. Our next speaker honored us with his presence. He's come all the way from Eswatini, Honorable Justice Beki Falala, the Chief Justice of the Kingdom of Eswatini and Chairperson of the Southern and Eastern African Chief Justices Forum. It's my honor to invite you to make your remarks.
Honorable Chief Justice of the Republic of Rwanda, who is also the guest, Honorable Judge President of the East African Court of Justice, as well as the Honorable Judges of the Court, my colleagues, the Chief Justices in attendance, as well as Honorable Judges of various jurisdictions in attendance, Cabinet Ministers present, Members of Parliament present, Your Worships, the magistrates, all legal practitioners, as well as development partners and invited guests, all protocol observed, ladies and gentlemen. I wish to extend my sincere gratitude to the East African Court of Justice for the invitation to this conference in my capacity as a chairperson of the Southern and Eastern Africa Chief Justices Forum. As a forum, we are humbled and honored by this invitation. Similarly, I wish to extend my great appreciation to the Judicial of the Republic of Rwanda, as well as the government of Rwanda, for the warm hospitality extended to the forum since our arrival to this beautiful country. As a forum, we wish to congratulate the East African Court of Justice for hosting with success the third annual Judicial Conference under the theme, Justice, Ethics, and Enforcement of Decisions, a Judicial Pathway for Regional Development. It is our hope that member states of the East African community will provide an adequate budgetary allocation and the required human resource personnel for the successful operations of the court. Furthermore, it is our hope that the community will provide a conducive environment for the court to execute its mandate as an independent institution as required by law and the treaty, which is binding on member states. More importantly, it is hoped that the judgments delivered by the court should be enforced as required by the treaty, as well as the rule of law. As a forum, we recognize the doctrine of separation of powers between the executive, the legislature, as well as the judiciary. We further recognize the principle of the independence of the judiciary, which is enshrined in the national constitutions of the member countries of the forum. Notwithstanding the existence of the doctrine of separation of powers and the principle of the independence of the judiciary, the three arms of government do have specific areas of cooperation and collaboration, particularly in areas involving public finances and the construction and maintenance of capital projects. Many African countries are failing to adhere to their constitutional provisions and acknowledge and practice the fundamental principle of the independence of the judiciary and the doctrine of separation of powers between the three arms of government. Many judiciaries are still considered as appendages to the executive arm of government, and they are under constant attacks from the executive arm of government for not supporting government policies in their judgments or for not issuing judgments in favor of the existing government where the government is a litigant. Many judges have been unlawfully dismissed and persecuted in Africa for executing their constitutional mandate as required by law, notwithstanding the existence of the independence of the judiciary and the security of tenure afforded to the judges by the national constitutions. The interference in the judiciary is a great cause for concern since it renders the judiciary incapable of executing its constitutional mandate to dispense justice. Such interference undermines the rule of law and fundamental human rights, and it further weakens good governance and the fundamental pillars of democracy. The forum was established in 2003 in recognition of the important role that judiciaries play in the administration of justice. The main objectives of the forum are to protect and defend the independence of judiciaries, promote the rule of law, human rights, and access to justice, as well as to promote and protect the welfare and dignity of judges within the members of the forum. The African Union has pronounced itself on the need for African reparations for past injustices committed against the African people. The call for reparations can be traced to the 1993 Abuja Proclamation and has since gained traction through subsequent initiatives, such as the 2001 Durban Declaration and the 2023 Accra Proclamation on reparation. There is now a resurgence and proliferation of reparation claims in Africa for redress of historical injustices which stem from the impact of colonialism and neo-colonialism, slave trade and slavery, discrimination, unlawful possession of land, apartheid, exploitation of natural resources, as well as the appropriation of cultural heritage. In accordance with the observance of the African Union on African reparations, it has become imperative for African states which have suffered historical injustices to accept the challenge and utilize all remedies available in law to fight historical injustices. Regional courts, the African Court on Human and People's Rights, as well as the International Court of Justice, could be utilized to reverse the historical injustices suffered by the African people. The East African Court of Justice has, over the years, set an admirable example of how regional judicial cooperation can be institutionalized to enhance accountability and promote regional justice. The efforts by the court are not only commendable, but serve as an inspiration to the rest of the continent. In an era where our societies are increasingly interconnected, the need for robust regional cooperation among our various institutions cannot be overstated. While our nations are diverse in culture, history, and legal traditions, the challenges that we face, whether in upholding the rule of law or addressing cross-border disputes, are strikingly similar. It is therefore imperative that we move beyond working in isolation and seek collective solutions to shared challenges. As the forum, we recognize that regional integration is a cornerstone to sustainable development and stability. No one institution can thrive or reach its greatest potential by operating in complete isolation. Our continued collaboration has the potential to open doors to knowledge sharing, capacity building, and harmonization of legal frameworks. We reaffirm our commitment to regional engagement. We stand ready to collaborate with the East African Court of Justice and other regional bodies with similar objectives to ensure that our collective voice as African courts and judiciaries resonate louder in advancing justice for all. Your Excellencies, ladies and gentlemen, as we embark on this journey of collaboration, let us be guided by the principle that justice knows no borders. Together as custodians of the rule of law, we have an opportunity to shape a future where our various courts and institutions are not merely guardians of justice within our nations, but also pillars of regional unity and cooperation. On behalf of the Southern and Eastern Africa Chief Justices Forum, and indeed on my own behalf, I wish to again extend our deepest appreciation for this invitation and express our hope that this marks the beginning of a long and fruitful partnership between our institutions. As for the discussions that we have successfully had during the past 2 years, I am confident that our resolutions, coupled with our collective commitment, shall be implemented to achieve the intended goals. Again, congratulations to the court for a successful conference. I thank you, and may God bless you.
Thank you, Honorable Chief Justice Beki Falala, for doing us the honor and for such an inspiring closing speech. We are nearing the very end. I would like to invite the Honorable Justice Nestor Kayobera, the President of the East African Court of Justice, to make his remarks. He will also be presenting something to our partners, and after that I will invite him to invite the Chief Justice of the Republic of Rwanda to officially close the conference.
Thank you so much, Registrar. Before I do my remarks, let me say the following. First of all, I wish to thank sincerely the Chair Council of Ministers. Because last year in November 2022, when we were in Kampala, Uganda, during our second judicial conference, the Chair Council of Ministers, the then Chair Council of Ministers, tried to threaten the court by saying that this court is interfering with the internal affairs of the partner states. As the Chair Council of Ministers, that was not a good sign. So you can see that now there is enough changes. That the Chair Council of Ministers, whom I visited personally, and today you have attended our meeting from the beginning of yesterday until today. So this is a good sign of collaboration between these very important organs of the community. The Attorney General who have attended today, they are with us from the beginning until today. The members of EALA from Rwanda, they have attended from yesterday until now. And unfortunately, they have brought the private members' bill giving the financial and administrative autonomy of the court and of EALA since 2017. That bill was passed by EALA. It was adopted by the Council of Ministers since 2017. It was given to the Secretariat to be given to the member states for comments. Now the bill, if it have died, can we request the members of EALA who are here to try to resuscitate that bill, at least after 8 years? When I visit the Attorney General of Uganda in Kampala, I talked with him about the bill, because Uganda has not given the comments on that bill. I don't know if they have given the comments after 8 years. But remember, the Sitenda Sebaru case, where Uganda Attorney General, for not having made the comments, the Republic of Uganda paid $54,000 to the Honorable Sitenda Sebaru from Uganda. And the community paid $54,000 for violating the decision of the Council of Ministers by one of the members of the Council of Ministers. So I was wishing that bill, please, member of EALA, that bill came from you. If it is died, if he dead, make sure, find a way you can resuscitate that bill. The Honorable, the Chief Justice and President of the Supreme Court of Rwanda, the Honorable Chief Justice from South Sudan, the Representative Chief Justice of Tanzania, the Honorable Chief Justice of the Kingdom of Eswatini, the Chairperson of Southern and Eastern Africa Chief Justice Forum, the Honorable Deputy Chief Justices of Uganda, and the South Sudan, the Chief Justice Emeritus from the Republic of Rwanda, who are with us today, the Honorable Judge President of ECOWAS Court of Justice, and the First Deputy Prime Minister and Minister of ESC Affairs of Uganda, the Cabinet Secretary from the Republic of Kenya, and the Chairperson of the Council of Ministers, the Honorable Deputy Minister from the Ministry of Foreign Affairs and ESC Cooperation from Tanzania, the PSAs who are present, the Honorable Secretary General, who is left, the Deputy Secretary General, the Honorable, the Attorney General, the member of EALA who are with us, the CTC, Council to the Community, the members of the diplomatic corps. I see my brother from Burundi. Thank you so much for coming. The legal practitioners, the development partners, the media fraternity, esteemed delegates, all protocols observed. As we conclude the third annual EAC Judicial Conference, I would like to reiterate my sincere appreciation on behalf of our court to the government of the Republic of Rwanda for their exceptional support and their partnership in ensuring the success of this conference. Additionally, we are truly grateful for the warm hospitality extended to all the participants and to the court. And this is the culture of these people. In a special manner, I would like to express my sincere gratitude to His Excellency Paul Kagame, the President of the Republic of Rwanda, for graciously agreeing to host our 3rd annual East Africa Court of Justice Judicial Conference and the ESCJ court session. This demonstrates His Excellency appreciation for the East African community affairs as well as the operations of the court specifically. Thank you so very much. On behalf of the East African Court of Justice, I wish to extend our sincere appreciation to all of our partners for their exceptional support. We would like to once again particularly acknowledge the contributions of the Raoul Wallenberg Institute, the Konrad Adenauer Stiftung, CAS, the UNESCO, the UNHCR, the Pepperdine University, the East African Law Society, the International Commission of Jurists Kenya, the Africa Judges and Jurists Forum, and the Chief Justice ADR Forum. It is widely recognized that this event would not have been possible without your invaluable assistance. Thank you so much. To our esteemed invitees, we have no words to express our gratitude for honoring our invitations. Please accept our heartfelt appreciation. Your presence is deeply appreciated, and we acknowledge that none of our accomplishments would have been achievable without you. We extend our sincere gratitude to all presenters, the moderators, and the panelists for their outstanding contributions, which have facilitated discussions aimed at enhancing the skills of judges, the judicial officers, and the court users in addressing the diverse challenges encountered by individuals in their pursuit of justice. Distinguished participants, ladies and gentlemen, the 3rd annual ESCJ Judicial Conference has achieved notable success, offering participants an opportunity to share insights, expertise, best practices, and the challenges related to emerging legal issues. It also highlights the ESCJ's role in promoting justice, upholding ethics, enforcing its decisions, and contributing to the development of the agenda of the community. It is probable that the professors in attendance will agree with my statement that the knowledge acquired during this conference cannot be obtained through any conventional academic program. We sincerely value the exceptional insights, contributions, and the recommendations presented by our esteemed participants throughout the sessions. Their feedback is vital to the progress and effectiveness of the East African Court of Justice. I am assured that the proposed recommendations will significantly improve access to justice and strengthen the rule of law in our region. The East African Court of Justice, while having made notable progress, continues to encounter ongoing difficulties stemming from inadequate budgetary provisions, delays in the release of funds, and the shortage of human resources. These issues persist despite the court's growing workload, ultimately impeding the overall efficiency. The budget of the court requires thorough review. Adequate financial resources will empower the court to administer justice effectively and efficiently for the East African residents. This in turn will support regional integration by upholding justice, the rule of law, and the fundamental rights and the freedoms in alignment with its treaty obligations. We respectfully urge the Honorable Chairperson of the ESC Council of Ministers and the esteemed ministers in attendance, the Attorney General, to persist in their roles as effective ambassadors of the court. It is imperative to guarantee that the court is not impeded by financial limitations, as this may result in a deterioration of trust among the residents of East Africa, who have had unresolved cases before the court for an extended period. Rather, we propose the initiatives that will enable the court to fulfill its treaty mandate in furtherance of the EAC integration agenda. In conclusion, we find ourselves at a loss for words to adequately express our gratitude for the time and the resources you have devoted to participating in this conference. Before I thank you, I wish to say that our next conference, after consultation with the Chief Justice of Kenya, whom were all also the students of Pepperdine University on ADR, we consulted and we agreed that our next session, our next conference will be held in Kenya, but in a place that we will agree with the Chief Justice of Kenya. Thank you once again, and I wish you safe travels and success in all your endeavors throughout the year 2025. I wish you a pleasant farewell. Asanteni sana.
Thank you very much, my Lord, for your very powerful closing remarks. We appreciate your leadership and the form or the ways in which you've steered this court. My Lord, I would like to request that you kindly stay on the podium. I would like to invite the chairperson of the National Organizing Committee, the Secretary General of the Judiciary of Rwanda.
Is it before the
Yes.
Ah, okay.
Honorable Anita has been the chairperson of the National Organizing Committee. She has done an outstanding job in coordinating the team from Rwanda. She has chaired all our meetings successfully, given us the leadership that was very required for the success of this conference, but most importantly, she was very vocal in ensuring that certain courtesies were extended to us. Our Chief Justices have had security, they've had transportation, they have had everything that is required for their comfortable stay. And this has also been extended to the AGs. SG, we are very grateful. We have a token of appreciation from the court. Thank you. I would like to invite the representative of the Ministry of Justice. I believe the PS is here. If the PS is not here, can we have somebody in the place of the PS? Thank you. The Ministry of Justice has also been part of the organizing committee. They've been very instrumental in ensuring that this has been a success. They took full charge of our attorneys general from the partner states. And the beautiful dinner we had yesterday was a joint collaboration with the Judiciary of Rwanda. Thank you very much. And please extend our sincere appreciation to the Honorable Minister for such a brilliant keynote that set the tone for this conference. I would like to invite a representative from the Ministry of Foreign Affairs and International Cooperation. Do we have somebody from MINAFET here? If we don't, then we'll find our way to the, okay? So MINAFET has also been a very supportive ministry. They have supported us from the time we approached them and informed them that we'll be coming to Rwanda to hold our conference and the rotational session. We appreciate the guidance, especially on protocol matters. We appreciate the courtesies. Thank you very much. Please extend our sincere appreciation to the Minister as well as the Minister of State. I would like to invite Dr. Stephanie to the front as well. We want to say a big thank you to Conrad Adeno Foundation. You have been with us at least for the last 3 conferences, but you've also supported us in very many other ways that I will not mention. We appreciate your support. Thank you very much. Raoul Wallenberger Institute, the deputy director was here, but I think he has traveled back. He had another engagement in Ethiopia, so we'll have a moment to share our appreciation with him. UNESCO, Akriti, if you're still in the room, please come forward. We really appreciate the support from UNESCO. As I did mention, they did sponsor a panel, and UNESCO has been very instrumental in training our judges on matters relating to freedom of expression and access to information. We really appreciate your support. UNHCR, the Nairobi Regional Office. I don't know if Mr. Morioki is still here. Thank you, UNHCR. I believe from the first meeting the Judge President had with the Regional Director, they took a very keen interest in the work of the court, and it was a yes from the get-go. We appreciate the support from UNHCR. Mr. Morioki, please extend our sincere appreciation to the Regional Director. I'd like...
I'm their product.
Thank you. East African Law Society. I know we have the president here. I know we have Mr. Sigano here. Mr. President, kindly step forward, but I'd also like to ask Mr. Sigano to please stand up. He's the CEO. Thank you, ELS, for being such a great support. Not only have you supported us in the conference, but you've been very instrumental in some of the key litigations that have been brought before the court. You're a key partner, and we continue to appreciate your support. International Commission of Jurists, Kenya chapter. Julie is here. Thank you so much, Julie, for your keen interest in the court, in our work, and for your instant yes when I approached you. We appreciate your support, and we believe that there is so much you still have to offer the court, and as a court, we also have so much to offer the International Commission of Jurists, Kenya chapter. I would like to invite a representative from the Africa Judges and Jurists Forum. It was a yes as well from the get-go when I called them. It's the first time they're supporting the court, and I told them you have a lot of things you can learn from the EACJ and the work that we do. And they were very positive and sponsored the presenter on ethical dilemma. Mr. Tsunga, please extend our sincere appreciation to your board and the rest of the management. Thank you very much. I would like to invite Professor Hauka to receive our appreciation for Pepperdine University on the one hand, and the African Chief Justices ADR Forum. Professor Hauka is the director in Africa. He's been very instrumental in channeling the support of Pepperdine, especially when it comes to the role of our court, but also the national courts in Africa in alternative dispute resolution mechanism. We shall be signing an MOU between the East African Court of Justice and Pepperdine University that will allow for, among others, key support in the capacity building of our judges. Please also extend our sincere appreciation to the chairperson of the Africa Chief Justices ADR Forum, His Lordship Justice, I think I'm tired. His Lordship Justice Alfonso Windolo, who graciously prepared a presentation that was delivered by the Deputy Chief Justice. Finally, we made 3 attempts to convene this conference in the last 2 years. We were not successful. And this is because of the resource constraints that the court has faced. I did mention earlier that we've had the toughest 2 years as a court. And we appreciate the support that has been extended. But most importantly, we appreciate the patience of the government of Rwanda. Imagine twice engaging a government and telling them you cannot come. And yet, for the last 2 conferences, they were a resounding success. with no hitches. It was a debt that we owed the government of Rwanda, and we really appreciate that that we've been able to successfully hold this conference. So when we came at the beginning of this year, we were not sure we were going to have the conference, but we said, whatever it takes. So we came to Rwanda, and there was a new Chief Justice. She received us with open arms. She was superb, she was positive, and from the time we met her, she said, this will happen and it will be a success. And Chief Justice, we are grateful. You were very positive from the start. It gave us a lot of comfort, and it renewed the President's commitment and the staff's commitment to make sure that we come to Rwanda. Thank you very much. So we have something small for you. We wish we could give you something bigger. So I kindly invite you to come to the front and receive our small gift for you. We come from a community of the Maasai. That is where the court is located. The Maasai are a typical community that reflect integration. You'll find Maasai in Kenya, you'll find Maasai in Tanzania, and today we have Maasai in Rwanda. The farthest point of Rwanda, the border with DRC, you will find Maasai there. And that is, that is clear evidence of what integration can do. And we also have Maasai in Zanzibar, by the ocean. So the picture that we picked was a picture of the Maasai as a reflection of ESC. Kindly open the painting. Please unwrap the... So it is a community of Maasai. We have women, we have men and children, and it depicts a dancing of the Maasais. So this is something that we hope will remind you of us and where we come from, where we are located as a court, graciously hosted by the United Republic of Tanzania, in a community that reminds us of the importance of integration. I would also like to thank you, Chief Justice, for giving us the Nyamirambo High Court to hold a rotational session of the court, for equipping the court sufficiently to enable us hold our court session with all the comfort that is required. Thank you very much. It's the other way around. Thank you. I think we needed a lady to help with the lifting, the unwrapping, and the presentation. Thank you. I request that we clear this place so the CJ delivers her closing remarks in a clean, tidy place. Kindly, can we have somebody help to remove these little scattered papers? Mr. President, kindly invite the CJ to make her closing remarks.
So thank you so much, Registrar. And if this is not, I wish to invite the Chief Justice and President of the Supreme Court of Rwanda to make her closing remarks. Karibu.
Honorable Chief Justices, Honorable President of Regional Courts, Honorable Ministers, Honorable Attorneys General, esteemed judges, fellow stakeholders in the administration of justice, distinguished guests, ladies and gentlemen. It is an honor to stand before you once again, and we bring to this conference to a close. I would like to begin by expressing my gratitude to your presence and active participation, which have made this event productive. During these 2 days, we have engaged in a dynamic discussions and explored solutions aimed at enhancing justice, ethics, and enforcement of decisions within the East African Community Judicial Framework. I'm inspired by the enthusiasm, commitment, and collaboration that has defined our interactions throughout this conference. To our speakers who shared their expertise with passion and clarity, thank you. Your presentations have both deepened our understanding and inspired fresh perspectives on how to advance justice in our region. To all participants who attended sessions and contributed thoughtfully to discussions, thank you. Your engagement has been instrumental in creating a collaborative learning environment that will continue to benefit us long after this conference concludes. To the organizers of the East African Court of Justice, I commend your tireless efforts in planning and executing this event. Your dedication has ensured that every aspect ran smoothly. As we conclude this conference, let us reflect on the valuable insights gained. It is crucial that we recognize our shared responsibility in promoting justice, ethics, and enforcement of decisions as fundamental pillars for regional integration. By working together to establish a unified judicial framework across our jurisdictions, we achieve 3 goals. First, we facilitate cooperation by enhancing collaboration among member states. Second, we promote the rule of law by strengthening our legal systems. Third, we support economic development by creating an environment conducive to growth. Ladies and gentlemen, let us carry the momentum of this gathering back to our respective roles with renewed dedication, continuing to uphold principles of integrity, impartiality, and accountability within our judicial systems. Similarly, let us also remember that as guardians of justice, our role goes beyond interpreting laws. We must actively promote ethical conduct, equality, and human dignity by working together to build a region where justice prevails for all. Distinguished guests, ladies and gentlemen, as we depart today, I wish you a safe journey back to your respective destinations. The East African Court of Justice, I wish you continued success in your rotational court sessions. If you have time, dear guests, I encourage you to visit Rwanda, especially the beautiful city of Kigali. I thank you all for your kind attention.
Thank you very much, Honorable CJ. Just one last recognition. I would like to request that the staff of the East African Court of Justice please come forward so that we can recognize your efforts in ensuring the successful convening of this conference. Kindly, let's be fast so we can finish. Please come to the front. Can we please move forward? Thank you very much. Do we have members of the National Organizing Committee here? Can you also join us, please? National Organizing Committee from the Judiciary of Rwanda, Ministry of Justice, Ministry of Foreign Affairs, please come forward. A round of applause for them as well. Thank you very much. This is the team that has delivered the conference. Please thank them. Thank you very much. Please take your seats, or kindly let us keep up standing for the EAC anthem and the Rwanda national anthem. You can go back to your seats and we'll sing the anthems from there. The IT team, please. We'll start with the EAC anthem and close with the Rwandan anthem. Thank you very much.